Members of the committee will come to order. At this time, the chair lays out House Bill 3 and recognizes Representative Murr to explain the bill.
Thank you, Mr. Chairman. Committee members, I'll start off simply by thanking you for your time. I appreciate your service. You have been here all day, and so I am grateful that that you are still here and focused on important issues for the state of Texas. And so that means a lot to our constituents back home. That means a lot to the folks that have come to testify today and present their own personal viewpoints. So with that, I want to be expeditious in the layout so that we can try to address any and all of your questions that you may have. I want to start off by offering just a perspective real quick, a brief history of election law, or a snapshot of it in the state of Texas. In 1975, Texas passed mail-in voter registration. So before 1975, if you wanted to register to vote, you had to do it in person. In 1987, Texas was one of the first states to implement early voting in 1987. Before 1987, Texans went and voted only on election day. In 1991, 2 years before Congress took action, Texas passed its own motor voter law, requiring voter registration to be offered at what we call now DMV sites. And in 1997, Texas took steps to ensure that voting machines be accessible to voters with disabilities. The point that I'm making is that Texas has consistently reviewed its election law policy over time, making changes and updates as needed. And I believe that House Bill 3 continues this process. Now, while we generally have 2 years in between our legislative sessions, we presently are only weeks out of our regular session. And so I know that this issue is fresh on everyone's mind. House Bill 3 generally picks up where the House left off. You will find that it contains many of the provisions that were passed by the House during the regular session as a version of then called SB 7, along with some provisions contained in the conference committee report. But for members here today, I'd like to just point out that it makes an effort to exclude provisions that already became law. And that means that some of those provisions were in separate bills that did pass the House and Senate and were signed into law. It generally excludes provisions that were outside the bounds of the conference committee report, and also generally excludes provisions that appear to have originated solely from Senate language and not necessarily considered by the House. But importantly, that you may note is House Bill 3 contains language offered by both Republicans and Democrats, senators and representatives, made during that process. I emphasize this because it demonstrates that all viewpoints have been and are being considered, regardless of party affiliation, in an effort to draft sound and thoughtful election policy. Importantly, House Bill 3 does not contain what I understand to be some controversial topics that we heard during regular session, including content relating to the souls to the polls on Sundays, judicial overturning of election results without determining how individual voters voted, and unwieldy proposed regulation of occupants in motor vehicles during eligible curbside voting. Now, I'd like to give you a quick overview of the subject matter of this bill, but I think that a lot of that will be driven by our questioning. On page 2, I'd like to highlight the legislative intent. It is the intent of the legislature that the application of this code and the conduct of elections be uniform and consistent throughout this state to reduce the likelihood of fraud in the conduct of elections, to protect the secrecy of the ballot, to promote voter access, and to ensure that all legally cast ballots are counted. This is so Texans can remain confident that we have a reliable election system. Now, there are articles throughout it, they're headlined, and I think that that's beneficial for us and in guideposts as far as some of the topics that you may want to visit about and address. But very, very broadly speaking, without delving into the details, because I think we will spend some time on that, we talk about the registration of voters and the ability of a voter registrar to forward to a a voter's new county of residence, an application to vote. We talk under the conduct and security of elections, clarifying that the state of Texas doesn't currently have and does not engage in a 24-hour voting process. We also talk about the fact that we do not have a universal curbside voting or motor voting from your cars, that curbside voting under state law is limited to specific reasons. We see an expansion of the hours for voting during early voting. For most purposes in this bill, it's from 6 a.m. to 10 p.m. with at least a 9-hour minimum to be chosen by the local jurisdictions. That can expand to 12 depending on the population size. That expands the number of counties that are involved in that 12-hour from 39 to 60. That covers almost 25 million people in the state of Texas. This improves voter access. On Saturday and Sunday, during early voting, we see an expansion of hours as well there to improve voter access. We talk about early voting polling places, being able to vote inside the clerk's office or at other vote locations. We actually make some clarifications because we've already said that straight ticket voting is no longer used in the state, but we do have some software out there that still could accidentally allow that. So we want to clarify that for vendors. Under election officers and observers, we talk about the role of the poll watcher. You will have questions about that. We already know that poll watchers have restrictions on their ability to communicate with a voter, and they're not allowed to be in certain places, but we do talk about them taking an oath, that oath that they will not disrupt the voting process or harass voters. We clarify the ability of elections officials to remove a watcher under certain circumstances. We also clarify that a watcher doesn't necessarily get parked in the corner where they can't see, that they will have free movement while following that oath. We see that there is some authority from the appointing authority of a watcher to seek relief if they feel like the watcher has issues with the ability to pay attention. And I'll just go ahead and point out that a poll watcher is not necessarily there to watch voters. A poll watcher is there to watch the election clerks and the other folks that are working hard to make that process successful. We clarify that there's no drop box voting. We're codifying what the Secretary of State has explained to counties as a procedure to accept in-person delivery. The whole goal there is to ensure a good chain of custody, and so it's not necessarily a drop box. Under voting by mail, which we saw a spike in 2020 with good reason, we talk about the fact that there is not a proactive or active system of reaching out to folks, that Texas has always engaged in a policy of a passive system. If you're a voter and you fit the category and you're eligible to vote by mail, then you request it. That's part of that process. You have to be qualified to vote by mail, and so not everyone hits the categories that we have. You have to be 65 years of older, be sick or disabled, be out of the county on election day and during the period of early voting, and be confined in jail but otherwise eligible. We talk about and we address the identification of the folks that do request to vote by mail. And the language that you have before us is actually identical to the same that we ask when someone shows up in person at the poll and votes. And so the goal there is to make sure that we have confidence in the system. We'll have a discussion about fraud, but at the end of the day, if you constantly are reviewing your policies and processes to identify what out there could be a weakness, when you have a ballot leave the location and be mailed to someone and be in transit, get there, arrive, linger, and may come back, well, there could be weaknesses in that system. And so I think it's beneficial for all to know that that ballot successfully made it to the person that requested it, and the person requested it, completed it, and returned it. There are provisions in here for curing any defects of that ballot by mail. That's important. That was standalone legislation proposed by Senator Zaffarini. according to the, we have other sections in here regarding the assistance of voters, fraud and other unlawful practices, enforcement, ineligible voters, and related reforms. And I feel like we're going to have a lot of discussion on that. I won't spend any more time. I will tell you that this is a serious attempt to make sure that Texas has good policy in place. I recognize that folks may have differing viewpoints, and I remain open-minded in discussing each and every provision in this bill. I think that's beneficial for our discourse today. And with that, Mr. Chairman, I am happy to take any and all questions.
Thank you, Representative Murr. We're going to start with Representative Niave.
Thank you, Mr. Chairman, and thank you, Chairman Murr, for your brief layout of a very, very significant bill that is going to make a big impact on Texas. And so I want to start off on page 1 of your bill and just walk through several of the provisions, starting on page 1, line 8, and how you named the legislation. Can you tell us what the word integrity means to you?
Well, I do think that goes back to the core content of our legislative intent. And so when you think about, and there's other language in here, and I think it's reflected also on page 1, we talk about public confidence in our system, and that we want to make sure that public confidence in the electoral process is not undermined. And it doesn't matter what level it is, we owe it as a state to ensure we constantly have a policy that puts good measures in place. And so from that viewpoint, in the analysis of integrity, it is a system in which we believe that at the end of the day, valid votes are cast and counted, and folks can feel comfortable that the right people voted, and that their votes counted even in razor-thin margins of error. At the end of the day, I can trust that the candidate with the most votes that showed up is the legitimate person. So yes.
Okay, and we'll get to some of the provisions that you referenced as well. But let's go to section 1.02,
okay.
Where you reference section 4, article 6 of the Texas Constitution, and you reference that part of the Constitution. It says to make all laws necessary to detect and punish fraud. And can you know what section 4, article 6 of the Texas Constitution references, right?
I did not bring the Texas Constitution with me, but I brought some of the books on the election code. As you know, all bills typically have a section for their purpose to identify where the legislature derives that authority to make that. And so I believe that we've identified that section of the Constitution typically deals with what we're talking about today.
And that's a significant or important part of the Constitution, because when this bill was previously brought up, there was some concerning language in that section of the Constitution. And there was a difference between this bill and the bill that we previously heard before the House. And so I wanted to ask you why certain language was excluded. And I have some of the language with respect to that article of the Constitution, and I'll read it for you. It says, in all elections by the people, the vote shall be by ballot, and the legislature shall provide for the numbering of tickets and make such other regulations as may be necessary to detect and punish fraud and preserve the purity of the ballot box, and the legislature shall provide by law for the registration of all voters. And we heard on the floor of the Texas House, as a previous bill author was laying out, and some questioning by Chairman Rafael Anchia with respect to language of the purity of the ballot box and how the historical context of that phrase. And so as I'm looking at section 1.02, can you tell us why you did not include that particular language that was in the previous bill?
Absolutely, I certainly can. Representative Jarvis Johnson offered floor amendment 2 to Senate Bill 7 when it was in the House, and that is his floor amendment deleted that reference. And that is why it's not contained before you today, because if you step back and look at the deliberations of the House and try to provide a thoughtful work product to put before the committee today, there was a discussion that occurred on the House. And
So was
I
it
paid
because of
attention to
that
that.
discussion of the concern with that language being, having historical context of a discriminatory nature, which is why it's not included in this bill?
I believe that it was a meaningful discussion that occurred on the floor of the House. And I take note of the fact that Mr. Johnson brought forth an amendment and that it was accepted by the author at that time. And so that's where we try to carry this forward, since literally we're weeks removed from our regular session. And so that's why you have it before you today. And I also go to great lengths to articulate that members' considerations as far as the product that we have in front of us from both Democrat and Republican, they have put those forth, and it means that we need to pay attention. And that's why I do think that we do have an opportunity here where we have taken past work product and put it in front of you and provided hopefully good policy. But that is exactly why we got to that point, was Representative Johnson offered that amendment, and that amendment was included at that time.
Okay. So section 1.03 on page 1, subsection 2, these, you have a list of legislative findings that, you know, you're leading with the bill on, and this particular section discusses fraud. The legislature finds that, quote, fraud in elections threatens the stability of a constitutional democracy by undermining public confidence in the legitimacy of public officers chosen by elections. And I want to discuss specifically that undermining of public confidence that you mentioned earlier in the legitimacy of public officers chosen by election. Do you believe that any current elected officials are not legitimately chosen by election?
And I would like to answer that I'm sitting before a body right now of elected officials that I am confident that each and every one of you were properly elected to your office as an example of my belief in the system. And so I look today at a set of lawmakers, and you're elected by your own constituencies, and each district is vastly different than the other. We're urban and rural, different parts of the state, and I'm confident that we're here because of the electoral process and that our constituencies believe in that process, or they wouldn't trust us to be in Austin, Texas today having this hearing. But at the same time, I certainly want them to always continue to believe that. And so I think it's always thoughtful and forward thinking for us to take steps to ensure that they maintain that understanding and belief in the system.
And I appreciate that you believe that we all that are here have been duly elected, but my question
And I offer
is,
that as an example, yes.
and thank you. And do you believe that any current elected official has, you know, is not legitimately you know, public officer chosen by election?
A current elected official is not legitimately in office. I'm not aware of any at the moment. And so my belief is that the folks that are properly serving are there. Now, I'll certainly offset that with, I'm not advised of all situations across the state of Texas down to the municipal level if there is something going on that I'm not aware of as far as a challenge. But typically those occur right around the determination of an election. So we would see that in May, we would see that in November, or at a school board level, for example.
The reason I'm asking is because this language is very specific and I believe really ties into a lot of conspiracy theories that we hear from individuals who do not believe, for example, that President Joe Biden was legitimately elected and that he's allegedly not the president of the United States, and Donald Trump is apparently still the president. And so this language that you have here seems to perpetuate that. So I'm trying to figure out, is it your intent, Chairman, that this is trying to avoid, or is it because there is concern either from you or in the public that there is not public confidence in the legitimacy of public officers?
So I'm not emanating any concern. I do not raise that issue. An election has been determined and followed properly under the Texas and federal constitutions. That being said, you and I can both agree in the public forum, you can turn on one news channel or another, or perhaps read in the newspapers, that there are some shows, articles, discussions that do occur where folks have aired those concerns. And while they are airing those concerns, I go back to the same premise. Well, gosh, we should continue to do everything that we can to reflect upon our electoral policy here.
And is our electoral policy here that you're presenting to us based on any of those concerns?
They are based primarily on input that we've received from elected officials, those that participate in the process as volunteers and election judges, constituents, and some of which are based on actual experiences in recent years about how that might work out, for example, in voting by mail or with poll watchers, or as we may have seen during the COVID-19 era, we saw some interpretation of Texas law that previously hadn't been done that way. And so you're seeing a clarification of what we all understand Texas law to be. When I speak about we don't engage in 24-hour voting, but yet we saw some jurisdictions try to take that, even if that was intended to respond to those conditions there. And so I think that from that vantage point, we don't want there not to be a uniform system in place across the state of Texas. And so this legislation is intended for that purpose, so that we can make sure that folks in Harris County and folks in Loving County do feel like they're operating under the same framework.
Okay, and we'll get to some of those other
Absolutely.
provisions.
I didn't mean to jump ahead. I was just trying to give some meaning to the overall legislation.
I hear you. In the first section of that same sentence on line 1, page 16, you're talking about, threatening the stability of a constitutional democracy. Do you believe that our democracy is unstable?
No, I do not. And I have watched as other countries around the world experience that. Most recently, I believe the country of Haiti has had challenges. I just bring that up because that was on the news yesterday. I read articles. I worry for a country like that. And I do not believe that the United States or the state of Texas has that level of instability. I think we might have what you might call public opinion, sharing common discord, but I don't believe that we are unstable.
Okay. So this legislation is not based on that thought, correct?
That is correct.
Okay. So section 4 of subsection 4 of section 1.03 speaks to the reforms to the election laws of the state made by this act are not intended to impair the right of free suffrage guaranteed to the people of Texas by the United States and the Texas constitutions, but are enacted solely to prevent fraud in the electoral process, ensure that all legally cast ballots are counted. So I want to get to, it looks like there are several provisions also in subsection 6 that also discusses that legitimacy of public officers. And I want to get to that as well because there was discussion in the last committee hearings or testimony from the Texas Secretary of State, correct?
And I didn't necessarily participate in that. I know that I wasn't on that committee, so you'd have to give me a little more clarification. But I would assume that you had resource witnesses from the Texas Secretary of State on pretty much any election bill that was considered during the regular session.
Okay. And the Secretary of State in that hearing testified that despite the challenges presented by COVID-19, the election was a resounding success and turnout among registered voters was the highest in 28 years as Texans exercised their right to vote, correct?
I would not disagree with you.
And there was also testimony that Texas had an election that was smooth and secure, correct?
To the best of my knowledge, that sounds accurate.
So your legislation is not based on any concerns that our election was not secure, correct?
No, and I would just point out that we can find several provisions contained herein that under the auspices of COVID-19, we all went through 2020, there were certain areas of the state that created, I hate to call it, but ad hoc voting rules that were really outside the code that we understand it to be. And so one of the important goals here is to establish and reemphasize the uniformity when we talk about that 24-hour voting. We talk about motor voting in droves from cars. That's part of what you're looking at here. And so I'm not saying that the ballots that were cast were not successfully done. It's just you had one jurisdiction over here doing it and then other parts of the state that weren't.
So I'm trying to determine why specifically, and we'll get into it throughout the parts of the legislation, why specifically we need this legislation when our election was safe and secure.
And is that a question or is that?
It's a question.
Okay. Again, I'm going to go back to, we have a lot of discrepancies where we didn't have uniformity in the application of current law.
What are those discrepancies?
Texas does not allow for 24-hour voting. We did have jurisdictions that implemented an effort of that.
So you're saying the 24-hour voting was a discrepancy that made you concerned about alleged voter fraud?
It didn't create equal opportunities for Texas voters across the state.
Because one jurisdiction chose to have 24-hour voting to accommodate their citizens, whereas others didn't?
In short, yes.
So
because
you think that if more people had access to 24-hour voting then, that it would be more uniform?
Not necessarily, because current law doesn't allow for that. I believe that was an interpretation on some jurisdictions to implement that. And
It
what
doesn't
we've done,
prohibit it, though, does it?
I believe that current law does prohibit it, yes.
Can you cite to where that law is?
What I'd like to do, and I don't mean to deflect, but there are professionals with the Secretary of State that would be here as a resource witness, and I would ask for them to answer that, and I'll make a note, and if they didn't give you a sufficient answer, I'm happy to try to address that in closing as well.
Okay, so we'll come back to that. The next sentence in page 2 of subsection 4 says, integral to the right to vote is the assurance of voter access and the right for all votes legally cast to be counted. That assurance of voter access.
Yes.
And I mentioned this just because you use the example of the 24-hour
Yes,
voting. Assurance of voter access is providing voters with an opportunity to have access to the ballot, correct?
Yes.
And
At
so
the
it's
same time, we're also empowering our local jurisdictions to make some decisions, and many of those are based on volunteer participation. And so they vary across the state too. And so they have to make some flexibility, which is why we provide a framework under our state law. But at the same time, there is some deference to allow the local jurisdictions to set the times that work best for their citizens, and they know that.
And more hours would give more access, correct?
Which is one of the reasons that we've interpreted in this bill to, for example, in early voting, in the 2 weeks that we have in early voting, I propose that we start it at 6 a.m. and it could end at 10 p.m. And we're suggesting for certain size counties, pick at least 9 hours, but we're letting them choose what seems to work best for their constituents.
And I know some folks will get into that when we
Yes,
get to
ma'am.
that section as well, but my question was, more hours means more voter access to the polls, right?
Yes, but at some point, I think you're going to have trouble if you did 24-hour. I view that as potentially an opportunity to have trouble staffing, have trouble staying focused, and also to make sure that we give folks 2 weeks to early vote. We give them an opportunity to vote on election day from 7 to 7. We give the ones that are eligible the opportunity to vote by mail. At some point in there, if you really needed to vote at 2 o'clock in the morning, I'm confused a little. And that's me personally.
And I think there are examples of the urban versus rural, and I know that some folks will be getting into examples of why that is very helpful, especially for people who work late at night or late shifts or where they're working all day, where that is the only time that they can go vote. So I'm going to move on to the next. So the second part of that sentence talks about the right for all votes legally cast to be counted. And we at the legislature are always concerned about unintended consequences, correct?
I think we should always be mindful of that as we deliberate policy, yes.
Okay, and section Part 4 of the bill states that the first part talks about the reforms to the election laws made by the state are not intended to impair the right of free suffrage guaranteed to the people of Texas by the United States and the Texas constitutions, correct?
Yes, ma'am, that is the section. That is correct.
That's two constitutions, or Texas saying that the people of the state have this right, correct?
We have a constitutional right to vote.
Okay, and when we realize that a part of legislation may have some unintended consequences, it's part of our job as elected officials to voice those concerns of unintended consequences, correct?
And practically, we see that every session because we revisit the process to see what did work and what didn't work well. And that's why you see that we amend law, and sometimes we repeal law, and sometimes we have to start over and make new law. And so, yes, I think that is reflected in all law that the legislature tackles.
And if this legislation had unintended consequences of making it more difficult to vote, we should fix that issue, correct?
First, we would need to identify what those might be.
And we'll be doing that
Okay.
all day long today and tonight. We all agree that, well, actually, let me move on. With respect to the votes legally cast to be counted, we have a system of courts here in Texas to ensure this, correct?
We also have a process that is already in statute for casting provisional ballots, for example, where something appears not quite right, but we don't want to turn someone away and they miss the opportunity to vote. And so I also bring that into the fold in that discussion.
Okay, and we have, you have faith in our judicial system, correct?
I have faith in all three branches of our government.
Okay, and it's our judicial system that hears cases where there are allegations of voter fraud that are charged, correct?
I believe so.
Okay, do we have a system of appellate courts to help us if the lower courts potentially get it wrong?
That is correct.
Okay, and we have a Texas Supreme Court who gets the final say in Texas unless we want to appeal to a higher court, such as a federal or Supreme Court, correct?
That sounds accurate.
Okay, and there was a lawsuit that was brought to the Supreme Court of the United States this past year, correct, by Texas?
You'll have to clarify for me.
The state of Texas versus Commonwealth of Pennsylvania, state of Georgia, state of Michigan, and state of Wisconsin, brought by the state of Texas, our Attorney General's office, with respect to the lawsuit alleged voter fraud and said, among other things, that vote by mail had violated federal law, correct?
I'm going to defer to you on that. I don't have that in front of me.
You don't remember the major case where Attorney General brought stating that there was voter fraud going on in other states, but not in Texas?
I'm only familiar with the news reports on that, so I have not reviewed that today. And so I understand where you're going with that. I'm just saying that I'm not being deflective. I just don't have that in front of me, so I have to rely upon what you are telling me.
So the state of Texas wasn't claiming that there was voter fraud or a violation of federal law that had occurred here in Texas. They were alleging that voter fraud had occurred in 4 other states, but not here in Texas. And so those states were Georgia, Michigan, Pennsylvania, and Wisconsin. And so I'm just trying to find out, given that in a major Supreme Court lawsuit where we're trying to bring this sweeping legislation, that Texas did not cite to any purported instances of voter fraud in this lawsuit, where you're alleging voter fraud.
I understand that, but I didn't participate in that litigation, and I haven't dialogued with, I guess, the Office of the Attorney General about either the filed litigation or the outcome of that.
So you didn't determine whether there were any alleged instances upon which to base this legislation?
No, well, you're talking about the lawsuit. I'm just telling you that I didn't participate as a party or has visited with the Office of Attorney General about that process or the arguments that were made in that litigation.
So have you visited with the Office of the Attorney General or any state agency with respect to whether there are any instances of alleged voter fraud upon which to base this legislation?
Yes, I have in my office has visited with Mr. Fisher with the Office of Attorney General, who I believe will be a resource witness for you and can elaborate on instances of fraudulent activity in voting, both present and past.
Okay. I will move on to section 1.0015. That essentially states that the election code should be uniform and consistent throughout the state, correct?
Yes, ma'am, that is correct. And that tracks, I guess, I read to you earlier about what the legislative intent for this bill is.
Right. And we want to encourage voting by all eligible citizens and counting as many of those votes as possible, correct?
We want to count all legally cast ballots.
What do you mean by that?
Just exactly what that is. If someone casts a ballot, and I go back to my sidebar example of a provisional ballot, which all of our election judges are trained to do, if there is something that doesn't appear quite right whenever they're doing the paperwork, they don't turn someone away. They have them prepare a provisional ballot, and then if it can be remedied, we make sure it gets counted. And that's one example of ensuring that we are counting those ballots. At the same time, if someone didn't follow the rules that we've already outlined in already current law when they vote, you know, you and I would both agree that their vote shouldn't be counted if they haven't followed the rules that we currently have in the election code.
Do you have concerns about valid votes not being counted?
I think we should all, as policymakers, want to ensure that we have a framework and a process in place to count validly cast votes, yes. And I mean that in a generic sense. I'm not pointing to a specific scenario so much as all the ballots that do get cast that are legally cast, I want them counted. And we want them considered because at the end of the day, if that discourages voter participation, or if we find that shakes voter confidence, then we haven't really continued our job to improve election law in Texas.
I'm going to get a little into legislative intent in a minute. We're going to come back to that.
Okay.
Section 1.05 has language about election officials and other public officials shall strictly construe the provisions of this code to affect the intent. Can you tell us why you have a strict construction standard in here?
I believe that you see it in a lot of legislation. I don't think that's uncommon. I think the goal there is we're asking all of those who conduct our elections, and we have thousands of people across the state of Texas in 254 counties that work hard to do that. We're asking all of them to make sure that they follow this law, and that goes back to the language you have about a uniform and consistent application of it. And so, of course, we want them to strictly construe it so that it's interpreted the same way regardless of jurisdiction. I think that's the goal.
Okay, are you concerned that this strict construction requirement would prevent local officials from taking common sense steps to ensure that people are allowed to vote?
I am not concerned. As you probably understand and know, our election officials also receive a great deal of guidance from the Texas Secretary of State's office when they're trying to interpret provisions in this code or trying to make determinations about what to do with individual circumstances. Essentially, they turn around and call the statewide experts and say, here's a fact pattern. How do we apply the law to this fact pattern? And, you know, as a state, we encourage that. And I would assume that the resource witness for the Texas Secretary of State would elaborate on that if you wished.
Okay, and there are some local officials who may apply certain standards or interpret rules a certain way where somebody would not be allowed to vote. Is that correct? Have you heard of that happening?
I'm not going to disagree with your statement. It's the same as we've heard local officials, election officials interpret it a different way. I pointed to the 24-hour voting. I could also point out the concept that was done in a couple of jurisdictions, which I know we'll talk about later, about trying to send out applications to vote by mail. And we operate under a passive system where a voter has to request that, not an active or a proactive system where the local official sends all those out and then lets the voters decide if they're qualified to send it back in. And so I do think that you do see some variety of different interpretations there. And that's part of the important reason for House Bill 3 is to clarify and make everyone understand that there shouldn't be a discrepancy in interpreting that.
Okay. Have you conducted a racial impact study to determine the effect of House Bill 3 on Latinos and African Americans?
I don't have one in front of me. I will tell you that I think would want you to ask that question to our resource witnesses with the Texas Secretary of State. I know a great deal of effort has been put into those efforts, and in your Dropbox, you did have additional documents for this as well.
What documents?
I don't have those in front of me. You had bill analysis, a fiscal note, et cetera. Yes, ma'am.
So you're saying that there has been some action taken to make sure that this legislation is not disproportionately impact on people of color?
My understanding is that I don't have any documents in front of me that demonstrate that. At the same time, I'm not aware of a disproportionate impact or studies that have shown something of that at this time.
You're not, are you aware of all of the testimony that was presented during previous hearings with respect to the potential disproportionate impact on people of color of this legislation?
And those previous hearings dealt with different legislation, not the legislation that you have before you.
So you have not requested any particular racial impact study to be conducted to determine the impact of this legislation, correct?
I have not.
Okay. Don't you think that would be important?
Sure, that is important, but at the same time, I also look to my peers for their input. And I have considered their input in the document in front of you as well.
And you'll consider the testimony of the individuals that are testifying today with respect to the impact of legislation on people of color?
I look forward to listening to every witness's testimony. And I respect the fact that they have traveled great distances and sat for many hours to be able to share that. So I'm going to give that the importance that I think it deserves.
I want to go to section 2 with respect to the registration of voters. Page 3, lines 6 and 7, where it discusses the information required under subsection C must be supplied by the person desiring to register to vote. Why do you have this provision in here?
And you're talking about section 2.01, just to clarify.
Yes.
The purpose of this, in my mind, is, as I understand it, is we don't necessarily want pre-filling of voter registration applications. We want the individual that's doing the application to fill it out himself or herself.
Why?
I think that your goal there is to ensure that someone else is not doing that for them with the goal of, in essence, hoping to be able to come back and help them vote, especially if they end up requesting to vote by mail. I think at the end of the day, if we hold the right to vote in high regard, which you have pointed out is a constitutional right, and we put a great deal of focus and emphasis on voting, and we have lots of ways to deal with folks who may be illiterate or have a disability. At the same time, we ask that that individual provide the information on their voter registration card, and that would be the language that you have there.
And what do you mean by the language of the bill that the information must be supplied by the person desiring to register to vote?
Correct.
What do you mean by that?
Exactly what it says, that voter individually gives the information that they need to complete the application, not a third party.
So this is an additional step that is being put into law in order to be able to register to vote, correct?
No, most people fill out applications every day, but occasionally somebody goes and fills it out for them.
And so
I would think that is not what you and I want. We want every individual to fill out his or her own application. That's not another step. That's already a step that we have in law. This simply says we want the person that's registering, that's filling out the application, simply to supply that information.
Okay, so let's walk through some examples. Let's say that a wife is registering a husband to vote and she fills out the information for him. Husband did not supply the information. She fills it out for him and hands the voter registration card to him for him to sign. She then has not complied with section 2.01 of your legislation, correct?
I don't know. Your use of the term supply, and I'm not getting into semantics there, but in the husband and wife, at some point, I would think in their relationship, that information's been supplied, whether it was address and date of birth. That being said, the intent is for a husband to complete the application if he's doing that. And he could have directed wife, please complete the application.
But
You
let's
have my
say that he
information.
didn't, and that's the problem with the way the bill is drafted, that you have to interpret what supplied means. I interpreted it a different way than you did. And what is the consequence of not complying with section 2.01 in order to register to vote?
We would have to read that with this section of election code, section 13.002, that it is amending, because that's a subsection C-1. So we can go look at that section if you'd like.
Can we do that,
We
please?
can.
Because
I've got
this
that
is
right here.
the way this is reading is it's an extra requirement that in order for somebody to be able to register to vote, they will have to put that information versus somebody doing it for them. That is an extra barrier. That is an extra obstacle in order to register to vote. We're making it harder for people to register to vote if they do not, quote unquote, supply, whatever that means, because it's not defined in the statute.
You know, very politely, Chairwoman, I disagree with you completely. So if I may, under section 13.002, this is existing state law. Paragraph A says a person desiring to register to vote must submit an application to the registrar of the county in which the person resides. So right there, we've already said that that person has to submit.
Right.
And then B, it says a registration application must be in writing and signed by the applicant.
Correct.
Okay, and then C, it says the registration applicant must include, and it has all of the information that you and I are actually discussing. So that's the applicant's first and middle and last name, the month, day, and year of their birth, a statement that the applicant is a U.S. citizen, a statement that the applicant is a resident of the county, a statement that the applicant has not been determined by a final judgment of a court exercising probate jurisdiction to be totally mentally incapacitated or partially mentally incapacitated without the right to vote. And I don't mean to read these to you. I was just...
I have the statute here.
Okay, I'm sorry. It turned into that. So they're required to supply that information. And I think the goal here is that we don't want a third party somehow playing a role in this, and the person that's being registered may or may not be familiar with what's going on.
But who are these third parties that you're concerned about? And what examples do you have where this is a problem that necessitates this language in this bill that creates an extra obstacle to register to vote? We're not even at the voting yet. We're just talking about registering to vote.
Just talking about registering to vote. And I believe that you will probably hear witness testimony talk about circumstances with voter harvesting, for example, and others that press unregistered voters to sign up and register by completing their form necessarily in an awkward fashion. And I want to hear those witnesses testify to that. But information that I'm aware or have been made aware of by members of the public and by other members of the body is that we want to ensure that the registration process occurs with the person that's wanting to vote. That's the focus and the intent behind that sentence that you're speaking of. We want that person to participate in that. Now,
You just don't want somebody to help them register to vote. Is that correct?
it doesn't say it's a prohibition against assisting them. The information
extra
simply needs to be
requirement.
supplied. They have to supply their own information. That's it. And so, and as you heard, it's all information that they would know off the top of their head.
Okay. Whenever you register to vote, it gives you the option of putting your driver's license, correct?
That is correct.
And let's say that somebody doesn't know their driver's license number, and somebody else, for example, a wife, is helping supply that information on an application to register to vote. Is that an example that is in violation of subsection C1?
So in that circumstance, are we talking about it's another family member that is aware of what the driver license number is? And
Driver's license or, yes, any piece of information.
Because I guess that's common. A lot, sometimes people don't remember their driver license, and I understand that. I don't necessarily believe that that would be incongruous with the language that you have in front of us, but the basic core practical intent is that you want the person that's being registered to vote to be supplying the information, not some third party fill it out. Hey, I looked on the internet and I've got this, I just need you to sign it so I can send it in.
The page before you have strict construction language, and that is a problem with this section 2.01 of the legislation, that you want individuals to strictly construe the language, yet you have a vague term that is going to be difficult to interpret, and that is already being interpreted differently just by having this discussion about the husband and wife example.
I interpret it very broadly.
You interpret it broadly, but you have strict construction language on the page before.
Well, I'm saying I interpret the term supply can come from many different places. I get that. At the end of the day, the intent and the goal here is to simply have the person who's being registered to vote participating in that process. And I believe that that's what we all want. We all want that statute that you have in front of you to be used in a way with that person.
If somebody does not supply the information as you are requiring by this section, what is the penalty? Is there a criminal penalty for registering somebody to vote who did not supply that information?
Off the top of my head, I would have to review. So I don't want to give you a misleading answer, just because the code would have to be reviewed. And if you like, we can ask a resource witness for a specific answer on that question.
Do you know the answer?
Off the top of my head, I do not. And that's always a fair answer.
Do you intend for it to be a criminal violation?
I think I will go and look at that in a minute. I do not intend for that to be a criminal violation.
Okay.
For this C-1 provision on lines 6 and 7.
Representative Niave, real quick, if I could, just for your reference and for the rest of the committee members. Our fourth invited panel, when we get to that point, we do have two resource witnesses here from the Texas Secretary of State's office, as well as we have a representative from the Office of Attorney General that can help answer some questions. So I just want to make sure everybody knew that we do have those two agency representatives here in the room.
Thank you, Mr. Chairman. I'm concerned about this section and the impact on individuals who are disabled, who will need assistance in, some of whom need assistance in registering to vote, and the impact on them. Can you speak to that?
And we're still on the C-1, just to clarify.
Yes.
Okay. I know it's late in the day, and I don't want to answer the wrong question. I don't believe that there is any language here that would interfere with a disabled person's process or ability to seek someone to help them register to vote. It doesn't say you can't have somebody help you register to vote. It's talking about the actual information.
What if they don't supply the information to register to vote?
They don't supply their name, and they don't supply their date of birth. And so the only other part there that would be confusing, I suppose, would be when we talk about a driver license number, the last four digits of their social, or a statement that they have not been issued a driver license Is that what you're thinking of, or the address?
In any piece of information that is being required to register to vote,
Well,
under subsection C, as your
yes.
language is drafted.
I go back to, I think that most of those pieces of information are well known to most everyone, unless we start talking numbers. And I will recognize that even members of my family have to pull out a wallet and look at a number, and I understand that. So, given that, though, this C-1 is not intended in any way to interfere with the process of someone with a disability from registering to vote.
Do you see that the vagueness of that term presents a problem?
I don't see it, but I do acknowledge the fact that you do. And I want to make sure that we do look at this legislation with the concepts of never doing anything but promoting voter participation. And so if we've identified an area where someone with a disability would have a difficulty registering to vote, I would want to give attention to that.
Is it your intent that, let's say that if a computer supplied the information in order to register to vote, is that intermediary? Is that violating this subsection?
What do you mean? In what way? Like a pre-filled form?
Yes.
Yeah, and I believe there's a different section in here where we talk about, elected officials or campaigns sending out a pre-filled registration application. We don't, inherently that also can lead to challenges or errors because of a pre-filled application. So you go back to the core focus of the person who usually knows the information, the person being registered usually knows it best.
Okay. I'm going to come back. I'm going to go ahead and pass, Mr. Chairman.
Thank you. Before I recognize Representative White, let me recognize that we have Representative Rose was here. She stepped out temporarily, but Representative Tony Rose has been here, and then Representative Meza is also joining us here. And Representative Howard, you've been with us all day today. Thank you for hanging in there with us. So, Representative White.
Yes, thank you very much, Mr. I'll say Mr. Speaker. Mr. Chairman, okay, yeah. All righty. Hey, I like that, okay. Representative Murr, Chairman Murr, thank you for bringing this bill. I think you have served as a county judge before.
Yes, sir, that is correct.
Right, and one of the most important jobs a county has is conducting elections. You know, you guys are pretty much the utility unit. Counties are, that is.
Yeah, counties are an extension of state government. So we've delegated as a state that a lot of that responsibility to the county to ensure that gets done.
Okay, so real quick here, we're in a special session. These things are moving fast. Again, what would you identify as the purpose of this legislation?
So I hate to beat a dead horse, but
yes.
I would go back to the legislative intent that we talked about, and succinctly, we're looking to protect the secrecy of the ballot, promote voter access, ensure all legally cast ballots are counted. In result is we want that uniformity and consistency throughout the state. And so you'll see throughout the sections in House Bill 3, the goal and intent to do that either by clarifying existing law or providing express provisions so that we don't have different interpretations going on in different jurisdictions or counties and state.
Yes, thank you for that. When we go to page 5, lines 10 through 13 in our bill, we talk about an audit of voting systems and equipment before, during, after an election, if practical. Do we know of any conditions on the ground that would help our local officials determine practicality?
So what you're talking about there on those lines, and I know it says the term voting system equipment, and that's intended to be broad. And so Just real quick, the purpose of that is to ensure that an audit can occur for every voting system that can be audited.
Okay.
And that language actually came from Representative Beckley in a floor amendment, just to point it out.
That's right.
But when you said, your question was, do we have the ability to do that? Is that what?
Or what are the conditions to determine, hey, it's a practical time, or it's a practical environment, a practical situation to do the audit?
To do the audit? So the audit is done, and a lot of times now in the old days it was paper, but now we have equipment and machines. You'll be familiar with, and I know the resource witnesses will explain that audits occur on a routine and regular basis. There's actually a published notification process that goes out so that the public or interested parties can come and observe participation of the audit, and they can visit with the officials that are conducting that. And the goal is, we go back to public confidence. We want confidence that the equipment works properly, and that's what an audit is intended to do.
Okay, and I think I've seen those notices in papers back home.
Yes.
Okay, going quickly to page 6, line 6 through 9, and knowing that you used to be a county judge, when we have a disaster that may render a polling place or potential polling place inoperable, what contingencies would be out there for counties that have experienced a disaster if polling places or the building that they were going to do the elections are unusable?
Yeah, so that's a very valid question. First, I want to give some context to the lines you're talking about. And that sentence specifically says, no voter may cast a vote from inside a motor vehicle unless the voter meets the requirements of section 64.009, which is curbside voting. And curbside voting is not, the practice of current curbside voting is not touched in any way in this bill. And also I would point out that that's protected under federal law, to the best of my knowledge. And the purpose here is, again, to go back, we saw different jurisdictions interpret this differently, especially during the COVID-19 pandemic process. And so the goal is to simply say that there's not this universal curbside voting. You actually have to meet the criteria of curbside voting, which is to be physically unable to enter the polling place without personal assistance or likelihood of injuring the voter's health. And so that's the purpose that we've already put in place as policy. So that's what the sentence is. Now, what you're talking about previously in the regular session, this topic of discussion about, I'll call it motorized voting or universal curbside, there was language to talk about it prohibited it being in a tent or a temporary structure. And I think you essentially allude to that. That language isn't here because of what you talk about. Okay. You live near the coast. That's right. Sometimes big storms come in and mess things around. Or I live where it floods a lot, and all of a sudden the building that you're in was in 3 feet of water. And so I believe that there are contingencies in place built in the code, and the Secretary of State's resource witness will elaborate what is done when an emergency occurs at the local level, because our elections still occur, and we are all proud of the fact that they do, regardless of what a hurricane or other natural disaster has.
Right, and let me just digress here on the issue of disability. You know, you want a mail ballot, and you're claiming a disability. Okay, I believe in your language, in the bill that you have before us, Andrew, there's no necessity for me to say, you know, what my condition is of my disability. I will just state that's the reason for my requesting a mail ballot. Right?
That is correct.
Okay.
That is correct. It does not require additional information.
That's right. And so folks who had concerns about that, you know, American Disabilities Act or providing some type of personal medical information, they shouldn't have to worry about that.
That is correct.
Okay, good.
That is certainly the intent there.
Yeah, that's right. And so on page 7, on line 23 and on line 27, I see where you've changed the hours. This is on early voting, I believe. You've changed the hours. Are we increasing the number of hours?
Yes. So in this section here, we talk about that. And remember, we've had a discussion now, and with the chairwoman, I use that as an example. Some jurisdictions had interpreted that practice of trying to do 24-hour voting. Now, commonly, the hours that are contained in the existing statute that we have here, which you see are at least 8 hours.
Right.
We're changing it to 9. Commonly, you saw that during hours where they thought that were most applicable to voters being present for early voting. So yes, the goal here is to clarify that we want more hours in the day, but we're not necessarily doing any 24-hour, and that we've generally put a stopgap on each end of that. So you're looking at a 6 a.m. or a 10 p.m., and you're trying to let the jurisdiction decide which 9 hours in that window works best.
So what's in code now, you're increasing the hours.
That is correct.
Okay.
Yes,
So
where you say
we're going
8
to
hours
more
is
hours.
9 and 3 hours is 4. That is correct. We're proposing to increase that.
Okay, and we understand the debate about 24-hour voting.
Yes, sir.
But that's
Yes,
not
sir.
really explicit in statute, but you're working with what's explicit in statute.
Explicit in statute, we are purposely increasing the number of hours in the statute.
Okay,
And that goes to the underlying goal of improving voter access.
okay. And then you go to page 8, lines 18 through 23. It talks about you show up to the early vote line, and, you know, it say it's supposed to end at 8. You get there at 7:55. I'm in line, okay. I will be able to cast my vote even though the polls closed, you know, 5 or 10 minutes later, right? I'll still be able to stay
That
in
is
line to
correct.
vote.
I mean, the whole purpose there is if you're in line, you vote.
Okay, so this is very important. I think back home they do this anyway. But the point is, going through the code, you saw this and you saw the need to make that
Expressly clear.
expressed
That is
in the
correct.
code. Okay, thank you so much. And then when we go to page 9, paragraph E, I think there's an increase from current statute to your proposal in the voting hours on Saturday and Sunday in early voting.
That is correct. And if we'll all recall, because sometimes we have to clarify.
Yes.
Generally speaking, we have 2 weeks of early voting, and you have that weekend in between. And this speaks to that Saturday and Sunday. And so, yes, proposed increase from 5 hours to 6 hours, the enumerated amount of time that the polls must be open for early voting.
And with that, you expand the brackets.
That is correct.
Population brackets, so you're bringing in more counties.
That is
That means
correct.
more Texans will have the benefit of this as well. On this issue of the poll watchers, page 12, getting a lot of emails about poll watchers. Page 12, line 4 through 8, there's language that prohibits a poll watcher from interfering with the orderly conduct of an election. Does this infer that a poll watcher can intervene if they see disorderly conduct?
A poll watcher is not intended to, you should not infer that a poll watcher can intervene. I think that
Either way,
they are limited only to conveying anything that they observe to an election official or election judge.
Thank you very much, and I hope I can work with you going through this special session on holding your position on most of these issues in conference.
Thank you, Mr. Chairman.
Thank you. Members, real quickly, just point of information, please note the time. It is 6:40. As you may recall, as I was giving my opening comments before I laid out the bill, I said we would close witness registration in 1 hour, which would have been at 6:27. So we have now officially closed our witness registration on House Bill 3. And for the record, we have 295 folks registered in the system to register, or that have registered for this bill. So with that, we have Representative Johnson, followed by Representative Landgraf.
Thank you very much, Mr. Chairman. Good afternoon, Mr. Chairman. I want to visit with you a little bit about the Section 3 provisions.
Okay,
And I want to ask,
give me just a second. There's a lot of pages. I want to make sure I'm on the right page when you're talking so I'm not distracted.
sounds great. I'm going to start with page 7,
Okay,
closing polling places. I noticed that you are changing on 7, taking city secretaries away and giving power to the county. I noticed in another provision that you're eliminating some of the powers by the county clerk, and you're creating a provision that allows the Secretary of State to adopt rules to close polling locations. why are you putting a centralized power in the Secretary of State to close? What's the intent there?
I think, so generally speaking, the intent is always uniformity, so that whenever local jurisdictions take action, they're doing that uniformly and consistently across the state, so that in one county, if they take an effort to close a polling place, it's going to be done similarly to another jurisdiction. So that's the goal. And if you'll see on the provision you're talking about, the Secretary of State shall adopt rules and create a checklist and similar guidelines. That's for the uniformity, so that locals are doing it the same way. And so I think that's always important. And you and I, we've spent a lot of time talking about criminal law, and I know y'all spent hours this morning talking about that. So I'd point out the same thing. It's generally the same concept. You would want criminal law applied evenly across the state. And so having the ability for the Secretary of State to adopt some rules and provide that guidance for folks who don't engage in that process on a daily basis, it might be a unique scenario for them. And remember, many of them are volunteers. You want to give them that level of comfort that they're doing it correctly if they are going to close anything. I think that's important.
Is there any reason why county clerks are being excluded from that process?
In that process, in this, which section are we in? I'm sorry.
What you've created on page 7, lines 4 through 9, section 66.0 on closing polling places. Is there a reason why we would not want to include local county clerks in any of those actions or decisions?
On page 7, when we talk on section 3.08, when it's the...
No, above it.
I'm sorry.
I have,
sorry.
And hopefully I'm looking at the right copy, but lines 4 through 8, you're creating an entirely new section that says closing polling place. Secretary of State shall adopt rules, create a checklist with the presiding judge. I'm just wondering if there's an intent to purposely exclude local county clerks from
No, there's no intent to purposely exclude local county clerks, to my knowledge.
Would it be a good idea to include local county clerks so that, like, for example, in Harris County, you have our folks that are on the ground or in other locations to be able to participate in this process, so our local elected officials are not being excluded out of this election process?
Yeah, and if you'll just read this, this is just the authority given to the Secretary of State to adopt rules and create a checklist to assist the presiding judge in processing forms and conducting procedures required by this code at the closing of a polling place. And so it's not omitting some other authority from that process. And we would have to go look at the existing code about the process to close, which I don't know that that's what we're trying to do. But the language here is not intended to change whose authority it is to close. It's to make sure that they have all the adequate information and that they do it correctly. Because you and I both know we wouldn't want a poll closed incorrectly. I come from a very rural part of the state, and surprisingly, in that small county, we have polling locations where just a few dozen people vote, but it's very meaningful to them. And it's been something that's intergenerational in the community, and they have a sense of pride from it. And so if, in fact, they ever wanted to close it down, you want to make sure it gets done properly. And I'm not saying that's part of the local process. So nobody's wanting to change the authority to do that.
So, we had an issue in Harris County in the middle of COVID with the ballots, and we were told by the governor that Harris County only warranted one drop-off. And I think that's the concern here.
Okay.
Is to not have a centralized state power stepping in on local control, local elected officials. And so I understand your statement, but what I don't see in this new creation of the ability to close polling places, just like we saw mail drop-off places closed in the middle of our election, we'd sure like to let our local elected officials participate in these processes. So.
And I would disagree with you one bit, and I would look at this language and say it doesn't really expressly state authority to close it. It's more of the Secretary of State adopting rules and providing the guidelines and checklists for those that are making those decisions.
Okay. I want to move on, and again, correct me if I'm wrong on the code, but at the bottom of page 7, when we start talking about these hours,
yes,
line
ma'am.
23, it says that the polling place shall be conducted at least. And so when you say that there was a prohibition on 24-hour voting, I don't see that. and I would appreciate being corrected if that's true, but what I see is at least 9 hours. I don't see only 9 hours.
Let me rephrase if I misspoke properly. The practice of a full 24-hour voting period has not been common or implemented in the election code that we currently have, which is the section you're looking at. That is not common practice.
Okay.
And if one jurisdiction goes down that path, then you do have non-uniformity and inconsistency between different cities and counties as to how that plays out. And so that I think does raise some eyebrows, because common practice in the past, that we didn't really see something like that.
So
and it only took a pandemic, and I'm not saying that the intent behind doing that was harmful or trying to brazenly flaunt the election code, but the outcome was that certain jurisdictions, and we're talking about your jurisdiction, engaged in that, but then other areas of the state didn't. And so you did have inconsistency in how voters are going to go to the polls. And so I think the state then needs to step up and have policy more clear, so that we do know that depending on where you live, you're still having some equal treatment of being able to show up.
And I want to go through that in a little bit, but let me just make sure I'm clear on the first part, because I want you to correct me if I'm wrong.
Certainly.
Texas law does not prohibit 24-hour voting.
I believe the intent is Texas law didn't intend for 24-hour voting to be engaged with.
And again, when we look at the legislature and our words, the law says at least so many hours.
And
there was no prescription on how long it could be. Just to make sure, I don't want to get slapped with the code over there and you say, hey, Ms. Johnson, it says right over here.
No, ma'am.
Okay, so it didn't exist.
No, ma'am, I wouldn't do that.
I do want to talk about when you said, hey, consistency in the rules.
Inconsistency, so
Wait, hold on.
I'm sorry.
One second, please. I want to get in this rural-urban discussion that we were doing. I know you're from a smaller place. I got a sister that's got property in a rural place, and when the sun goes down, it gets awfully quiet. At my house, it doesn't get quiet. And so there's a difference between rural and urban settings,
Understand.
correct?
That's right.
And so for the same reason, I want to make sure when we say we're trying to be uniform and consistent, is it more important to be uniform and consistent, or is it more important to promote voter access?
I believe that they're both common goals.
Okay.
And I do think that depending on the provisions that we're always looking at, because there's so many different angles when you look at and there's multiple books of these, but we all desire uniformity and consistency, because the state of Texas needs to have that framework in place, or we're going to have election officials doing it differently in different places. And I think that's not necessarily what we all want.
Okay.
Case in point, if you have elections that happen to include larger jurisdictions, so now we're talking about state officials running in districts that are multiple counties, even within that, if multiple counties are all doing it a little differently, does that inconsistency cause concern and lack of confidence in the outcome? I don't want that to ever occur.
Okay. But you're not suggesting that 24-hour people that voted 24 hours somehow were fraudulent voters?
Did not say that, no, ma'am. I'm suggesting just perhaps that mechanism that was in place was certainly different than if it was a multi-county district.
Okay.
Is certainly different than at the other end where they followed the 8 hours and it was typical hours. Do they feel like the outcome could have been different, and does that change the confidence in the outcome?
So again, with promoting voter access, and we're talking about uniform and consistent, just, if you will, by analogy, in a small rural town, you might have a state highway that's 2 lanes.
If we're lucky.
If you're
We're
lucky, right?
That's right.
And in our jurisdiction in Harris County, you might have a highway that's 16 lanes.
Can barely
right?
count that high. I understand.
But those are uniform and consistent, that they're forms of transportation, but they meet the differing needs of the population, correct?
Regarding transportation, but I don't think that analogy fits well for our election process.
All right, so let's take this, if you will, and follow me. And again, let me know if I'm wrong, but I want to go back to page 7.
Page 7.
Where we have at least 9 hours. You decreased the amount of population from 100,000 individuals on page 8 down to 55,000 individuals. And in those populations, you've actually given an additional hour every day to vote. right?
That is the goal. Yes, ma'am.
And you've also said that for individuals with fewer than 1,000, that they have 4 hours.
Instead of 3.
And so you've given them an additional hour to vote.
Yes, ma'am.
And in those jurisdictions, why the difference between 1,000 jurisdiction 4 hours and 55,000 jurisdiction 9 hours?
I think the practical answer that you'll find over the decades that we have compiled this. And so first and foremost, we all know that this election code is fragmented over time because each legislature adds little layers to it. They don't always fit together neatly and cleanly. But let's go back to the very basic premise of how we operate our elections. They're typically done by volunteers.
Okay.
So in the smaller areas, you're probably going to have less people to lean on to show up and help with that. And so that's probably proportional to your population.
How does that comport with your analysis that you just gave me about people running for statewide election? And
No, I didn't say statewide. I said think of it as a multi-county district, like a state senate seat, for example. Correct.
So in jurisdictions with 1,000 people, 4 hours is sufficient. You've upped it an hour. Jurisdiction of 55,000 people, 9 hours is sufficient. You've upped it an hour. I'm not great at math, but when I look at it, 1,000 in population is 1.8% of 55,000. And with that increase, you gave an additional 5 hours. When I contrast 55,000 with Houston, Harris County, of 4,700,000, it's 1.1%. So if we're uniform and consistent, if you can double the amount of time in those smaller jurisdictions from 1,000 to 55,000, why would you not double the amount of time for large jurisdictions like Harris County, where we have an excessive amount of population, we have an excessive amount of population who can work polls, and create the same uniformity and consistency that you've done from 1,000 to 55,000 to million jurisdiction voters?
So I've worked off the framework we have here, and I'm not going to be able to give the answer that you want. I know that you want me to agree that 24 hours a day would be the outcome that might be best for Harris County being a jurisdiction with a very large population. Mm-hmm. That being said, I don't know that state policy, I would not agree that state policy desires to be 24 hours a day. I'm sure that some witnesses will have opinions both for and against that. And so instead, what we've provided in this House Bill 3 is a framework to say, here's an early time and an end time, and it's a lot of time, and we want the jurisdiction to pick which hours seem to work. And so that I think operates best. The jurisdiction, there's still local flexibility.
County,
there's still local
jurisdiction, we selected 24 hours. That's what we wanted.
During the pandemic, correct?
4 election cycles.
Okay.
But let's talk about the pandemic.
Please.
Because the pandemic changed behavior, right? And we learned from it, right?
Some people experienced a lot of things from it. That's correct.
So like we've expanded technology in courtrooms through Zoom. And then let's go to something trivial like alcohol to go. People liked alcohol to go, right? Yep. And I remember the first day that I got sworn in, the governor said, we're going to change for the people of Texas and we're going to pass alcohol to go. If 24 alcohol to go is good to change, why can't we learn from the pandemic and give a almost $5 million jurisdiction, or 5 million, not dollar, population jurisdiction, an additional amount of time to run through the voters on the same statistical percentage that this bill changes from 1,000 to 55,000?
And my answer is going to be the same. The framework that I'm providing the committee for review here of a start hour and an end hour with an expansion of the hours that are already listed in the code is, in my opinion, good policy to advance. It's probably more incremental than where I think that you want it to be. And I understand that and I respect that, but I don't necessarily agree with that.
Okay. And you just told me earlier, you don't think that 24 hours were fraudulent voters.
No, ma'am, I did not. I did not say that.
Do you think that drive-through voters were fraudulent voters?
I don't know that the equipment was designed for that type of process, and I don't know that our framework of current law was really set up for that. And that's why we've only set it up for curbside voting for a specific purpose.
Would it surprise you to know that the curbside voting equipment that was used for drive-through voting is the exact same curbside voting that you have in statute for people with disabilities? No different machines. It's the same technology. It's the same counting.
And I'm not going to argue with you on that because
Okay.
you have greater knowledge of exactly what Harris County participated with. I understand.
So it's the exact same machine that they would bring out to the car for a disabled individual that was being brought to the cars. And again, a change that was inspired by the pandemic in the same way that alcohol to go was and has been implemented as policy across the state. We're supposed to promote voter access. The building, and I know Chairman White raised this, and I want to make sure I raise it. I didn't read it the same way he did, and he's gone. But on page 10, you cut on line 3, you cut 85.062E, which specifically allows for the creation of a movable structure. And so you are now deleting the possibility for a movable structure. And so there are rural communities that flood, power outages, whatever else. What do we do? Where's the emergency exception in a disaster that we seem to be occurring more and more often? How do people get away from what you are now requiring, that you're also changing on line 20 from stationary structure to, quote, building? What's the definition of a building?
Building is actually not defined. I did search for it. So it's not defined in the election code.
Okay. So can we define it? What's that mean to you, a building?
Well, what does it mean to you? You and I, are we going to arrive at the same definition? I also would tell you that the definition of stationary structure was not the
Well, why did you
definition
feel
that
the
exists.
need as the author to change it from stationary structure to building?
Because I think building is more understandable for folks. And I think that we all,
You couldn't tell me what it was.
stationary structure,
No, building. I just asked you. You said, I don't know.
a
I
building.
couldn't find a
A
definition.
building is typically a place of work that we see where, for example, a clerk's office or another office of local officials would be located. A stationary structure, you and I can name anything under the sun, and me being from the sticks, I can identify stationary structures that people don't use as workplaces or as places to securely be able to vote.
So I saw that language about suitable rooms unavailable at the branch office.
Yes, ma'am.
Is it your intention to stop places like Harris County from having new voting places and only have them in branch offices of county clerks, or am I totally reading all that wrong?
No, ma'am. In that section 3.11, and we're talking about early voting polling places, this really speaks to clerk's office, if I understand correctly, and we can ask our witness from the Secretary of State's office, but it speaks to a clerk office, and we're just clarifying that if it's going to be inside the branch office, if there's not space, then it doesn't have to be inside that specific office. It can be in the building. And then under section 3.12, that's speaking to polling places at any other voting location. That's my understanding.
And
So trying to create some consistency between those. And you know, they probably, over time, we've seen lots of different provisions stacked upon one another as amendments, deletions, and new laws were created. So
And I want to make sure people also recognize one of the things we learned in the pandemic, and the reason I ask about where does it need to be, we had a polling location in the medical center. We had it open so that our frontline workers, our healthcare workers, had the ability to vote
that's understandable.
during a time in which they were literally risking their lives to save other people's lives during the pandemic. Through that moment, we recognized that it was definitely something that promoted voter access from our healthcare workers and many communities of color that work throughout the night to keep that medical center going. I was thinking about your numbers in 55,000, and there's 106,000 employees just in the medical center alone. And those folks work around the clock. The early voting hours, meaning the days. Did you at all change the days of early voting?
And where are we looking specifically so that I properly answer your question? Are you on page
Yeah,
9?
I'm actually just asking. 'Cause
Okay.
I'm looking through.
No, ma'am.
We're back on 7.
The short
Are we
answer
talking
is
about the
no.
hours?
There is no change in the dates of early voting.
Okay.
Or the weekend of early voting. All the dates that we currently have are consistent and remain the same.
So early voting is the same?
Yes, ma'am. We're just talking about hours is the only change that you have there for those existing days.
And you would recognize, when we talk about increasing access and promoting voter access, we were talking about making sure that individuals who have previously been suppressed maintain their right to vote, right?
Yes.
And so that would obviously include communities of color that have faced significant voter suppression. And that would also include women, right?
Every person.
Every person. But unfortunately, we don't have a history of every person. And I thought it was interesting, and I didn't know this, but did you know that Texas was the first southern state to ratify the 19th Amendment? And it was done when the governor called a special session in June of 1919. And here we are in a voter potentially suppression special session, because you did not change the amount of time for early voting, but you have eliminated 24-hour voting, and you have eliminated on page 6, lines 7 through 8, the possibility of drive-through voting. And I want you to think anecdotally about who does drive-through voting. Do you know who took advantage of drive-through voting in Harris County?
I'll let you explain that to me.
I mean, just think about it. Think about single mothers. Think about caregivers that have a disabled person in the car with them, or an elderly individual, or 2 young kids in a car seat. It was a whole lot easier for women to go through that drive-through than to take those kids into the polling place. And those numbers bear out because 60% of women took advantage of drive-through voting in Harris County. And that is getting taken away. Communities of color took advantage of 24-hour voting by 54.9%. And you all didn't touch early voting. And white people voted 57.9% of the time, taking advantage of early voting. It should be nice if we could allow diverse urban communities with an excessive amount of population, a high percentage of communities of color, of frontline workers, 24-hour workers, janitors, everybody who is keeping this state economically moving, to have an opportunity to vote and to truly promote voter access, which is what the policies in Harris County did. And this Section 3 guts the steps that we take and took to increase voter access for communities of color and women. And I would ask that you rethink those provisions, or how they are going to harm the progress that the great state of Texas started with in a truly special session back in June of 1919. Thank you, Madam Chairwoman.
Representative Landgraf.
Thank you, Madam Chair. Thank you, Chairman Murr, for your layout, and appreciate the discussion that the members of the committee are having. Just before we get too far on, and I won't take up very much time here, but as we continue to discuss the various provisions of House Bill 3, there is a bit of a theme that I just wanted to make sure that I'm clear, and I think maybe some of our colleagues here on the panel might need some clarity as well. Chair Niave brought up the point about the strict construction provision that's included there on, on page 2, below the legislative intent. And this would implore that public officials shall strictly construe the provisions of this code, meaning the elections code, to affect the intent of the legislature under section 1.0015. Is that correct?
That is exactly what it says, and I've read the sentence regarding legislative intent in section 1.0015 already, yes.
Okay, and so when we're talking about strict construction or how a public official would strictly construe not only the provisions of this bill, but the elections code in general, it would be to go back to that legislative intent. Is that correct?
That is correct. Okay. That is the purpose of that provision and the fact that we've actually set forth in writing the legislative intent.
Okay. Well, I appreciate that. And then, so if the strict construction has to do with the legislative intent, which you have admittedly gone over a few times, if we address Chair Nyabe's other point about the word supplied, and I agree that at first blush that could have some ambiguity, and just for identification purposes, we're moving on to Article 2 in Section 201, where there's a subsection C1 added. And again, just since it's been a few minutes since we covered this, the information required under subsection C, which is the simple name, address, first name, middle name, last name, driver's license number, etc., that information has to be supplied by the person desiring to register to vote. So in other words, the applicant to vote. Is that correct?
That's correct.
And so and again, just to be clear, because I think this is going to come up several other times, and that's why I want to make sure that we're clear at a relatively early stage in the discussion. But strict construction wouldn't have anything to do with any sort of debate on the word supplied. Is that correct? If the construction relates to the legislative intent?
That's my understanding, is the legislative intent and the application of the law itself. Mm-hmm. And then when you talk about the determination of what a word means, you're simply supposed to follow the ordinary meaning. Mm-hmm. And I think that's what we see the courts do, and I think that's the obvious intent of what the legislature does whenever it does create law.
And I appreciate that. In terms of the ordinary meaning, and look, when I read this draft that you filed, and in looking there on lines 6 and 7, page 3, that the information required under subsection C must be supplied. Again, I don't want to get caught up too much on this, but I think this is a very good example of drawing a distinction between maybe the different discussions that are going on about this bill. When we're talking about supplied, now it can be, to use Chair Nyabe's example about a husband and wife providing or supplying that information, as long as it's coming from the person who is the applicant, then that person is supplying it, even if it's through an intermediary or not. Is that your understanding of this bill?
That's my understanding. And then also the chairwoman had questions, and I've had plenty of time to digest them. And I think one of the examples that she'd given, didn't necessarily indicate that it was supplied at the same time. But a husband and wife, over the course of their relationship, would certainly have supplied that information.
So if we're talking about that information needs to be supplied by the applicant, I was trying to think of what a counterexample to that would be. And to me, it's not whether it's a spouse providing the other spouse's information or supplying that. But the way that I read that is that the opposite example would be if that information, in other words, the information that's provided on the application, if that information is being filled out by somebody other than the applicant who acquired that information through identity theft or something like that, and as we know, identity theft is becoming more common as we live in an increasingly digitized world. So if somebody steals your personal information through identity theft and then uses that, would that be an example of the applicant not supplying his or her own information?
That would be a very clear example, yes.
Okay, and so was it your intention, or is that kind of what that is designed to do, is to make sure that as long as it's the applicant providing that information, supplying that information, that's, and if they use an intermediary, that's fine. If they enter it on a computer, that's fine. But they are the original source of that information rather than somebody who has acquired that information through theft or some other means that's not authorized.
That's right. And as I told the chairwoman, the ultimate intent here is that the applicant is participating in the process. Mm-hmm. And typically the applicant knows all or most all of that information very easily. And so they're playing a role in that process. That's the goal.
Okay, so the applicant could supply that through a caregiver or through a family member or anybody else, so long as they are the one who is the supplier of that
I
information.
would certainly not disagree with you, Dave.
But again, just to highlight the counterexample, if that information is acquired through illegal means, then that would not be the applicant supplying that information.
And the applicant was not playing any role in that, and so I think that certainly goes to our intent, yes.
Okay, I just want to be clear. Thank you very much for
thank
that
you.
clarification.
Madam Chair.
Representative Neri.
I wasn't going to come back to that provision, but just to address some of the issues that he raised. The legislation does not state illegally supplied, correct?
No, ma'am, and if I may read, just for your clarity, since we're revisiting it must be supplied by the person desiring to register to vote.
Correct. And in his example, he's stating if information was acquired without that person's consent is different than if somebody is disabled, or a husband or wife or a family member is assisting somebody to register to vote, even if that person didn't initially have that desire. And that is the problem with how this legislation is specifically drafted. And when we're dealing with fundamental constitutional rights to be able to register to vote and to be able to choose who we want, this is creating another hurdle by which people now have to comply and prove. And so that's why I was trying to find out from you specifically, what is the consequence? Who is going to determine whether information was supplied in order to be able to put it just to register to vote, on an application to register to vote? We're not even talking about that. And that is a huge, huge concern, Chairman. Wouldn't you agree? Do you see the problem with this language and how it's worded?
I am happy to continue discussions, Madam Chair, with you on that language. I also think that Chairman Landgraf makes a valid point, and if that point can be further clarified, just as you said, there's not a certain word here to talk about it being illegal or without consent. I do think that would provide additional guidance, and if we're going back to the strict construction of the goal there, and our goal is certainly to make sure that applicant is participating in the application. That is correct.
Are you open to cleaning up the language of this subsection to ensure that this is not another barrier for somebody to be able to register to vote?
I do not want there to be a barrier, and I am certainly open to ideas and suggestions for that. I sincerely am.
Okay, thank you.
Yes, ma'am. And I appreciate both of your comments towards that provision.
Any further discussion? Representative Landgraf? Oh. Are you asking? Have you completed your discussion?
Yes, Madam Chair.
Okay. Anyone else? Okay. All right, we're going on to the next section. That's section 4. Charlie, would you preside?
Yes, ma'am.
I'm gonna do section 4.
Chair recognizes Ms. Thompson.
I want to thank Chairman Murr for all the work that he's done on this bill. Been working on it for several days now. I want to talk to you a little bit about the poll watchers. Can you give me some idea of what a poll watcher really is?
My interpretation of, and I'm going to slide here because I know that Representative Landgraf is in between us, so that way you can see me. I'm sorry. I have the whole table here, so I can spread out some more. So my interpretation of the election code regarding a poll watcher, and I mentioned it earlier, is the poll watcher is there to observe the election officials and the election judge as they perform their duties. They're not necessarily there to watch individuals vote, if that makes sense. So and the end goal is for the parties that are participating in election, or perhaps it's a referendum of some kind, that those authorities, they have eyes and ears in the polling location through their poll watchers to instill a sense of confidence that everything is being followed and that everything's going off without a hitch.
Are there any particular qualifications they have to meet?
I believe there are some particular qualifications, and I'm happy also to allow our witness with the Secretary of State to go into specific detail, but our poll watchers do have to be, give me just a second to flip a page here so that I can talk about it. They do have to be appointed. They have to be appointed by the appointing authority, and it depends on whether it's a candidate, a political party, a write-in candidate, or an election on a measure. And they have to have a certificate of appointment. And then we have lengthy existing law that deals with that.
Do you think that with the responsibility that we're giving this person to be a poll watcher, that is sufficient? Here's my point. We're giving this person a pretty big latitude in this polling place. They don't have any training.
And I think you're correct. To my knowledge,
And
there's
don't you
not.
think there's the deficiency there? And we ought to have some training if they're going to have this kind of latitude in the polling place?
And I know that, and I appreciate your point. I think it's well taken. We do have lots of other folks that work there, from our election judges to other folks that assist them, and they do have training. That training's typically administered through the Secretary of State. We have charged with setting up that process. And so essentially, just to get to the heart of the matter, you're mentioning, shouldn't the poll watchers have training to understand what they can and they cannot do, I assume. That's correct?
Well, yes. And what brings me to that concern is on page 11, a presiding judge may not have a poll watcher duly accepted for services on the subchapter 8, chapter 33, removed from a polling place for violating a provision of this code and the penal code or any other provision of law relating to the conduct of elections unless the violation was observed by an election judge or clerk after the watcher was previously warned that the watcher's conduct violated the law. And if we are depending upon his poll watchers to know what these violations are, don't you think that they're going to need some training?
Madam, I can't disagree with you that it is good for folks to have information. And I think that this language is in response to experiences that we might have heard anecdotally around the state with the removal of poll watchers. And as you can, the paragraph that you just read talks about the opportunity to give them a warning so that if it's conduct, they don't do it again. And obviously, if they do it again, they should be removed. And then the next sentence that you have in there, paragraph H, actually says, notwithstanding all of that, a presiding judge may call law enforcement officer to request that a poll watcher be removed if the poll watcher commits a breach of the peace or a violation of the law. And part of what we have in front of us today includes an oath that the poll watcher takes, and that oath says that they will not interfere with or harass a voter. So if that conduct involved that would be a violation of the law in which they could be removed. And so, but you're right. Your basic premise, if I'm not mistaken, is should we make sure they know what they're supposed to do and not do? And I really can't disagree with you on that. I think that's a very valid point.
And when you say was previously warned, are we talking about one warning, two warning?
One warning, yes, ma'am.
A warning.
A warning.
A warning. All right then.
The same thing that I yell at my kids whenever they misbehave.
But when the police officer or whoever the law enforcement officers come to enforce this particular section upon the poll watchers, to remove the poll watchers for a breach of peace, is there a violation given to that person?
If it's a breach, I'm sorry.
What law are they breaking? We know a breach of the peace, I get that. But what is the penalty?
So the term breach of a peace, while it's generic, includes all violations of the public peace or order or decorum. And I actually did some research on that because we have that provision in here. And so practically speaking, if a law enforcement officer felt so inclined, it would likely be a citation for disorderly conduct, which expressly includes a breach of the peace, if they were going that direction. Now, this says just remove them from the location, but they could actually also be cited for disorderly conduct, which is a Class C misdemeanor, if I'm not mistaken. So I think your point is, if they're really causing a problem, then the presiding judge can simply call law enforcement to say, I think that this person's causing a breach of the peace, or we've identified that they are in violation of the law, which could be any provision of the election code, and I kindly ask you to remove them from the location. And I don't say all those things in a flippant way to say that this is something that happens on a frequent basis, but at the end of the day, it's a way to provide some express guidance to our presiding judge that if we are going to have poll watchers, and poll watchers typically are partisan, sometimes they're there for a candidate and for either party, we want to make sure that they do feel like there is an apparatus in place if somebody does get out of line, because that at the end of the day decreases the level of confidence in what's going on at that polling location.
Well, I noticed in this section of poll watchers that if the presiding judge does something wrong, the precinct chair, the election officer does something wrong, we have a penalty in this bill for that person, but we don't have any penalty necessary in this bill for the poll watchers. But you're giving the poll watchers a lot of responsibility here.
Well, the poll watchers are only there to observe. They don't have any other responsibilities beyond that. And I would make a distinction that an election judge or presiding judge, they do have more official responsibilities in handling the election itself, including handling the ballots and ensuring that the voters who show up go through the proper requirements in order to vote. And so we place a great deal of burden and responsibility on our presiding judges and our election judges. The poll watchers are simply eyes and ears of the appointing authority, which is a unique term that practically means a candidate or a political party.
But when they're talking about violations and irregularities, they can cause an election judge probably to get filed on and get criminal charges or criminal penalties lodged against them. I mean, that is a big, big responsibility seemingly to fall into the hands of someone who has little of no training.
So when you talk about training, if I may ask, and I know I'm the one that's supposed to answer the questions, but when we talk about training, what type of training do you mean?
Don't you think that when a person has the responsibility of looking at irregularities and making reports and things, even a report against an election judge, they ought to have some kind of knowledge about what to look for, other than just irregularities? What do we mean by irregularities? Let me just ask that question.
Well, your first question, I don't disagree with you, and I would entertain language that set forth training requirements for poll watchers, because I think that's the heart of your line of questioning. And if I'm not mistaken, and I would certainly encourage that we ask our resource witness from the Secretary of State's office what level of training they provide other election officials, I assume that might be part of that process for them as well.
And since you mentioned we were discussing irregularities by poll watchers, what is the definition? Where's the definition of the irregularities that they have to look for? Where's the definition here?
I don't know if that is a defined term in the election code.
Okay. Well, let me ask you this question.
Yes, ma'am.
When you talk about, I'm on page 12.
Page 12, yes, ma'am.
Under the purpose of the poll and the duties of the poll watchers, they are to preserve the integrity of the ballot box. What are we talking about?
In that citation, it also has a reference to in accordance with Section 4, Article 4 of the Texas Constitution, which we talked about earlier, that deals directly with elections. And when you talk about preserving the integrity of the ballot box, the same thing, that the ballots that have been cast have been done so in accordance with the law, and the folks that are properly entitled to vote have voted. That plays directly to the integrity of the process, with the outcome being we have confidence in it as voters and as constituencies.
You know, I didn't see that definition of integrity of the ballot
No.
in here. That's when I was asking that question.
No, ma'am, I don't think it's a defined term. I thought you were asking how I interpreted it. I'm sorry.
Okay. It just seems to me a little awkward that we give the poll watchers a lot of latitude to be able to observe misconduct of the election officers, and they can be charged up to a Class B misdemeanor, which could entail some jail time. And yet the poll watcher misconduct is left up to the decision of the police officer of whether or not that even though they may have breached the peace, there's little and no or nothing that may be done. But the poll watcher is put on the spot to even go into jail because of an alleged irregularities by the election officer is put on the spot by the irregularities of a poll watcher, to the extent that they can be charged to a misdemeanor, Class B misdemeanor. It just seemed like a little inconsistency there.
Well, I understand that. I know that the poll watchers have less responsibilities as far as conducting the election. I will point out that current law also explains and sets forth that a watcher, they're not allowed to be present at the voting station when a voter is preparing their ballot or is being assisted by a person of the voter's choice. And they're also may not converse with an election officer. They're not allowed to converse with a voter or communicate in any manner with a voter. And to paraphrase current law, they're supposed to simply be the eyes and the ears of the candidate or the political party there, whether it's Democrat or Republican. I think that's how they've been set forth in it. And you look at the statute, it actually talks about they observe. And so that's how I think policy has been put into place and why they exist in our current election code. But whenever you say, do they need to be trained so that they understand what they can and cannot do, and they understand what the violation of law might be because of the reporting requirement that you mentioned earlier, I can't disagree with that. And I think that it would be wise and good policy to have them trained similarly by the Secretary of State and ask the Secretary of State to develop some process for that. That could be uniformly provided. That's just me. Yes, ma'am.
It just seems to be a little inconsistency where you're going to have a person with no training, they just get a certificate to come and stand in for a candidate or a partisan a party to observe irregularities, and they can get an election judge charged with a Class B misdemeanor, but their misconduct is a breach of peace. It may be so negligible in the eyesight of the law enforcement until nothing happens. I mean, that's a lot of power to give a person just coming in with a certificate to say, I'm watching to see if there's any irregularities. It just looked like that needs to be tightened up in there.
Well, I will say this. I think that generally speaking, and we can wait and hear testimony from witnesses, that many poll watchers likely do a very good job, and that the ones that we hear about, like with any type of industry or profession, you have outliers or specific incidents that we always point to and worry about. So in that circumstance, you could rise to the point where other criminal charges apply. I don't know that. I can't even pretend to make up what that might be in my head. But I do recognize that you are making a distinction with the level of outcome between someone who's charged with the process of conducting the election versus someone who is permitted to observe it.
And what if they just happen to be at a poll that they don't like the place where they are, they don't like the election judge where they are, and they make up something, and all of a sudden you got a person who's charged with a Class B misdemeanor offense. Then they got to hire a lawyer, prove their innocence, and get out of this situation. I just think that there's a lot of latitude that we're giving poll watchers. I'm not saying that they are dishonest, but I just think they have a lot of latitude when they can only be dismissed for a breach of the peace and probably not even charged with any offense but the breach of the peace, but they can also turn around and have the election judge be charged with a Class B misdemeanor for something that they may allege as irregularities, and yet we don't train them at what those irregularities may be. We're just going to assume that they know.
I understand. I see your point, and I recognize that fact.
Let me ask you another question about,
Yes, ma'am.
about this. On page 13, and we on line 9 through 11, watchers who is entitled to observe an election activity is entitled to sit or stand near enough to see and hear the activity. Now, don't you think that there may be a First Amendment violation if they're hearing what I'm saying? I'm in there trying to cast my ballot, and I'm talking to myself as I'm going down my list, and they up there hearing what I'm saying, they close enough to me to hear what I'm saying, even though I might be that audibly loud. They can get close enough to hear what I'm talking about.
I believe, yes, ma'am, I'm sorry, I didn't mean to interrupt you. I think the goal there is outcome that may have been experienced in several jurisdictions in the state, especially during attempts to vote during COVID-19 pandemic conditions, where the opportunities to hear and see what was actually going on were limited. Instructions were made for folks to either stand so far away as to be not productive in their poll watching ability, or we heard, and I think you will have testimony that talks about their ability to observe in the same room, and instead they were told to look through a window or glass and not be able to see what was going on. And I think that language speaks to that. But if they're also taking an oath that says they're not supposed to interfere or harass with the voter or the process, and they can certainly be removed after a warning for doing so, I would think that there's not an issue for them to see and hear, since they are the eyes and ears of the candidate or political party that's present.
But why would you have it say near enough to see and definitely and hear the activity? They have to be close to you enough to do that.
I believe that there may be witness testimony that might show that sometimes it's across the entire room and they can't see anything that's going on. And I'd certainly like to hear the witness testimony, but that is where I understand and this language originates from.
Well, let me give you some information.
Yes, ma'am.
I had a poll watcher come and stand behind me. And normally in an African-American area and Hispanic areas, when they send poll watchers to our areas, they always send people that look like the Proud Boys into our communities. And they walk behind you and look just like they finna kick your rear end if you just move out of place. And they make you nervous. They make some people nervous.
Okay.
And this particular lady came and she stood behind me. And I politely turned around and asked her what did she want. And she looked at me and I looked at her. And I stood my ground, because I didn't think that she needed to come and stand behind me while I cast my vote. Number one, I could read. I didn't have any need for assistance by anyone, and I definitely didn't need her to come stand near me. And what she was trying to do, or probably had been doing, I'm assuming from her conduct with me, that she had been intimidating those African-American persons and those Hispanic-American persons coming into that precinct trying to cast their vote by the mere presence of her nationality, her ethnicity, Anglo, looking mean, you know. And I'm gonna tell you, I don't want to say it. Anyway, she left me alone, and I was able to cast my vote. But I can guarantee you, when that happens in our communities, it's a chilling effect upon the people who want to come and cast their ballots. And that in itself is intimidation as a poll watcher for me. In my opinion, I think that poll watcher should have been dismissed from that particular precinct.
May I respectfully ask, did you complain to any person there about that poll watcher?
When I had to say what I had to say to her, I think the lady left the room.
Oh, okay.
But I don't know if she came back. I didn't have to complain because I was vocal enough in my statements that the election judge heard me, and everyone else who was working that election in that room heard my statements. Now, I don't know whether she came back after I left voting, but the mere presence of her being in my poll, it was not, I wasn't concerned about her ethnicity as much as I was concerned about the way she looked mean, mad, tough. You know, like, you know, she's going to have everything got to be just like I wanted. You know, she's the guard, the prison guard in there. And she made you feel like you were in a prison. That's the kind of things that comes in our minority communities by poll watchers many times in an effort to be able to suppress our vote. And I believe that if she had some training, that she, number one, would have known that kind of conduct was impermissible. Now, suppose they call the police. What would have been the complaint? I felt intimidated as a voter for her conduct, and the police said, "Ma'am, don't get near her next time. She's gonna feel intimidated." You know, most people would have just left out of the room and probably not cast their votes, and they probably passed the word along, and other persons coming in that polling place would not feel comfortable about casting their vote. And those are the sort of things reason why I'm asking you about education, some kind of training for poll watchers, because that kind of conduct is impermissible.
I cannot disagree with you.
And
I
had the
think that
police
is
come out,
impermissible.
I don't think they would have done anything to her, particularly if they had been of the same nationality.
I do think that, well, in your opinion, you mentioned maybe it would have been a different outcome with proper training.
Yes, because sometimes I don't think, that's why I was asking about what do you mean by irregularity?
Understood.
Because I want to know, do they recognize what irregularities are? It's easy to get a person to come to a polling place to be a poll watcher because I want you to be a poll watcher. I'm going to give you a certificate. You can go to poll precinct number 1, 2, 3. And that's all the training that they need. They just go in there and seeing whether or not everything is going to orderly take place.
I understand.
But now you have a lot of responsibility on poll watchers in here because, you know, they got an opportunity to follow the ballot all the way down to the delivery place, right?
Yes, ma'am. Under current law, even they're allowed to follow in a separate vehicle.
Okay.
To accompany the ballot to a central ballot location.
Okay. Well, I like to work with you on this poll watcher because I don't want anyone else in my area, particularly in my district, experiencing that kind of misconduct.
Well, Madam,
I can take care of myself, but a lot of people can't take care of themselves.
I understand, Madam Chair, and I will look forward to working with you.
Okay. Thank you, Mr. Chairman.
Thank you.
Thank you. Before I recognize Representative Busey, followed by Representative Lozano, I want to recognize that Representative Chris Turner has joined us here this evening. So, Chris, thank you. Good to see you. Representative Busey.
Thank you, Mr. Chairman. Chairman, just to follow up on what Dean Thompson was just talking about, she just gave us an example of intimidation that would have gone outside the realm of what a watcher can do. They're not allowed to go over there when she's voting, when there's not an assistant.
That's correct, and I did point that out earlier. You're right. You're right.
But it happened anyway. So I think what we're trying to get at here is looking for a commitment for training, for required training for poll watchers to make sure they know fully, not just that they sign an oath, but that they understand what they can and can't do. Is that something, you just said you'd like to work with Dean Thompson. Is that something we can work towards adding to this bill, amending to this bill, some kind of training?
Yeah, and I'm very sincere when I said I look forward to talking to the chairwoman, and we'll work on that provision. And what I'd like to do, and I think that I would encourage the committee, is to ask questions of the resource witness with the Secretary of State regarding existing training programs for others that participate in this process to see what that might look like.
And I think we need to get that training put in here. I think the other thing is that's concerning about this bill that was just pointed out, the chilling effect that that would create and that would spread to a community at that entire voting site. This bill would require it to happen again and for the judge to witness it the second time. So you asked if she put in the warning, the complaint, so then the warning could be given. That extra step is going to still create that chilling effect to continue on. And so I think that's one of the major concerns we're bringing up here around poll watchers is that second step shouldn't be necessary, and especially in areas that really violate the rules already there. And so that's why the training is necessary, and that's why the warning system still is too much.
Well, arguably, in that example, Mr. Busey, and I know you and I have discoursed about this some, in that example, if in fact that poll watcher violated existing statute by, and I spoke to it earlier, by going over to where the voter is located and actually being in the area where the voter was in the voting station, that's a violation of existing law, and they could be dismissed immediately under that extra provision we talked about.
Without a police officer?
No, with the police officer.
Yes, so
Yeah,
that's a whole other.
And sometimes, I would say, sometimes I would think, speculating, but it might be better to have that law enforcement officer involved so that that person can be removed without issue.
Well, I think a couple things there. I don't know if that can always be
Understand.
obtained in a timely manner, but I also think I would let other members of our committee speak to what it may feel like to always have an officer standing there while they're voting as well, and how we get the access. And I think it's not always obtainable. We think about rural districts. I think we had Representative Clardy in committee speak to concerns of getting people out to sites. He said people come by horse where he is. So I think that's a whole other step. And what we're trying to do is make sure the election judge has the authority they need to maintain decorum at their site. And so I think that's where
they still do have authority here. There's just an opportunity for a warning, and the election judge is well-trained. And I go back to the process of working with Ms. T respectfully to develop some type of training for these poll watchers. Your point is well taken.
Let me go back to your opening statement, Chairman. You talked about the history of voting in Texas a little bit. You gave us a timeline.
Touched upon a few examples.
Sure.
Not give you
some good examples.
Yes, sir.
Some good examples. I think maybe you said 1983, sometime in the 80s, we expanded to early voting from just election day voting to expand. You don't have to give me the actual year, but I think it was in the 1980s you said we added that provision. That was a big step.
It was huge.
It was a step that at the time Texas really led the way on increasing access to the ballot by expanding voting days beyond election day. And so I guess what I'm looking for when I think about legislation and serving on the elections committee is how do we continue to take bold, big steps? The next big step that would be in your next layout years from now of the major things we've accomplished in expanding voting access. And for me, based on your timeline, the next bold step, and we'll hear a lot of our advocates who work in this day after day and understand voting access, and that's their passion and their fight. I think they would tell us the next bold step in this state is to expand online voter registration. And I have legislation to do that through the DPS portal. I hope you and I, between now and whenever this bill gets a vote, can work on a possible amendment to this bill to increase voter access by putting on expansion to the online portal. And I just want to elaborate on why. In our elections committee, the first hearing, we had the Texas DPS come forward and talk about the DPS portal and online voter registration. And if you don't know this, or people in the room don't know this, Texas already has this to some capacity because there's a federal mandate that when you are making a change at DPS with your ID, you are required to be allowed to register to vote. So on online, we have that in Texas as of September last year. We've now had over 970,000 Texans use that system. So, and Texas DPS came and said the system is working well and without complication. So, and I said, are there any problems? And this is all in committee testimony. The response is working well and without complication. So I think I agree with you when you laid out the history of voting in Texas, some of these bold movements. I hope we can work together for the next bold movement, which would be something like.
And if you don't mind, just to go back and hit that point again, I talked about the Texas motor voter law, which I think you're alluding to, which
Yeah.
is when we go in and do a vehicle registration, that voter registration be offered. Now it's a DMV office, but then
Yeah.
it was DPS office. And so that's what you're alluding to, is the fact that not only can you do it physically if you do a registration in person, but you're speaking to an online registration of a vehicle, correct?
Yeah, or your yes, correct. When you're updating your DPS
Or a license.
yes, then you have to have the option to tweak your registration as well.
And then you're sharing with me, and I'm making sure it's late. I want to make sure I understand correctly, that currently, if one was to go on the online portal right now, and I update my driver license with a change of address, for example, or I want to be an organ donor and I previously wasn't, you're mentioning that DPS has provided testimony that there is some capacity to do it at that point?
Well, and we already do it because, unfortunately, not because Texas led. In fact, Texas resisted this mandate, federal mandate. So I'm not sure this is tied to a Stringer case. I'm not sure this would fall in to our narrative of Texas leading, but we could. And what happened in September, it was ruled that federal law requires, when you're updating that, you have to have access to your voter registration. So this has to happen by federal law, and it has been in effect since September, and now we do it. I'm arguing that the next bold step is to open that up to anyone through the DPS portal.
I understand. Okay.
So they can register or change their registration. And as DPS has testified on record here, it's working well and without complication.
Okay.
So I'm just hoping we, as a 150-member House body team, can make your next list of the bold steps of progress in voter access in this state by doing that. And I've drafted that legislation before the special, and I'd love to work with you on it in the interim. I want to jump, serving on the Elections Committee, I served with eight of our colleagues, and we saw 300 bills filed this past session, this immediate past session, on elections, 65 of them described by national organizations that evaluate legislation to hinder access to the ballot box. I want to make sure that this bill is not the 66th, and I look at the intent you have, and it's to promote voter access. And so I think as we go through this entire, and I'm really going to focus on Section 5 with you here.
Okay.
But as we go through the entire bill, I think every question needs to be, are we promoting voter access? And sitting on that committee with our colleagues, and I'll speak for myself and my Democratic colleagues on that committee, and probably not just the Democrats, some of them are here, they can speak up, but Representative Fierro and Gonzalez and Beckley and myself sat through these bills time after time, trying to understand what problem are we solving? Are we trying to solve? And that goes back to what Representative Niave shared at the beginning of this hearing, is quoting the Republican-appointed Secretary of State's office. And I've got the entire quote here, and I know we've said it, but I think it bears repeating as we think through this process. Secretary of State Ruth Hughes said, despite the challenges presented by COVID-19, this election was a resounding success, and turnout among registered voters was the highest in 28 years as Texans exercised their right to vote. Then in our committee, same day we had the DPS come and tell us about how well their system was using, the Secretary of State's office, Keith Ingram, went on to say that the 2020 elections in Texas were smooth and secure and a success. So as that is what the Republican Greg Abbott, governor appointed Secretary of State's office, is telling us. So we're trying to figure out, why is there 65 bills that are being evaluated to not match what we're being told to happen in our state, that we had elections that were smooth and a success, and that yet we have bills that are going to make it harder for communities of color, for individuals with disability, for individuals where English isn't their primary language, for our seniors, to vote and to have access to the ballot box, even though the elections were a resounding success. So I'm just trying to figure out, when I think about legislation I'm going to file, what problem in this state do I want to solve? So I'm trying to figure out, what problem is this bill trying to solve? Maybe that's a question, if you would like to elaborate.
And I touched upon it a little bit with Chairwoman Niave. In response to what you mentioned that the Secretary of State's statement was, you know, I pointed out that under the auspices of COVID-19, there were several areas in the state that essentially we had non-uniformity interpretation of the election code, and HB 3 helps to make sure that we do have a uniform framework for consistency of the application of our code. And we've already cited a variety of those topics that I think get us there. That's an important intent of this, is because at the end of the day, we need that consistency within that framework, so the different citizens that live in different parts of the state do feel like it's being interpreted the same way.
But as I also think, though, as we look at the intent, what I've highlighted as key here, and you've spoken to it as well, is to promote voter access. And we have passed legislation after legislation in this building where we make carve-outs for small areas. This bill even does that, or for larger areas. So, I mean, when you say the intent is consistency, we don't mean 100%, though, because we realize even in this bill that some areas are different than others.
No, and the current election law already recognizes that. Representative Johnson ably pointed out that there are different jurisdictions and different sizes. And I go back to our legislative intent. We speak to actually multiple concepts there, and I don't necessarily treat one as automatically higher than the other. I think they are all specific goals of intent, including promoting voter access, as you've highlighted, but to go forward with reducing the likelihood of fraud in the conduct of elections and to protect the secrecy of the ballot. Those are also concepts within this focus of legislative intent at the beginning of the bill. And so I think each one of those components is an important concept that is promoted throughout HB 3.
Yeah.
And so I don't think one is singularly higher than another.
Let me just say, as we're about to move on to some content in Section 5, going back to what the Secretary of State reported, and I believe you told Representative Niave that you agree with that. You agree with the assessment of the Secretary of State, correct?
I do not disagree. I agree. That's correct.
Okay. So elections are secure in Texas. We agree with the result of elections in Texas. But nonetheless, you think there's a problem to solve?
But nonetheless, we did experience inconsistencies in the implementation and interpretation of current election code. And we've talked about numerous examples for that. And I think one of the goals here is to come back with House Bill 3, clarify and expound upon those so that we don't experience those inconsistencies amongst different subunits of the state, our counties, for example, going forward with election cycles.
Yeah. You know, earlier you referenced listening to that you don't agree, but you hear different news channels out there that talk about different theories and what's going on in the national landscape. And I think what is frustrating, if Texas is such a success in putting on our elections, this feels like at times parts of this bill are playing into that national narrative out there, the big lie that Donald Trump is president that was articulated, that there was cheating going on. I know you weren't on elections committee, but this is a continuation of that, some of that legislative ideas. We heard, you know, people think this is a long day. Every week was a long day in elections committee. We heard time after time people come and testify about fraud and lies and never backed up with evidence, nothing substantial. And so I'm just, again, deeply concerned that we're continuing to play into the big lie, the big national narrative lie, that there's an issue with the elections, even though our Republican appointed officials tell us there's not. But you're saying that's not what you're doing here.
I am saying that's not what I'm doing. I am pointing to the legislative intent that we certainly want to reduce the likelihood of fraud, which I think every person in participating in any election, whether they are a voter or a candidate, would certainly agree with. And I know that you're wanting to move on to the Article 5 provision, talking about voting by mail, and I certainly make that point there. And I think you're going to have a series of questions to speak directly to that.
Sure. Well, I hope as we continue through this conversation, as we continue to hear from our witnesses, that we'll keep in the lens of, are we promoting voter access as we go through these different provisions, and what problems are we trying to solve? And so With that, moving on to Article 5, Section 501, which is on page 16
Yes, sir.
in our hymnals here. Let's see. We've got, I stole that line, but. What we have here is dealing with a signature in an application, and we put some provisions in, and I'll read it. Subject to Section 1.011, an application must be submitted in writing and signed by the applicant using ink on paper. An electronic signature or photocopied signature is not permitted. Why are we adding the provision that bans a photocopy signature? Can you speak to the concern here and what problem we want to address?
So specifically, the language that you're seeing here was a House bill by Representative Harris, I think, and I'm sure you heard it in your committee, if I'm not mistaken, that focused on this. If you'll notice, it involves using ink, and it's a goal to try to show that there's an original signature that's obtained. A lot of focus is spent, and I think some of your lines of question will talk about the actual voter's signature. And part of the process is to compare signatures, especially whenever you have a ballot go out and a ballot application go out and then the ballot go out, and you want to compare those and make sure it is the same person that requested, that completed it. And so the specific intent by that is to ensure that you have a proper signature in front of you to accomplish that task.
Let me ask you here, this is something different from previous versions. We see subject to Section 1.011. Can you talk about your goal with including that language?
Yes, and talking with my counterparts here in the House, specifically Section 1.011 is existing statute that refers to the signing of a document by a witness. And I know that you are aware of this, but I'll just kind of highlight that when the code requires a person to sign an application, a report, or other document or paper, it may be signed for the person by a witness. And that person can do so because they're unable to sign because of a physical disability or illiteracy. And they simply need to make a mark on their paper, and then the witness does the rest. And so that was in discussions to ensure that what we're talking about here doesn't necessarily create an issue for someone with a disability. And as we go, I do think this certainly fits that category that you mentioned about promoting voter access by referencing that specific provision.
Well, and I appreciate that being included here. Have you had a chance to talk with, I know one of our invited witnesses coming up is Chase Bearden with Coalition of Texans with Disability. Have you had a chance to talk with Texans with Disability or one of the other disability advocate groups?
It's been a very busy special session so far, but I know I certainly intend to, and I believe my office has communicated.
So your intent here was to make sure there are some exceptions for individuals with disabilities when it comes to this?
That is correct, and these exceptions exist in current law, and so it's simply to expressly highlight that fact.
Well, we're going to hear from Mr. Bearden and some other advocates later. If they feel this doesn't go far enough, will you work with them?
My door is open, and I know that, we're only on the third day of our special session, but I'm happy to visit with that advocacy group and any other advocacy groups.
Yeah, I appreciate that, because I think, and we'll ask them when they're up here to try to address throughout this entire bill anytime they feel there's a hindrance for someone with a disability, or we need to go further to make sure that's protected. And I take you that's your commitment as well, that we can.
I am all ears when it comes to paying attention to the observations of those that are looking at it from an important lens like disability.
Absolutely. All right. Well, thank you, sir. Moving on, Section 505, page 20, lines 21 and 24. Election code is amended. If the information required under Section 84.002A1-A included on the application does not match the information on the applicant's application for voter registration, the clerk shall reject the application. So what we're talking about here is we're requiring an applicant's identifying number provided on their ballot by mail application. So we're dealing with the ballot by mail application to match their voter registration. One thing I worry about here is, let's say Jane Doe registered to vote with her driver's license, or let's say she registered to vote with her Social Security. Maybe this will make more sense.
Okay.
So she registers to vote with her Social Security.
Well, first, can we just elaborate for purposes of the committee? since this section actually refers to a section of the code. So when we talk about, they're supposed to, if the information required under section 84.002 doesn't match what's supposed to be on there from section 13.002, can we clarify that under 13.002, we're talking about the applicant's driver license or a number on a personal ID card issued by DPS, or the applicant has their social security number, the last 4 digits, or a statement that they have not been issued a number. That's what we're speaking to?
Correct.
Okay.
And it's actually in that order, which is why I think the scenario I want to use is, let's say they register to vote and they use the last 4 of their social security.
Okay.
Okay, and let's say 20 years has gone by. And now they're applying for their ballot by mail and they use their driver's license number. Maybe they didn't have a driver's license at the time, so they didn't use that. How I read this bill, if they used one at one time and they used the other one at the other time, then that application could be rejected because the numbers don't match.
And so, understanding that concern that you have, I visited with resources at the Secretary of State, and I hope that they will expand upon that when they come as a resource witness. But the Secretary of State actually trains your clerk to look into the database that they're trained to access and check the numbers. And so those votes they are counted. And so I think in practice, and so here's where I want to go. My understanding in practice is that discrepancy that you're speaking to doesn't occur because those clerks actually go check the numbers to make sure that they jive. But when you read this bill, you don't overtly or expressly see that. And I know that gives you pause to say, well, I certainly don't want to disenfranchise the scenario voter that you spoke of. I want to make sure that clerk is not going to reject it solely because 2 numbers don't line up, because they're different numbers and the statute allows one number or another number. And so I think ask the resource witness that question, but if that's not sufficient for you, I'm happy to work with you to make sure that it expressly clarifies here that we're certainly not out to catch somebody where they used one number one time and used the Social Security last 4 a different time.
So
Does that make sense?
Your intent is as long as they're using one of their approved measures.
That's correct. That's correct. So
because literally it says the clerk shall reject the application, which is why I'm concerned.
So the whole goal here, and I know in practice, I think the Secretary of State will tell you that doesn't work that way. The goal here is to simply align voting by mail identification purposes with in-person identification purposes, which is why we're citing the same statute. Okay. And so to take that extra step, if that is something that eliminates your concern, I have no problem doing and putting that language in the bill. And I'm happy to visit with you once the committee's completed to.
I appreciate that. And then just to jump ahead, and then I'll come right back, but Section 510 deals with almost identical language. I assume your intent here would be the same, so we don't have to go through all that.
Yeah, and in 510, I believe there's also some language in there about a rebuttable presumption, which I think is actually more significant, and so it makes it a little different. So it says the signature on the ballot on the carrier envelope shall be rebuttably presumed to be the signature of the voter. So as long as those signatures exist, is that what you're talking about in Section 510?
Well, I'm also talking about, though, it still deals with requiring that the identifying number.
But yes, consistency throughout this section.
Yeah, I just want to make sure you would agree to both.
I'm sorry.
Okay. Sorry about that confusion.
It's only past 8 a.m. for us, so I apologize.
We're still rocking and rolling. 506.
Yes, sir.
Page 20, lines 25. Requires that a voter put their driver's license number or social security number on the underside flap of a carrier envelope. I have one here. I actually have this as a prop for later, but just want to make sure people see a carrier envelope. And so I guess you're talking about this, this little section right here.
I believe that is accurate, and that was also legislation that you heard in Elections Committee, if I'm not mistaken.
I don't know if everyone can read this, but, and this is really for questioning later because it's not in this section, but we want to add more content to this. So we'll talk about how we do that later because I can't figure it out. But have you had a chance to talk with clerks about any challenges from putting information in here what it could lead to? I mean,
On that specific question, no, I haven't talked to the clerks specifically about that process, but there does, as I explained earlier, trying to simply align that identification process for mail-in ballots versus in-person ballots, that seems like a practical way to get there. But yeah, I'm happy to hear the testimony that may be forthcoming on that topic.
Yeah, I'm just trying to figure out, one, why we want to put more stuff on there. What happens if a voter doesn't use the provided secrecy envelope that comes with this?
If I'm not mistaken, later in this section, there are language to cure those defects, given the time frame in which it comes in.
And so your language would include if they didn't use the proper envelope or any other accident like that.
So if you review that language, that's actually a Senate bill by Senator Zaffarini. And so it gives provisions so there's an opportunity to cure for a variety of reasons, but it also depends a little bit about when that envelope shows up. I mean, if it shows up too late, then there may not be an ample time to enact the cure. But it certainly puts provisions in place so that a cure could occur.
But your cure would be for any defects, they can come in and work on that and get
Whatever's set forth here in the legislation. And there are several lengthy pages on the cure itself.
In the same section, it talks about signature verification on page 25.
Page 25, and you're in section 5.10.
Yeah, let me find it for you. So I'm on 25 lines 13 through 17. So yes, may also compare the signature with any known signature of the voter on file with the county clerk or voter registrar. So what we're changing here is, used to be, can compare with any two or more signatures of the voter on file with the county clerk or voter registrar to determine whether the signature of those of the voter. I guess my concern here is, as I read it, it's removing two distinct safeguards with signatures here. First, it's removing the limitation that you cannot compare a signature that is more than 6 years old. Second, it is removing the requirement that multiple points of comparison be used when determining a match or throwing out a ballot. Is that how you read this?
So in answering your question, is your concern that you're not reviewing enough signatures that may be of record?
Yeah, I think that's part of it, and I think we'll hear from some witnesses, but signatures change over time. We don't always write them the same way. I think when we're looking at a single point, I'm afraid that we're going to throw out people because we're using people with minor training, but not signature experts, to determine throwing out ballots based on signature.
And just to clarify, there on lines 13 and 14 that you're speaking to, talk about compare the signatures with any known signature. So we're not singling it out. I think it actually makes it a little broader in scope to make sure that that vote is counted, not is rejected. So my interpretation of that is actually it's an expansion of voter participation. So we're no longer going to say, oh, we have to compare it with two signatures. It's any known signature that's on record, and if it matches up, then it gets counted. And so I think you and I might be on the same page with that, and viewing that as that's promoting voter access, and that's ensuring that that vote's going to be counted.
One second, please. All right, and then let me ask you another thing. Section 5.15, which is page 28.
Section
5.15, 5.15.
Okay.
Page 28. Line 26. So this is each member of the early voting ballot board.
Yes, sir.
Something that's deeply concerning to me in this bill.
And I believe you and I have actually had conversation about that.
Absolutely. And what this bill would do, it would permit members of the early voting ballot board to make and keep notes. And what I'm concerned about here is members of the early voting ballot board have access to private information. So one, I'm asking, before we even talk about what they could have in those notes and what that could mean, why do we want them to be able to make and keep notes?
So right now, you're aware that poll watchers are permitted to make notes. there are some restrictions on them leaving with their notes.
But also poll watchers don't have the same private information access that these individuals
That is
would have.
exactly correct, yes. And I believe the term of art that the Secretary of State will use is personally identifiable information, or PII. That has to do with any information that could be used to steal one's identity. That's what you and I are speaking to. I also understand that Section 552 of the Texas Government Code prohibits the distribution of any personally identifiable information. And also, Section 552 requires copies of any notes. They would have to stay with the voting clerk and with the elections records for a 22-month retention period. Per my understanding, I'm going to quote my source, the Secretary of State. So when you talk in the concept of taking notes, and then we take it a step further and say, what happens if those notes do contain personally identifiable information, then that concept right there is addressed currently in the government code, because there's a prohibition against distribution of that. And there's also a requirement that copies of those records be maintained. So it's not like they get to take their notes and leave in secrecy with notes. They'd actually have to, copies of those notes have to be made if that were to happen.
So they're taking these notes home, but they can't have any private information. So what type of notes are they taking home?
No, it prohibits the distribution of the.
So they can take home your private information.
And I would ask for clarification from your resource witness on that. I don't know that there's a prohibition against what might be on the note. I'm talking about the fact that if it is personally identifiable information, that in and of itself is not allowed to be distributed somewhere. So, for example, we might have notes that really don't have anything to do with personally identifiable information. So I think you have two categories, I'm guessing, just to keep it simple for us. So we have one category that might include a date of birth or a driver's license number or a social, or
So that's more.
Correct.
Well, not the social, but yes, those are more public.
Yeah, those are parts of information that can be used to steal your identity. And then other notes just might be the number of ballot boxes that were observed, or what happened during their process, and they wrote down date and time. So it's really more of an internal note process. I think you do have a dichotomy of two types there. I think you're mainly worried about the personally identifiable information. Is that correct?
Sure, that would be at the main issue, because we're worried about someone getting private information, taking it home with them. And while maybe they can't use it or distribute it, we're enticing. I think we're doing something that's enticing people to have information that they could use against someone, even if it isn't at their crime.
So to that degree, I'm also happy to continue discussions, since you and I have had discussions on this topic, to see if there is any language that we could bolster the fact that personally identifiable information remains protected, and it's not some section of the government code that's in another one of these books. And so I'm happy to continue to visit with you about that.
We can find a solution that would keep them from having that personal, that personal, private, identified information going home with them, and thus ultimately opening up Pandora's box for sharing information.
Nobody has an intent here to open up, as you describe it, a Pandora's box of that information being out there, I think. Now, in their role, obviously there is some exposure of that personally identifiable information, and Section 552 of the Government Code certainly prohibits them from distributing that.
Sure.
And we can agree on that.
But I also think having them take it home is concerning. Let me give an example why. They can match back, stuff coming in, seeing who voted, seeing how people voted, seeing how candidates and elected officials voted. And so it's just concerning to me that this could be used in the future.
I disagree with your concerns there, but I've also said I'm happy to have the dialogue with you to see if there's some remedy in addressing.
You disagree with that becoming knowledge of people?
No, that what your concerns are about what they might do, I don't necessarily think that is a concerning issue. That being said, I respect that you have a concern about the personally identifiable information, and I will happily continue dialoguing with you about making sure that is protected.
Okay.
Okay.
I just, I have, now it wasn't through the early voting ballot board, but I have information, right, that from friends, colleagues here, that maybe Republican colleagues that didn't vote for some of the people that serve in statewide office. And if that was obtained by someone through the early voting ballot board, they may not want that information to be shared or to be obtained by anybody. So I think could hurt them, could hurt their career. I think there's real, and that's just a kind of a goofy example. What we're really talking about is identity theft. What we're talking about is personal information, violation of your privacy in voting, and that going home with you. And so I think we just need to be really careful and make sure, one, I think we still got to ask the question, why are we letting them take notes home in the first place? If their copies are staying there, if this is tied to a future investigation, a future issue, there's going to be a copy on file, you said, for 22 months, correct?
If they take the note, if they make notes,
If they make notes.
they make notes.
Well, why do they need to take it home? Why can't we just let it stay there locked up for those 22 months, and then it can be referenced in a future case?
And I would go back to, I think, access, and I would ask the Secretary of State resource to explain that specific scenario, and then I'm happy to come back in closing and talk about this specific issue, if that's okay.
Yeah, absolutely. So you're open to us continuing?
I am open to us to
Conversation.
continuing this dialogue. Yes, sir.
All right, I will make that note. And then I would say, Mr. Chairman, I have a few sections later on, but that is it for this section.
Okay, thank you, Representative Busey. Next, the chair recognizes Representative Lozano, and he will be followed by Representative Moody.
Thank you, Chairman. And Chairman Murr, just a couple of quick questions, maybe suggestions. On page 13,
Page 13, yes, sir.
line 3, where it says enough to see and hear, as Ms. T was speaking about earlier, would it be a little less subjective if it were to have like 6 feet or something that the polling judge would easily be able to denote with, tape or something that you can go up to this line where there's no ambiguity and it's uniform across every county? I just foresee if you have a polling judge that is kind of grumpy, so to speak, or he doesn't like a certain poll watcher, and he's like, you know what, you can hear me just fine. You're just trying to create a problem. Well, if there's like 6 feet, that's not debatable.
Your point is well made. I do understand that. I guess the only challenge we may have, and I think, again, a resource witness can clarify, is, these locations will all have different dimensions, and some will be expansive. You'll have lots of room, and other places might be small. So I guess practically speaking, is that a workable solution? I'm certainly open-minded to that, because I agree. We certainly don't want to set ourselves up to enact policy that can create additional problems. That's fine. And the point was well made by Chairwoman Thompson earlier. A remedy to that shouldn't create a new problem. And so I would just want to explore if that in and of itself creates a new problem, or is that the solution?
Yeah.
So, and I'm happy and I'm all ears to continue that dialogue by talking to our experts, and also to get your point of view as you work through that.
Okay. And then this other question, and the last question I have, it deals with, on page 13, line 23, and you mentioned it's already allowed in current law for someone to follow the transfer.
Yes, sir.
So they could follow the vehicle, I guess.
Yeah, right now in section 33.060, it actually allows a watcher to follow an election officer in a different car, and that satisfies that process if they're moving election records, say, to the central polling location, for example. Mm-hmm. And so the current law does allow that, and then that way they observe that all the materials that I guess they're in the car that they're following, and they could ride in the car too, I'm assuming, if it's a small town and everybody knows each other, but they can follow that vehicle to its destination and observe that those materials or election records are unloaded and taken inside. Yes, sir.
Okay, great. And I say that because I actually have an experienced members. One of my elections, there was this one box that had not come in. That was the only box that was remaining in all.
What number was it?
Well, it wasn't box 13, okay. Actually. It wasn't box 13, but it was in Jim Wells County. And there weren't enough votes in that box for us to lose the election. But someone called me from the courthouse to say, hey, the box just got here. It's 2 a.m. And I think the seal was busted. And I just had this feeling like there's going to be 2,000 votes in alphabetical order. And so I wanted to ask you about that. So members, the Box 13 scandal, it happened in Jim Wells County, which I represent, during the Senate election of 1948. And LBJ appeared to have lost the Democratic runoff primary to Coke Stevenson. But 6 days after the polls had closed, 202 additional ballots were found, all of which were in Johnson's favor. So, Chairman Murr, was Coke Stevenson, that was your grandfather?
That is correct, sir. I would say that the largest, most infamous election scandal in Texas history is directly related to my family.
Yes, sir. Thank you, Chairman. I just wanted to point that out to the committee.
Thank you, Representative. Next chair. Yeah, use the mic next to you. Chair recognizes Representative Moody.
Thank you. Now we know.
Now you know.
Now we know why you're here. This is a long time vendetta.
There are not very many of us up here that will allow it.
I'll leave that there. You'd agree. I'm gonna go to Articles 6 and 7 of the bill. You'd agree with me. I mean, I think a lot of the work that we do as representatives is tied to helping our constituents with, I'll call it government red tape. You'd agree with me that we get those calls in our district office. I got a problem with DPS, or I got a problem with this state office, or I know we certainly got that during the pandemic with unemployment.
No, yes, Mr. Speaker. I would say, and I lump that into constituent services. Our staff and ourselves, we get calls, we get stopped on the street, at the grocery store, at the ball game, and we do that a great deal. You're correct.
And we hear that a lot in this building. I know certainly in politics. Let's clear the red tape. Let's clear the bureaucracy. We need to make government accessible. Those types of things. Those are things we hear a lot about.
Yes, sir.
And you'd agree with me that, why we call it, we get frustrated with quote unquote red tape is because it makes what should be simple tasks difficult, right?
Sometimes that is the end result. Yes, sir.
And so,
even though, and I would interject, policymakers may view the red tape that you talk about as with good intentions, or it may have a meaning or purpose that the end user is not aware of.
and I agree with you, but then when it gets deployed out of our brilliant minds here and then out into the state, and sometimes it's implemented in ways that we didn't ever intend it to be implemented. Isn't that correct?
That is occasion, very true, yes.
Because I don't know if you know, sometimes we're back here every session and we're referencing stuff we did in past sessions. We got to fix that because the way it went out into the field didn't work.
Well, and that's also combined with the fact and the point I made, which is a lot of the policy that we consider is constantly ongoing because we implement it and we determine what works and doesn't work, and then we improve upon it if we can.
So that, and have you ever been to a government office to do one of these things, a tax office or license registration or property taxes, anything like that?
I believe I've been to all of them, yes, sir.
You've had constituents that go do these things. Do you ever have the occasion to fill out the wrong form or forget a piece of information, or you weren't able to complete the task that you had because there was something you didn't have handy when you were there? That ever happened to you?
I believe that has happened on occasion.
And have you had constituents have that happen and they complain to you that, why did I have to go do this and I had to go this line twice? And
yep.
Okay, so that, we know that happens. And I guess why I bring all that up, would you be worried about going through those processes and those places to do those things, that if getting it wrong meant that you would be a felon? Would that change that dynamic of going into that government space. That a
Well-
mistake being made or something going wrong in your visit to that office puts you in a category of being a felon.
Now, arguably, you don't go in there without the opportunity to ask questions or seek instruction. So I don't want to answer that in a vacuum. But I'm sure for any person, the statement you make would certainly cause them angst.
Well, and I'm going to drive that kind of down into it a little bit in detail, but I guess the point is there are in this bill multiple criminal penalties that didn't exist before based on new requirements that are being placed on voters and the people that assist them.
I was going to say, and the people that assist them, yes.
And so those are new. To those people entering that space to help people vote or to get people applications, that there are places in this bill that have new criminal penalties, right?
There are provisions in this HB3 that do include new criminal penalties.
And
That is correct.
I guess my point is, well, let's kind of go through those. So in 6.02 of the bill, page 29, line 14, that's where we start there. You've got a new form that must be completed by anyone assisting a voter, right?
Yes.
Okay, so I'm going to call this new red tape, additional red tape. Now, red tape carries with it a negative connotation. You may not want to give it that connotation, but this is something new that's required of this assistant, right? Doesn't exist today, will exist if this bill becomes law.
I would agree with that. That's correct.
So is this information about assistance that is already being entered in by election officers?
To my knowledge, it is not, but I would certainly encourage you to ask the resource witness with the Secretary of State to clarify that. And in talking about the specific provision that you're referencing, you'll see on lines 24 through 26, a very important component of that is whether the person assisting the voter received or accepted any form of compensation or other benefit from a candidate, campaign, or political committee. And I think that speaks to the purpose of the form, even if perhaps you were to view it as the level of red tape.
So are there current allegations or cases that we know of people doing it? Because I guess that's what we're driving. Is the nefarious activity we're trying to get at is that people that are receiving compensation or other benefits from a candidate, campaign, or political committee are assisting and doing things improperly?
I believe that you could hear anecdotal evidence from witnesses. I think that you have probably, some or all of us have heard some stories where either it's an overzealous person in support of a campaign, or it's actually more organized than that, where they assist voters. I think you will find that your resource witness with the Office of the Attorney General will explain that some of the cases that they handle would go down this path where there is someone there that has been compensated by a candidate, campaign, or political committee and is assisting someone to vote.
Well, with respect to their office, that office is in my opinion, hyper-politicized and is compromised and is never going to offer anything of value to this committee. That's just my opinion. But anecdotal stories, and I mean, those are good. I like stories, but I also like facts. And so I want to know what the nefarious activity is going on here that we're trying to address. And so if that's not something that you have at your disposal and some other resource witness does, consider you yourself asked at this point. So when you come, I'm just, whoever it is, go ahead and answer that when they come up, because I'd like that information.
And so just to clarify, the point here is the name and the relationship of the person. That shouldn't be an issue for most folks. It has to do with whether they're receiving form of compensation. And that goes back to one of the legislative intent items there is, which we talked about at the beginning, is we want to reduce the likelihood of fraud in our election system. And certainly there is opportunity there for campaigns, political campaigns, other parties to engage in that. Having a form like this involved for someone who does assist a voter certainly reduces the likelihood that fraudulent activity might happen or that somebody is overtly influencing someone voting, because at the end of the day, it's a constitutional right that we all hold dear and near. And if someone's taking advantage of that for political gain, I think a form like this certainly discourages that or will identify that.
But wouldn't we have a record replete with instances of someone saying, this campaign did this to me, or this campaign did that to me? I mean, is that, because,
I can't.
look, I'm aware of.
I can't say that's always necessarily the case, because the person signing the form may never have divulged that they were receiving compensation or benefit from a candidate, campaign, or political committee to the person they accompanied to the poll. So it's really not necessarily, I think, easy for us to assume that's the case, that the voter would complain.
What's the harm we're after if someone assists and is working for a campaign and voter X is assisted in that instance and they wanted to vote for that campaign or candidate?
Well, then we all know about it. And the other campaign, because I'm assuming if it's a campaign, there's an opponent, they also are aware. And so sunlight is good. And it goes back to that core principle. We want to make it easy to vote and hard to cheat. And having a form like this for someone assisting them in voting certainly makes it a little bit harder for influence to occur, and
also makes it harder to vote. What happens in this instance to the voter or the assistant if there's a mistake on the form? Let's say there's a mistake on the form, or there's missing or incomplete information on the form that's promulgated. What happens to the voter or the assistant?
And I'm looking at it in congruence with the following sections. Is that where we are? I'm just trying to read it properly.
Yeah, I mean, what's the consequence? So there is a mistake, or there's missing or incomplete information. What?
It must be submitted to the election officer at the time the voter casts the ballot. So I think that falls to the election officer to ensure that the process has been completed, just as though someone is going through the voting process and you have incomplete ballots, et cetera. So I would assume that the election officer would handle that at that time.
Okay. Have you or a member of your office done any research as to how this change in the law would impact voters of color?
No one in my office has done research on that topic, no, sir, on this provision.
Are you aware of any government entity that has done any research as to how this change in the law would impact voters of color?
I am not aware at this time, no, sir.
Are you aware of any private entity that has done any research as to how this change in the law would impact voters of color?
I have not been advised of that, no, sir.
Do you think it's important for the body or this committee to know whether and to what extent how this change in the law would impact voters of color?
I think it's important to consider all information that's known or available. At the same time, I go back to the intent that we talked about. The likelihood of fraud seems, practically speaking, to increase where someone is, especially with a campaign, helping a voter vote.
Is it your intent to ask any governmental entity whether and to what extent this particular change in the law would impact voters of color?
I have no hesitation in asking any applicable agency or entity that question.
Okay. Let's go to 6.03.
Yes, sir.
And we've got new provisions of an oath here, right?
Yes, you have an existing oath in current law, and so 6.03 modifies that. It amends that language, including explaining that this doesn't apply to an election officer. Obviously, they have their own set of requirements.
And where is this oath happening? Is it the?
I'm sorry.
When this oath is given, where is it occurring?
I would have to consult the provisions around that in the election code if you would like to answer your question. Otherwise, we have to go to resource witness.
No, that's all right. Go ahead.
Okay. So it's my understanding that this oath occurs at the time that the voting process is also occurring. And I would qualify that with happy to receive the expert advice of resource witness to clarify.
And it's a longer oath now, is it not?
It does add a couple of lines more than the existing oath.
And does a longer oath slow down polling places, even if it's only incrementally?
I don't necessarily agree that it slows anything down, no, sir.
Well, even if it's, I mean, even incrementally, it's longer. It's going to take longer.
A few words are added to the oath, that is correct. I don't know that
Well, that's why I said
delays
incrementally.
But I would not necessarily agree with you that it causes a slowdown or delay in the process.
Well, it's added time to someone engaging in the voting process.
Yes, but I don't.
Depending on how many times that happens at a particular location, depending on the voters that go to that location, maybe that's cumulatively may make a difference. I don't know. Why is the current oath we've always used insufficient?
My understanding is there certainly is a desire to as I go back to our legislative intent, the reduce the likelihood of fraudulent activity or conduct, and at the same time increase confidence in our processes. If you're going to have someone who's selected to provide assistance to the voter, then this is the oath that they would take while they're providing assistance to the voter. And that tells us, the rest of the world, that they're not influencing the outcome of that vote. We want them to have assistance, but I certainly wouldn't want someone in there that's steering someone to vote a certain way each and every time assistance is being provided. I want to know, and you would want to know, that they didn't pressure or coerce the voter into choosing that person or the results of their vote.
Okay. Part of the new oath is certifying that the voter is eligible for assistance. How is that something the assistant can know beyond what the voter represents to them?
At this point, I don't know that I can answer your question. I just think that they are saying they're eligible because the voter that is requesting the assistance has a physical disability that renders the voter unable to write or see, or an inability to read the language in which the ballot is written. Presumably then, the person providing assistance doesn't have any of those limitations.
So if the voter, so we're relying on what the voter's telling them. So if the voter says that they can't read English, for example, and it later turns out that they can read English, is the assistant facing a perjury charge at that point?
I believe it says the voter I am representing represented to me that they are eligible to receive assistance. So I don't know that that subjects them to perjury, no, sir. Not under the facts that you provided.
So what happens in that case, same scenario, what happens to the vote and the voter? Any sanction for violation of the?
I'm not aware that there's a sanction for a violation for the voter on that.
Okay.
But I seem to hear you again. That tells me that I would ask for clarification from the Secretary of State's resource witness on that. I would assume under current election law that there might be some penalty, but I don't have that at my fingertips.
Okay, so then I'll say that to the,
Please.
that into the ether.
Yes,
Or the
into the ether.
experts listening intently when they arrive here at 1 in the morning. Consider that question asked, please, and answer it when you arrive. You gonna be later than that? Okay. Let's go to 6.04.
Yes, sir.
This is adding similar requirements that we just talked about to assisting voters, but not, now we're outside the polling place. You're in the vote by mail environment, right?
Yes, sir. It's a ballot by mail. That's the distinction. We always have you vote in person or vote by mail. And vote by mail obviously is limited to the eligible categories.
Okay, and
Yes,
so
sir.
I guess some of the same questions I had before. Why the additional red tape? What is the real world problem? What are the real world cases that we're trying to address with this additional red tape?
And to treat both an in-person voter and a person that votes by mail similarly, that's why you see this provision there first. Second, in talking about that, and we alluded to, certainly the existence of likelihood of fraud, and any time that you have a ballot that's going to leave somewhere, go to someone who's requested it, and hopefully it comes back, there is certainly a potential or likelihood of fraud. And I think overall intent and policy goal is to reduce that likelihood of fraud. And in this scenario here, if they did have someone that assisted them with a ballot by mail, that's done outside the polling location. There isn't anyone else. There's not an election judge to observe that process. And so we're also accumulating the information from who assisted them, which should be fine if the person assisting them was just helping them out. But it also alludes to the fact that they, whether they received or accepted any form of compensation or other benefit from a candidate, campaign, or political committee. And I think in that scenario, if they were to say yes to that, then you may experience an increased likelihood of fraud in some circumstances. And so our policy goal there would be to highlight that, provide sunlight on it for the benefit of all and a fair and safe election.
I keep hearing the words potential and likelihood and opportunity. And this is where I really think most of us have caution. I can come up with a lot of scenarios. In fact, I'm going to have some hypotheticals for you in a second. But, the real world data does not bear out that there's a problem here that's in need of addressing. Potential likelihood and opportunity seems like a light standard when we're talking about the precious right of the vote and access to the franchise. Wouldn't you agree?
And what we're specifically talking about is not an individual voter. We're talking about an individual voter that has someone assisting them. And I think that's...
So you would agree that giving people an opportunity for someone to assist them is greater access to the franchise, because some people need assistance depending on their circumstances.
I don't disagree with you on that.
And so when we curtail or put additional red tape in front of those assistants, whether that be at the polling place or vote by mail, that is by definition going to decrease voter access for a certain population.
And I would respectfully disagree with
That's
your
fair.
conclusion. Yes, sir.
That's fair. And so there's data that there's research you've done that shows that this provision will not impact.
No, you have a conclusion, and you've reached that conclusion of your opinion, and I go back to say we have legislative intent here when we talk about voter access. Equally, we talk about certainly reducing the likelihood of fraud, and that we want our ballots to be secure and safe. And so if you're going to have someone else that's involved in the voter's decision-making process and the completion of the ballot, especially if they happen to be involved with a campaign, a candidate, or a political committee, that should tell you that we would want to take steps to clarify that discourage inappropriate behavior, and having a form such as this where they indicate that would certainly help do so. It's not intended to discourage or decrease voter access, in my opinion.
Is it your opinion that this provision will not have any impact, will have no impact on a legal voter having the ability to cast their ballot?
What we're talking about in section 604, for example, no, that is my opinion. It would not. It's a ballot by mail. They can take as much or as little time as they choose to receive and complete it. And if they're receiving assistance from another person, that other person is also giving of their time. Very helpful to know if they're giving their time and they're being paid for or compensated in some benefit.
Do you think added, and I'll go back to another question, do you think added criminal sanctions and penalties, chill the conduct of people that want to assist voters, whether they're doing it for compensation or not?
No, I don't think that, in my opinion, no, I do not think so. I think they only discourage folks from improperly influencing the voting process. But if it's somebody who's legitimately assisting based on my community and knowledge of some of my constituents who might conceivably have assistance, I do not see a scenario that answers your question in the positive. I see that.
No. I appreciate your answer. It's just I've been, and this is not a commentary on your answer, having worked in this building for over a decade on criminal justice laws and people coming forward and saying, we need to make a crime here because we need the signal going out that people shouldn't do this. We want to discourage people from doing this. We want to send a message. We want to get people knowing that this is bad conduct. And so there is the intent there to you frighten people away from something. So if there's a crime here and they don't understand it, because this is a process of a legal ballot like being cast. And so if someone doesn't understand this and they see there's a crime over there, couldn't it possibly have the impact of going, I don't know what any of this means, and I certainly don't want to be accused of a crime. I'm out of here. I don't intend to commit a crime, but I certainly, we talked about it earlier today, I can guarantee you that anyone in here would make a promise to you that they're never going to commit a crime, but they can never make the same promise that they wouldn't be accused of a crime. And so when we create this type of criminal sanctioning regime around the franchise, it necessarily will have a chilling effect on assistants and others from being in this space and helping when we already have sufficient protections in place for these scenarios. Wouldn't you agree with that?
I don't know that respectfully, I would not agree with that. I
said a lot of things in there, though.
I know you said a lot of things.
Gotta agree with some
You did.
of it.
And Mr. Speaker, I can agree with you on other topics at other times, but I cannot agree that would necessarily have a chilling effect. I think that if there is a person that's assisting somebody to vote by mail, and whether it's a family member or a friend or someone else, they're not going to be chilled by filling out this form, but you will see the sunlight come out whenever they do have to state that they have received or accepted any form of compensation or other benefit from a candidate, campaign, or political committee. And that's the influence where we have an outcome that's not clean and tidy. It's influencing that vote and therefore affecting the voting process. And so I focus on that. So it's going to influence the ones that they're being paid or compensated in some fashion to help someone fill that out. That goes to the light of, are they influencing the vote itself?
Well,
and I don't know.
So when you say you're bringing light to a situation, I mean, I think then and it kind of cuts against some of the stuff you said earlier, but that like these, when you say you're bringing light to an arena, that necessarily means that you do believe that.
Talking sunlight, and I believe that there is the opportunity, and just as I go back to it.
But you bring light to something and go, oh, something wrong going on over there. So the assumption has to be based on that there's something wrong going over there, and we're not catching it. We're not catching it under current law.
And perhaps that might be the case. I don't know. I'm not postulating that we are, but if there is a greater likelihood of fraudulent activity, when someone is working with a campaign to help and assist a voter to fill something out versus they just have the assistance of a family member. That there certainly is a distinction I think you could draw there, and knowing that information is beneficial for the goal of reducing fraud and promoting the integrity of the ballot itself, so that we know that that person that cast the ballot, I mean, that's the decision they made, and they weren't influenced by the person assisting them.
Gotcha. And I know we've had multiple conversations prior to when we came here to talk about this bill. And there's a phrase here, and I think this goes to the point of why, there's some caution should be around here. There's at the top of page 32, and this actually may have been the result of a conversation we've had. So you have assisted by a previously known attendant or caregiver. And I kind of think I know what you're getting at here, but this is a phrase that I would say is ambiguous. And when there's ambiguities in a provision that have criminal penalties attached to it, that makes me nervous. And so I think this is even one that we've talked about previously, and I would still say there's an ambiguity around it. I mean, because what's previously known to whom? I mean,
I believe that modifies previously known to the voter. That's my understanding, and that's how I would interpret it.
That's how you would interpret it, but
That's correct.
But like I said, that's an ambiguity. Just point that out because I think there's a few things that fit in that category.
And I believe that's not the only place that language is in the bill. I think you have it in another spot as well.
I think that's right, and that's what I'm saying. Like even in a space in which we probably had a conversation about this, we might have an ambiguity and we have a criminal penalty attached to it. So that's why I think, and I think we should be cautious about moving too quickly on legislation like this. I'm going to go to 6.05.
Yes, sir.
We're expanding the prohibitions on compensating people for voter assistance. Is that right?
Expanding and clarifying by different language, that is correct.
So given the stricter restrictions in the bill about assistance and those things being backed by oaths and forms that we just discussed, what's the problem? What's the problem we're trying to address here? What's the real world problem is a problem that people might be helping other people vote for the candidate of their choice?
I think your goal here goes to the reduction of the likelihood of fraud, especially when someone is being paid to help voters vote. And that's what this section in current law that we're looking at here, that we have amendments to, speaks to. And I think it keeps it in a more simple format: compensates or offers to compensate another person for assisting voters, solicits, receives, or accepts compensation for an activity of helping someone vote. And we go back to a scenario where someone's being paid to go help people vote. And does that influence those people's votes when they're helping them? Because you and I would both agree, we want those folks to vote the way they choose.
But they have, in the oath, they've already said they're not influencing them. So what's going on here?
Well, this is an existing statute that we have, but it's also a portion of that. It's specifically targeted towards ensuring that we identify folks that are being paid. They're making money off of this in some fashion, or compensation. I mean, dial that back. I don't mean just to say money. Compensation.
Why is it so, it's so funny. Everybody talks about it, doing well for yourself and getting out there and making money. And that always seems like a good thing in this building, but apparently not.
Yes, I understand.
So is the problem that someone's getting paid to make sure they get this person to actually be able to successfully get their ballot in? I mean, is that conduct that we should be afraid of that conduct? That
we
someone
use the term
should get a vote cast for their candidate of choice?
So we use the term economic benefit as defined by the penal code. That's the revision here. Yes, sir.
So let me go back. Hold on. Actually, this new law, though, here on line 24. We're removing the mens rea requirement. Is that true?
Oh, now help me locate where you are.
32, line 24.
I'm sorry, I'm on 33. Okay.
Don't get ahead of me.
It removes the phrase with knowledge that accepting compensation for such activity is illegal.
So current law is that it's a crime if someone accepts compensation that they know is illegal, but this bill would make it a crime regardless of whether they know it's illegal or not.
I believe that your conclusion is accurate.
So that is your intent, to remove the mens rea requirement in this provision.
Yes, the intent is to delete the line that I just spoke of, yes.
And so compensation, I know we're tying it to the definition of the penal code, is providing someone who's doing this work a bottle of water. Would that be considered compensation?
The economic benefit is the definition that we've identified in the penal code, and it specifically states means anything reasonably regarded as an economic gain or advantage, including accepting or offering to accept employment for a fee, accepting or offering to accept a fee, entering into a fee contract, or accepting or agreeing to accept money or anything of value. I think in the context of your bottle of water example, that would not be an economic benefit.
That's not your intent here. Okay, as it pertains to this section, and actually let me lump in because I forgot to do it for section 6.03. Well, let me do them in that order. For 6.03, have you or a member of your office done any research as to how this change in the law would impact voters of color?
No, as I explained to you earlier, that my answers to your questions earlier applied to in the entirety of HB 3. Haven't done formal or informal studies.
So we've covered 6.02, 6.03, 6.04, and 6.05. And so the answers you gave me regarding 6.02, when we went through whether you've done it government entity, private, or whether you think that's something
that would apply to all the other sections.
Okay, so going forward, then I'm just going to ask if these sets of questions that we asked on 6.02 apply to this particular section. You're saying that for 602, 603, 604, 605, that's the case, right?
That is correct, yes, sir.
Okay, sorry, I just want to be clear.
And I encourage you to be clear.
Let's go to 6.06. Actually, in case of that, for that particular provision, the set of questions I asked you on 6.02, are your answers the same for 6.06?
It applies to the entire Article 6. How's that?
Don't be too efficient.
No, just yes, it applies to the entirety of Article 6. Yes, sir.
Thank you. Okay, well, in that case, let's move on to sections, or Article 7. 7.04 of the bill. This is where we...
You don't want to talk about section 7.02?
No.
Okay.
.04 is the creation of a restriction around what is being called here vote harvesting. Is that correct?
Yes, that is correct. And it actually has a defined term for vote harvesting services and for benefit.
And can you describe for the committee the real world situation this responds to, where a Texas vote was cast in a way that a voter did not want?
So as far as vote harvesting services, when you talk about that in concept, and I know that you'll have some testimony that'll go into probably better descriptions than I'm going to give you at this late hour, and that's just my fault, is folks who in person directly or through another party, they provide compensation to have someone engage in vote harvesting services, which means to interact in person with voter or voters and we use the term in the presence of the ballot, which is a term that actually exists in statute now, previously in this section, or during the voting process and intended to deliver votes for a specific candidate or measure. And so the concept here would be you have a person that's being compensated by a campaign or a candidate or a ballot measure, and they are interacting with a voter who happens to have a mail-in ballot in their possession or while they're trying to vote and influencing the outcome. And so I know that's a similar topic to what we've talked about in the other sections, but anytime that you have someone that's receiving compensation and may have a goal of influencing the outcome of that vote and they are with that voter, there certainly is a higher likelihood of fraud in that scenario than if that voter was voting without someone near them or without having someone engaged with them as far as doing their in-person or vote by mail.
You mentioned that in the presence of the ballot is something that's used elsewhere. We have that. That's a phrase that's typical. I want to focus on the other phrase, during the voting process. What do we mean, or what do you intend that to mean?
My understanding, and I would guess I would couch it in terms of my intent, is during the voting process could occur with a mail-in ballot or while they are at the ballot location.
We're not entertaining it.
Okay.
Okay. So in this section also, there's no mens rea regarding the ballot. So what happens if I go canvassing, like I'm prone to do, like everybody up here on the dais, and it turns out the person has their mail ballot inside their house with them?
And now, can I go back? You said mens rea, and I just want to make sure I'm looking at the right spots, because on page 36, I know there's some knowingly provisions. I want to make sure I'm syncing up with where you are.
Well, so you go to the definition of vote harvesting. Right?
Yes, sir. So at the bottom of page 35.
In-person interaction with one or more voters. So going to my example, you're having interaction in person with someone at their door, right?
Yes, sir.
In the presence. So I would say that the voting, would that capture the voting process? Like they have their ballot with them, they're within the voting time. I'm door knocking. Their ballot happens to be in their home. Is that part of the voting? Like, let's stop there and then we'll move to the rest of the language in a second. Are we within the voting process there? So I'm in-person interaction, talking to the voter. They've got their ballot.
They got their mail-in ballot.
Their mail-in ballot at their home. I didn't have anything to do with supplying it to them, because that's going to be curbed as well. But so now I'm talking to them about it, and I'm certainly door knocking, so I'm asking for them to vote for a specific candidate. That's me. Is it the intent of this section to create a criminal sanction for that
conduct.
No, it is not the intent to create a criminal sanction for that conduct that you have described in your example, which I would paraphrase as a candidate knocks on the door of a voter's home and the voter has in their presence a mail-in ballot.
And what? That's not your intent by this part of the section. So what, can you point me to the verbiage in this section that would lead you to the conclusion that is not covered or could not be covered in a potential prosecution under this section?
So
As a former prosecutor, I know people can get creative.
Yep. As a former prosecutor, I feel the heat that's coming. I understand. You're doing a great job of asking your questions. But if I flip over to the top of page 36, you asked me to review this section. So B explains that an offense is committed if the person, directly or through a third party, so in this scenario, it's the person, knowingly provides or offers to provide vote harvesting services. That's been defined in exchange for compensation. Well, that's not occurring at the door of the voter's home. Under C, it has an offense can be committed if the person, so again, directly through a third party, knowingly provides or offers to provide compensation to another person in exchange for vote harvesting services. That's not occurring at the door of the voter's home. D, an offense occurs or is committed if the person knowingly collects or possesses a mail ballot or official carrier envelope in connection with vote harvesting services as a candidate at the door of the voter's home. That's also not happening. And so you will also see under E, this section does not apply to interactions that don't occur in the presence of the ballot, that are not conducted in person, or an activity that is not designed to deliver votes for or against a specific candidate or measure. I don't see anywhere in here that a scenario where a candidate that knocks on the door of a voter and the voter happens to have the presence of their mail-in ballot where this would apply as far as vote harvesting services. I think it has to have that component of someone involved for compensation and or they're actually trying to collect it and take it. So.
Okay, so what about let's use the example of a facially neutral GOTV effort that's driven by data expected to engage favorable voters. The tools we use to target and talk to people are pretty sophisticated. You can be facially neutral in those efforts, but you're certainly engaging voters you think are going to be favorable to X. Is that something you intend to be a felony?
Not under this provision, no, sir. I do not see any efforts to get out the vote or related political activity that would ever fall under Section 7.04 on pages 35 and 36.
Couldn't you envision with me, though, a scenario in which, and I don't, I mean, I know that, at least in my time working in campaigns, the targeting tools have gotten much more sophisticated, and you certainly can work very hard at moving to a population that you say, if I get this person to vote, I know they're going to support candidate X or ballot proposition Y. And I know that, and the effort knows that, and so then they engage in this process, but they do it in a facially neutral way. So when you talk, that's the kind of scenario I think about where if there's an ambiguity, so if you don't specifically exclude it here, then that's where I think you can have an overzealous prosecution of someone because they don't want that particular candidate or that particular ballot proposition, and so they're going to say that this was even though facially neutral, that it was targeted enough to trip the wire of vote harvesting.
And I certainly don't interpret it that way.
Okay.
I understand that your example, you worry about an ambiguity there, but I don't interpret it that way.
So would there be any harm in specifically carving out conduct like that, so that if it's not the intent, and that's good, and that's what I'm hearing, it's not the intent to capture that activity, is there any harm in it specifically excluding it?
Speaker Moody, I've always worked with you on many different pieces of legislation, and I have no hesitation in continuing to discuss that concept with you.
And I appreciate that, and that is a fact, and I appreciate your willingness to always work on stuff together. Move forward. Let's go to page 37.
Yes, sir.
About distributing applications of vote by mail. What is the purpose of this provision? And I think we're on, what is it, 276.016?
276.016, yes, sir.
And we have a criminal sanction in this section, a new one, a state jail felony, correct?
That is correct.
Okay. What's the purpose of this section besides making it harder for people to vote?
So I disagree that that's making it harder for people to vote. I want to go back and look at ballot by mail. And so if you heard me explain earlier, I would describe it this way: is the current framework that we use for ballot by mail is a passive system, in that it is available, but the voter has to request by application to vote by mail. It's not proactive, in which we send them the application. It's passive. It's a passive system, and that's how we've operated. I have used that before, especially as a college student, being able to vote back home, for example. You know, it was on me to call my clerk's office and request my application, and they mailed it to me, and I had to complete it and send it back and then get my ballot by mail. The intent here is to clarify that the state of Texas is not a proactive system where we send out all those applications. That's the purpose, and I think that was demonstrated in one or more jurisdictions last year where that was experienced, and I think there was litigation that was tied to that. And at the end of the day, election officials should not provide early voting ballot applications to persons who didn't request the application.
Do you think do you think it is good public policy to be passive when it comes to individuals living with disabilities? People that could vote by mail?
Well, they're eligible. So you and I would both agree, right, that they're eligible to fall in the category. So it's late, so I don't want to mislead. So yes, they fall in the category of being able to do it. I would agree that, you know, it's good policy if they were able to put some methodology in place where they can say, I consistently always want to receive an application to vote by mail. But a blanket sending it all out to all the registered voters locally and say, hey, voters, determine if you're eligible or not, that's not what the law foresees right now. And that's not what the courts have interpreted the law to do right now.
And you piqued my interest in what you just said.
Yes, sir.
Not that you haven't throughout this conversation, I'll be clear. Because I really do think that's a population that we should not have a passive environment for. Shouldn't add the layer of forcing them to secure the accommodations they need to vote. And so there's nothing in here that would address that in the current state of this bill, right?
No, I would say there is nothing that handles that. This bill retains the current interpretation of code, which is a voter must request an application. And a clerk or other elected official, or other public official, can't proactively just go blanket the registered voters of the county with applications. And that's the intent that you see behind this section.
Well, so that vote by mail in, I don't want to call it in perpetuity, but you mentioned something, the concept. I know you're not throwing something out there to write down right now.
No, and I understand. I know where you're going with it, and I want to interject with something, but I want you to finish. Yeah.
No, because I mean, I think this is one of those things when you talk about a passive system, you know, the catch-22 is real obvious. you know, this is the population that needs help, and we're saying there's a, you know, there's a passive system, so we're going to make you be proactive about exercising your right to vote. So current system, and I'm not saying that's, again, this is the current system, and we're doubling down on the current system of a passive system and creating a crime if you do that, if you disrupt the current system that's passive. I guess my point is, why would we not react in a way that said we're not okay with denying help to those who may need it to get the vote by mail?
So
Why isn't that part of our reaction as well?
Let me give you an observation of why it is a passive system, I think, in part. And part of that reason would simply be that, you know, circumstances may change for those that qualify to vote by mail. And we put the onus or the burden on that individual because for a specific election, they may be out of the county and unavailable to vote. But the next cycle, they'll be present to vote. And so if you were to be proactive about that, you run the risk of all of a sudden they have a ballot in their hand and they're going to try to show up at the polls. You never know. Mm-hmm. Now, what you're doing is you're identifying folks who may constantly qualify. So I think the easiest example for you would be the age bracket over 65. Is that where you're thinking?
Age or disability, I mean.
Yes, sir. And so in that scenario, is there a mechanism that they could put in place where they say, I shouldn't have to request an application for each election? Is that what you're going with?
We have that. We have made a change in somewhat recently. We made a change where if you requested it at the beginning of the cycle, then it kind of persists through the cycle, but you still have to do it every election. Is that kind of election?
That sounds accurate. I don't want to speak to that and be incorrect.
I'm going to let John Busey correct me if I'm wrong.
There you go. Woke him up.
I know he knows more about it. Now, I know that we didn't. You used to have to ask for those vote by mail deals every single time.
Yes, sir.
And now I think we've at least extended the courtesy. If you ask for it in March, you're going to get it in November. I think that's the case. Is that right? I'll stand corrected if I'm not. I guess what's raised here is, could we do more for a population that I think everyone agrees we should probably do more for? And why is it that our reaction in a situation that happened in one county in Texas is to not just reinforce that the passive system exists, but criminalize the conduct?
Only for the person that initiated the effort, not for anyone else. Just to clarify for the committee.
Well, why not create some sort of sanctioning regime less than criminal then? Because we're talking about public officials that are doing this, right?
Yes.
Is there, you got to go to a certain amount of training, or let's send you to, you shouldn't have done that. Let's,
Removal from office?
Sure. Better than being a felon, probably.
That's also removal from office, I think, under some scenarios.
Down the road. Well, if you're convicted.
That's right.
Accusations aren't convictions. We talked about that earlier today. So I guess the point I'll leave here is our reaction to this situation has been to create a crime for that individual, which means, by definition, by doubling down on the passive nature of our system. Our answer is we don't want to change the passive nature of our system, even though there may be a population out there that deserves something better. So our answer is not to figure out how to extend a helping hand to those folks, but to slap the hand of the person that tried to help them.
And if that is a question, my response would be, at the same time you had a jurisdiction or a couple of jurisdictions try to be proactive and interpret the law differently than what it says, and that we lost the ability to have uniform and consistent framework across the state and other counties. So I think the goal here is to have that consistency, and that's where some of your voter confidence also comes into play.
Got it. This section, I'll ask the same questions I did on 6.02 and say, do your answers that 6.02 apply to this?
And my answers would say for all of Article 7, that my answers would be the same.
Thank you, sir.
Yes,
I
sir.
appreciate that. The bill here says that everything is cumulative and redundant, and that if something is an offense in one place, it can be prosecuted each different way at once. So in other words, someone who makes a mistake here is not just looking at a felony, but multiple felonies. And so that's throughout these articles, we have that language where you can be prosecuted under one or both, right? That's true.
I do believe that what you describe are multiple provisions that someone, depending on the conduct involved, might be prosecuted under, but it has to do with the conduct.
Would you agree or disagree that that's going to create a chilling effect?
I would disagree that it's going to create a chilling effect for the process of voting. I would assert, however, that its intent, which is to ensure uniformity and consistency in the application of the election code and ensure that voters feel confident in the outcome of elections, I think that that is supported by that language.
Okay, let me go to page 38, line 17.
Line 17.
Section 276.018.
Dealing with perjury? Yes, sir.
So as with so many other parts of the bill, the perjury offense here has no mens rea. Is that correct?
And by mens rea, you mean knowingly?
Well, in our penal code, perjury is always required that the person know they're making a false statement and that they intended to deceive.
Yes, sir.
And so here we don't have that same standard that we carry in the penal code for perjury, correct?
And I would acknowledge that it does not contain language that states with intent to deceive and with knowledge of the statement's meaning. Explain to me your distinction that you're arriving at.
Well, I mean, we have perjury in the penal code that carries with it certain verbiage, and that is not here when you're talking about perjury in connection with certain election procedures. So we've removed the mens rea. So don't you think it's something that we should fix so it doesn't conflict with perjury law as we've always understood it, and so that it's not a trap for innocent people, that they have to have some intent to do something nefarious?
I'm happy to visit with you upon the conclusion of our hearing about that topic.
All right, I'm gonna make note of that. All right, and in the last part here, line 38, line 22, section 276.019, this prohibits public officials from creating an election standard, practice, or procedure in a way not expressly authorized by the election code. Is that accurate?
That is an accurate reading of that section, yes, sir.
Wouldn't you say that that's going to prevent them from doing the basic work of running an election?
No, because the rest of the statement that you didn't read says any election standard, practice, or procedure mandated by law or rule in a manner not expressly authorized by this code.
But let's say if they tell people which entrance to use in a building hosting a polling place. This is an example. That's not expressly authorized anywhere. So does that jeopardize all the votes at that polling place?
Would you consider that to be an election standard, practice, or procedure? That's where I'm going to, and I don't mean to be...
the intent? I'm just saying it can be interpreted that way.
I don't mean to be flippant. I'm just pointing out that you're going to have some decisions that are made that simply are basic and core and simply ensuring that the wheels are turning, whereas other decisions derive directly from the election code or procedures and processes have been put in place by the Texas Secretary of State, which the legislature has delegated that authority to them. And in that scenario, I think that's what this speaks to when you're talking about modifying those standard practice or procedure mandated by law.
And so
I don't think we mandate which entrance they go into.
And I get, so that's not your intent, but I think it's ambiguous. I get not wanting to contradict state law, but there is a lot that state law is silent on. Wouldn't you agree?
I would not agree, I would not say a lot. I would just say that, yes, there are instances
There are
where
things
state
that it's
law.
silent on, even in the highly regulated area of exercising the right to vote. There are things that the law is silent on.
I would agree that our law is silent on certain topics.
So then wouldn't it follow that this would have the unintended consequence of preventing anything that's not expressly provided for in this way? And I don't know what those are. We're going to have election administrators come up, I assume.
I think you're going to
assume.
have a lot of other input from other folks, and so I guess I would at this defer to the
And
comments
I'm
that you're
happy
going
to.
to
I'm
receive.
throwing it out there, and so feel free, I'll throw that out there too for those who are in this. Because I don't know. I don't do this for a living, but I'd like to know what's not expressly provided for under these provisions that, you know, let's not be ambiguous if we're going to dive into this. Let's actually get to the core of it. Because if you're going to tie the hands of administrators that do this work and keep them from functioning because there's no express authorization, I don't think that's your intent to do that. I don't think it's your intent to do that, but I think it can happen based on the way this is written. So I'll stop with this set of questions. Do you have? So I'm going to ask very specific. Everything that we've talked about, sections we've discussed in my line of questioning. My questions are a bit different here, rather than just what I asked in 6.02. The question would be, do you or any member of your staff have any research as to how these changes cumulatively would impact voters of color?
The answer would be no.
Okay. And are you aware of any?
And I'm not aware of any research, or I haven't requested research.
Cumulatively of these provisions?
That is correct.
Do you think it's important that we have that information before we change these laws?
As always, and I've told anyone, my door is always open, and I'm happy to learn, visit, discuss, and educate regarding any information that's out there. I think it's always important to consider all information, but I haven't requested nor have I received any of that type of information.
Understood.
And so I don't make any assumptions or presumptions because of that absence.
And I wouldn't ask you to. So thank you. I appreciate the answers and your time. Thank you, Mr. Chairman.
You're welcome. The chair recognizes Representative Longoria.
Thank you, Chairman Ashby. Chairman Murr.
Yes, sir.
And I'm going to go over Article 8, which is the enforcement
Yes, sir.
provision, page 38. Now, you're on there?
Got it.
All
Yes,
right.
sir.
Now, before I start, maybe you can answer some of this. What is this section trying to accomplish, this enforceability provision?
So essentially, we're trying to make sure that there is a priority given to election cases, and I think that inherently, as candidates for office, those that have touched upon campaigns, et cetera, we would all appreciate the fact that if you seek remedy in court, you would want the court to address that promptly, because the experience has always been that there is a sense of urgency if it surrounds an election process. And so that in and of itself says that priority should be given to election cases, and the trial courts and the appellate courts that are considering relief in those should give them priority.
Now,
That's it in a nutshell.
is there I guess, a time frame on priority, or is it indefinite once it's filed? I mean, what is the specifics on it?
Part of it, if you look on 39, when we talk about priority of certain election proceedings, we actually reference it pending or filed in the court on or after the 70th day before a general or special election. So, especially if it was filed prior to the election, there's a timeline there, and we could all acknowledge that priority should be given, because once the election occurs, then the relief may not be available.
So 70 days before the general or the primary, so it would be somewhere between like late summer to early fall?
Yeah, I mean, to characterize it, it's a month and 10 days.
Okay.
So yes, sir.
Do you
for that particular provision? For others here, especially like an appeals process, they might occur immediately after, and so there's not a timeline for that, but there's still priority that is intended.
Now, I understand that, election cases, priority, but are you concerned that maybe it's going to take a big portion of the court's time?
I am not concerned. I have a lot of faith in our judicial system, and we have all watched and experienced it rise above in the challenges of 2020 in a pandemic situation where courts were delayed or put onto a Zoom world. But I'm not worried that it's going to cause serious problems. In addition to that, I would point to section B1 on page 41 that says that if there is a death penalty case, that still maintains priority. And so I don't think that you're going to have a prevalence, and I don't know that past experience over the last few decades shows that there's a prevalence of high volume of election cases.
Currently, is there a standard where the election cases fall in order of priority as the way the statute currently stands?
So as I understand it, and I will defer if there is an expert in the room, so we'll speak to the either, as the speaker said, I think that they just are any other civil matter.
Okay.
Now, that being said, someone's seeking injunctive relief. There are timelines for that, and so they'll probably be treated as any other injunction or temporary restraining order or that may be filed and pending. So those timelines that apply would apply in those scenarios as well.
Now, has there been any complaints or concerns that you're aware of or that you've seen reports on, priority being important on these cases?
So I would assume that anybody who is a party to a matter would tell you that, there's a sense of urgency in the relief that they're seeking. I'm not aware, and I'm not going to point to a specific example. I don't think that's a condition precedent that we should consider in order to give them priority.
Now, so if we change a priority, where is it going to fall on the court's priority list? You mentioned death penalty. Is there another, where does it fall?
It's going to be at the top, I assume. But remember, we're not talking a high volume in my experience and understanding of what I read about cases out there. You're not talking about tens of thousands of cases.
Okay. Now, I guess my understanding, it would be like death penalty or any type of cases that would infringe on someone's constitutional rights. It'd be like 1, death penalty, 2, constitutional, and then I guess 3, it would be election cases.
Well, and arguably, election cases may involve constitutional rights.
Okay. But where does that put the other cases, like a domestic violence case?
They are probably just in the regular mix of things. And I don't know if you mean civil or criminal, but typically a priority is given to criminal cases over civil cases in our courts of mixed jurisdiction. Then in larger jurisdictions where you have specialized courts, well, those courts are only going to hear family. And so it's probably not going to go to the family court, or it's going to go criminal courts are probably not going to hear a civil matter.
Okay, but you had mentioned death penalty. So if it's a non-death penalty case, would that take precedence if someone's incarcerated, or if it's family violence? Would that supersede the election cases, or do the election cases fall under death penalty?
Death penalty, then election cases, yes.
Okay. Okay, so all of those other cases would fall
I think they all fall into their own category, yes, sir.
Okay. Now, do we have anything in place right now just in case, and it may happen, probably will happen, not a question of if, it's when, frivolous lawsuits?
Regarding the elections?
Yes.
I'm not advised of that, and so I would assume that simply the existing codes that we have in the civil procedure codes that we use for those, they apply. Okay. Unless a smart person in the room comes up and provides additional testimony.
Have you looked at possibly adding an addition where if someone filed a frivolous lawsuit and there's grounds for it, and the facts and law shows that maybe being able to recover attorney fees for the other party? Because I can see where, elections are inherently contentious, right? So, someone thinks something's not going right, files the election contest or claiming some type of fraud, and the next thing you know, someone's caught up in litigation, and several thousands of dollars, hundreds of thousands of dollars later, they end up finding out that it was frivolous. And you mentioned, the same parameters may be available for civil cases as they exist now, but would you be willing to maybe look at putting some more stringent or direct remedies or recourse for frivolous litigation?
You know, I haven't explored that specific topic and haven't researched that line of reasoning. I'm certainly open to looking into that. I think as state policy goes, you know, we certainly owe it to discourage frivolous lawsuits, and that's why we do have some of those measures in place right now for all topics. So, yes, sir, and I'm happy to visit with you more about that topic if we want to research it together.
Now, there's a specific section, section 23.302, concerning the recusal process.
Okay, do you have a page for me on that? I'm sorry.
I'm going through it. It's 43. Page 43.
Okay.
Okay, where it says, my understanding is if a judge tries to recuse himself, they may have to make a ruling before they're able to recuse themselves.
Okay, and I'm looking, I guess, beginning at line 6, who wishes to be recused from the proceeding must, before recusal, hear an application, grant or deny it, and set a scheduling order. And I believe, you know, as you mentioned, election lawsuits typically are highly charged. You know, there's some party who feels aggrieved or wronged or is seeking a remedy. Sometimes the courts are slow to respond, and so I think that's an incentive to say, please take care of the initial relief that's requested before you seek to recuse. Because there can be delays that occur with the recusal process.
And I completely understand that, but you could technically have a judge that has a conflict, right? Inherent conflict, let's just say.
Father, son.
Exactly.
Okay,
you know,
I hear you.
Brother, brother.
Yeah.
Brother, sister, sister, brother, right? They file emergency protective order, temporary order, and you force the judge to make a ruling even though they intend to recuse themselves. I just think, I mean, if the judge feels that, hey, I'm going to probably have to recuse myself because there being a conflict, I mean, is there any way to possibly fix that? Because I think that's just going to...
I certainly see your point. Your point's well made, and so I would certainly reach out and work with you if you have some suggested language to address that. I don't think that would certainly be the intent here, and we would never want to put either the party that filed the lawsuit or the judges on the bench in that predicament.
Okay. Now, I guess going back to the priority, right? How would you feel with, you know, domestic violence cases or certain cases, you know, against someone's person, involving children, having higher priority over an election case?
Well, and so let's pick that apart just a little bit. So I'm from a rural area, and so I have a single district judge, and that single district judge hears all cases, civil, criminal, family, everything. And so he may hold a docket that has criminal cases one afternoon and then have a civil docket the next morning, but it all goes to a single court. Conversely, in urban areas where you have a higher population of caseload, then you will have courts that are specialized. And so your district courts will have family, even probate, criminal, and civil. And so inherently, if you're seeking civil remedies, they're not going to go to a criminal court when you have multiple courts. So the only scenario that you're going to experience that with, in my mind's eye at this moment, would be in a rural area.
Mm-hmm.
And typically that judge has a multi-county district and probably juggles all of it all the time anyway. So to ask your question, if you try to prioritize that, what I think you'll find is that for larger jurisdictions, it won't ever have any effect. It only has effect in your rural areas where you really don't have any more access to the courts because you only have that one judge.
And I understand that completely, especially like in rural Texas. Now, is there a mechanism maybe you can put in place, you know, upon the petitioner saying, hey, this is an important matter. It involves, you know, a child, you know, custody issue, you know, family violence, being able to petition the court saying, okay, I understand I fall below the priority of an election case. However, I think you need to make this a top priority, and if not, maybe kicking it off to an adjacent jurisdiction or something. I mean, has any of that ever been looked at?
I haven't had any experiences where that would be an actual concern. I think that just generically speaking, someone who requests remedies, say a temporary restraining order, that goes into that process for whatever fact pattern you can dream up. They have access to the courts, and I think that an election case would be treated similarly to that, not to disenfranchise other pending cases. I just don't think that's going to be an experience that would be had. That's my personal opinion.
Would you be willing to maybe look at something, putting there in the bill, allowing the opportunity, if it became an issue, to be able to opt out, either, bring it up before the court or opt to another court? And I'm just saying because we don't know what's going to happen, but I can anticipate a situation where you'll have a judge in rural Texas get bogged down with an election case. He or she may do that, and then there's something that just pops up out of nowhere that needs to require attention, and it may just fall below that priority.
I'm happy to have that dialogue with you. Okay. I do think as a civil matter, inherently criminal matters typically take precedent. And so if I'm looking at a distinction there, it's going to be criminal matters, especially someone who happens to be in custody or incarceration. That takes precedence over all civil matters. And so I think that's what we currently experience. And so when we talk about it being a priority, it's probably going to be a priority above the criminal matters. A better way maybe to approach it would just be putting in a timeline or a sense of urgency for the court. So maybe you and I could dialogue about that.
And I guess maybe making the distinction, because, one being death penalty cases and then two constitutional infringements, right? So I guess if someone is incarcerated, it'd be technically a constitutional infringement, right?
Well, we just lump it together that has to do with a criminal case. And okay. I wouldn't want to make anything unwieldy so that the courts don't easily interpret that, because what happens is we put something in the code and they might forget it's there for a while, and I would hate for that to happen. So instead, if we try to make a change, I think it does need to be simplistic in its viewpoint, so that way it's easily applied. But yes.
Do you think this section will have any infringement on access to being able to vote?
No, I do not interpret it in that way.
You see it having a negative impact on voters?
No.
What about negatively affecting, minority Black and brown voters?
I do not. In fact, conversely, if someone's seeking relief through the courts, the sooner that they have a chance to come before the court and have a ruling on the relief, it actually would be better and further those in many situations, especially if it had to do with the topics you just mentioned.
All right. Well, thank you. Appreciate it.
Yes, sir.
Chair recognizes Representative Landgraf.
Thank you, Mr. Chairman, and feel free to, Chairman Murr, to have a sip of water while I'm asking this question.
Excellent. Excellent. Sounds like a long question.
It won't be. Just wanted to be clear on these particular provisions. The only matters that would be prioritized are those for temporary injunctive relief. Is that correct?
Yes, in which there's an urgency, and I would just characterize it in my own way as very time sensitive because of an election, which is based on a date or specific time. And so that is the urgency in and of itself.
When you served as county judge in Kimball County, did you ever have any proceedings before your court where the relief sought was a temporary injunction?
Luckily, I was able to boot that all to the district court, but understanding where you're going with that, it was my experience that the court was never too busy to handle those when they came up in a timely fashion.
And in the way that different court proceedings are characterized, is an action for a temporary injunction typically brief compared to, say, a long, drawn-out jury trial?
No, it's typically brief and occurs, if I'm not mistaken, within 14 days.
Right.
So that's how we found that. It all has to do with just getting it set, but the court already has to operate under that. Similarly with a TRO, a temporary restraining order, help me here, I think it's 3 days or 7 days, something like that. Right. But that process works quickly, and presumably if that's the type of relief that's sought in an election case, that framework's already going to apply. But I think we go one step further when perhaps it's not just a temporary injunction, but it's other decisions about interpretation of the election code or determination of facts. We want those to be decided quickly too, because that affects candidates, voters, the officials involved in the matter.
So just for the benefit of us on the committee, these types of actions would be short and sweet as these things go. Is that safe to say that not only will that relief be granted in a very expedited manner, but it's not going to really clog up the judicial system for that particular.
I would agree with that. I think that this is not going to be something that's characterized as like a month-long jury trial in a complicated civil matter or something similar to that.
I just want to be clear. I didn't think that those unintended consequences would occur, but just wanted to be sure that that we had that set straight. So thank you.
I appreciate that.
Thank you,
Yes,
Mr.
sir.
Chairman.
Members, right now, the only person I have with a remaining question for Representative Murr is Representative Niave. So if there's someone else, please let me know.
Thank you, Mr. Chairman. And my questions go back to a section that ties into Section 9, which somebody else will be asking you about.
Okay.
But it's in Section 2, page 4, Section 2.03, specifically regarding the notice of unlawful voting,
Yes.
which was Section 15.028 of the Election Code.
Yes.
And you are adding in notice of unlawful voting. Now you're adding in or registration, correct?
Yes, and just to clarify, since it's a late hour, the additional language, so right now, the notice of unlawful voting exists in current statute, and that notice is provided from the registrar to the county or DA.
Right.
This adds in registration, so if the registrar determines that they're not eligible to vote, either not eligible to vote or registered to vote, then they would have that same reporting requirement for notice purposes only.
Right, and so that's what I want to
Yes.
talk about as we get into that Section 9. So first, can you tell us why you're adding in, before you didn't have, it wasn't in the statute, but why are we adding in now those who are not eligible to vote, that register to vote? Why are now we referring them not just to the local county DAs? Well, let's start there and then we'll
Okay,
get to the AG.
I think you've got two parts here.
We do
So
have two- we
I'm
do
going to
have-
try to answer your first part the way I think you're going. And so you're asking, why are we including this registration component?
Right.
Well, and if I understand correctly, and I would look to the experts that will come up later to clarify that if a person who is not eligible to vote registers to vote, that might be a violation of law. If I understand correctly, that's a
It might be
violation.
or it is.
I believe it's a violation of law.
What violation of law?
And I would have to go look that up. That's why I'm deferring at the moment to a smart person that has expertise in that area.
Do you think it would be a violation of the penal code?
I would need to research which violation that is, and I'm
How
sorry.
about section 15.0, actually 13.007 of the penal code, of the Texas Election Code is the closest thing I could find to what
Okay.
it could potentially relate to, which deals with a false statement on a registration application. Do you know what level of criminal, what offense it is, what level of offense?
No, but I believe you're fixing to tell me.
I am.
Okay.
So it's a Class B misdemeanor. So
Okay.
before, the unlawful voting is a second-degree felony, and we've heard about, we'll talk about that in a minute, but we're adding in now this Class B misdemeanor, false statement on a registration.
Which I guess to point out, you've identified currently exists in the statute.
What I believe, but you're the author of the bill, so I would think that you would tell me, but this is what I'm
Yes, ma'am.
guessing, I'm not the author of the bill. So assuming that it's this section, so we're adding in a Class B misdemeanor if a person knowingly makes a false statement. So you're requiring the registrars to determine whether somebody knowingly made a false statement on their application for registration?
If the registrar determines that a person who is not eligible to vote registered to vote or voted.
Right. So are you requiring the registrar to now determine?
They are
intent?
determining.
So
That is correct.
So they're determining the intent of somebody who possibly unlawfully registered to vote and referring that to the DA's office right away,
They're
right?
making a determination that they're not eligible to vote and that they either registered to vote or voted.
Okay, so but in order for them to determine, okay, let's go to the first part of that, which is the eligibility to vote. What are the requirements to be eligible to vote?
Well, we'll go look up that in the statute. You'll have to give me a few minutes because I don't have that at my fingertips.
I'll just save you some time. Section 13.001.
Okay, well, I'm on 002 right now. I just hadn't.
Go to 13.001 of the Texas Election Code, and it goes through the items. You've got to be 18 years of age, a U.S. citizen.
Yes, ma'am.
Not determined by a final judgment of a court to be totally mentally or partially incapacitated. And then, it gets into convictions of felons and individuals who are eligible or not eligible to be able to vote, and gets into this list of who can register to vote. And you would agree that subsection 4 of section 13.001 of the Elections Code is a little confusing. It's not really clear what it means, which ex-felons, individuals who are formally, trying to use a proper term here, individuals who can now register to vote, correct?
I wouldn't agree that it's a confusing existing statute. So you're talking about A, 4, big A?
Both big A and big B.
Okay.
Explain to me then what that means if it's not confusing.
All right, this is what current law states. So to be eligible to register to vote, must not have been finally convicted of a felony, or if so convicted, must have fully discharged the person's sentence, including any term of incarceration, parole, or supervision, or completed a period of probation ordered by any court, or have been pardoned or otherwise released from the resulting disability to vote, and be a resident of the county in which the application for registration is made.
So you're saying that's easy to determine and
I did not say it
interpret?
was easy. I don't think it's, you mentioned,
You don't
you
think it's-
described it as confusing, and I said,
You
I don't
think
think it's confusing.
You don't think what you just read is confusing?
I understand it.
To lay persons who are not attorneys to be able to determine what that means?
Well, I think that you could always make that assumption for a lot of the laws that the legislature promulgates, but
And this is really important, Mr. Chairman, because we're looking at now a whole new class of people who are going to be referred for prosecution because they may have interpreted or not interpreted their eligibility to be able to register to vote, are now going to be subject to Class B misdemeanor, which is punishable by
180 days in county jail and up to a $2,000 fine. Yes, ma'am.
Exactly. And so don't you think that that is concerning for a lot of people?
No, I think that they do need to be familiar with their rights. I think that's important.
Okay, do you have any concerns about the class of, the group of people that this might disproportionately impact?
Do I have concerns? No, I don't have concerns, but I do think it's incumbent upon every person. When we talk about our laws, they say lack of knowledge is not necessarily an excuse. And so it is important to be proactive and take steps to educate yourself on what you can and can't do.
Okay.
And I know that you're speaking to Article 9 of the bill, and that talks about that.
And it'll get to that
Yes.
because that deals with something similar, but this is sort of transitioning to that. Somebody else will deal with that. But specifically when it comes to this new group of individuals that are going to be referred to prosecution, have you done any racial impact study or any research to determine the disproportionate impact of this section 2.03 of your legislation?
No, ma'am, I have not.
Okay, don't you think that that would be important to do?
I think all information is important to consider. And you're asking me, do I need to do that? Is that a condition precedent in order to even consider legislation? I'm happy to consider all information, but
You haven't to this point.
I have not considered that information, no, ma'am.
And you also haven't analyzed the, how this will potentially impact hundreds of thousands of people in Texas who majority are Latinos and African Americans in our state.
Now, we're not talking about the existing eligibility for registration. You're talking solely about the fact that the registrar will report someone who's not eligible to vote has registered to vote. Is that what you're speaking to?
And the impact of who can determine whether they are eligible to
The
register
registrar.
to vote. And we discussed in another bill this morning at length about mass incarceration and the disproportionate numbers of Latinos and African Americans in our jails and in our prison system in general. And so individuals who are felons, unfortunately, because of that long history in our state, are going to be disproportionately impacted, Latinos and African Americans, by this section of the bill. And have you considered that?
So here's what I'm going to explain is that the registrar makes this determination of the eligibility to register to vote and to vote already. That's already being done by the registrar. The notice provision that we're talking about requires, so it's a shall, requires the registrar to deliver notice to the DA or the county attorney if someone votes and they are not eligible to vote.
Right.
Okay? But
To make that determination, though, Mr. Chairman, it's not easy even for the registrar to make that determination.
well, if you'll let me finish, I want to get to my point. They also make a determination of someone who's registered to vote, if they're qualified to register to vote. They already make that determination right now. And if they make a determination that someone is not registered to vote, there is nothing that prohibits them from reporting that. That would be, that is something that they can choose to do. And I do not know the prevalence, and you can ask any other witnesses if they do that, if that comes across as paperwork that they have reviewed and they're not in compliance. This simply changes it from permissive to shall or mandatory. So my point is, voter registrars already make this determination now because we require them to, but it's permissive on whether or not they report it. And this changes it to, hey, somebody did that, you shall report it.
And do you know what they do if they determine that somebody is ineligible to vote? What's their normal practice?
I would defer to Secretary of State resource to clarify that.
Do you think they typically warn individuals that, hey, you
I am
registered
not
to vote, but
advised.
you're
I
not
really don't know the
eligible?
answer to that question.
Okay, I'll give you some information that I found, and then we can have others testify to this. But according to an August 3rd, 2004, which is the most recent available memo that we were able to find on the Texas Secretary of State's website. This is a memo to all voter registrars in the state of Texas regarding the effect of a felony conviction on voter registration. And this memo specifically states that it is our official advice not to immediately cancel a voter whom we have identified as a possible convicted felon. DPS has cautioned us that felons are frequently convicted under false names. In addition to that, it says that to investigate a registration, you must send the voter written notice of the investigation and warn the voter that his or her registration may be canceled if he or she does not respond within 30 days. So the registrars, the advice that was given to them is that they're giving the voter person who's trying to register an opportunity to cure or address this. But here, your statute is now requiring them to immediately be reported for potential prosecution versus giving them this 30-day window. And that's why this is concerning. This memo also gets to, they recently learned that some counties were retaining weekly data, and then they were challenging applications. They were advising against challenging those applications. They said it's not expressly authorized by code. They said second, due to and this is contrary to what you were stating, essentially, that second, due to the many variables involved in sentencing, it's possible that a finally convicted felon may complete his punishment and be released from all disabilities in a very short amount of time. They're advising not to challenge new ones because they're not easy. The requirements for voting are often confused, and candidacy are often confused. So my point is, Mr. Chairman, that this particular section, you're now, again, referring a class of people, you're requiring the registrar to make a determination, you're subjecting people to potential class prosecution for a Class B misdemeanor. So that's part one of the section. You said there's two parts.
So the language for them to be subjected to a Class B misdemeanor already also exists. This is only dealing with notice. And then just to point out, and I hold you in high regard, but I know that you said you could only find a document that's 17 years old. I have no idea if it's being followed or not, and I would love to hear testimony
And I would love
that explains
to hear
that.
from the Secretary of State, because it's from their,
Sure.
but that's what, we could be wrong, but this is the most recent that we were able to
understand.
file with
Yes,
respect to felony convictions. But the second part, can you tell us why? So was there some problem with, right now we had the county and district attorneys getting notice, and now was there some problem, like, are they not prosecuting, or what is the problem that we're seeking to solve by adding the Attorney General and the Secretary of State?
So what you'll find, and I know that they'll have witnesses, and you can ask them this question as well, is that both those entities are also involved in this process. The Attorney General's office does have some expertise in that area that may or may not exist at the county or district attorney level, depending on your jurisdiction. And so you will find that that notice lets them know that they may be offering assistance or answering questions about it. As far as the Secretary of State goes, I know that a lot of data is gathered and collected by the Secretary of State, and this in and of itself is data that they likely would want to collect. And I believe that policy would be that we would want to collect that. We would want to know if this is something that happens rarely or frequently or not, and we don't know that.
Does it happen? Do you have any data regarding
I do not
this
have
if we're
any
adding
data.
it?
No,
So you
ma'am.
don't know how many prosecutions but you're just we're not going to send potentially hundreds of thousands of people for prosecution.
I don't know that you have hundreds of thousands of people that are not eligible to vote that are registering to vote. I don't know the answer to that.
There are hundreds of thousands of people that could potentially mistakenly register to vote when they're not eligible, or that could register to vote and are, just don't understand this. But I mean, that's separate. Okay, so you don't know how many prosecutions for this crime that we're now adding to referral for prosecution?
I do not know, and I will go back and say this is already a crime under current law. This is just makes the notice mandatory instead of permissive. So registrars could be doing this. They could be sending this notice already. There's nothing to hold that back. This just makes it so they don't have to make that decision.
Are you aware of any recent examples of people being prosecuted for unlawful registration?
Not off the top of my head.
Unlawful voting, 2 recent examples?
Not off the top of my head.
Crystal Mason and Harvest Rogers?
I believe that I have
Does that ring a
visited
bell?
with Mr. Busey about that topic previously.
Thank you. Pass.
Next, Chair recognizes Representative Landgraf.
Thank you, Mr. Chairman. Chairman Murr, just to make sure that we're not getting this twisted, on Section 203, that provision applies only to voter registrars, is that correct?
That is correct. Voter
It doesn't
registrars
apply to
only.
voters or potential voters or those attempting to register to vote. This is a provision that applies to a government official in his or her official capacity, is that?
That is correct, and that voter registrar already determines, they make the determination if someone is eligible to vote or is eligible to register to vote.
And then if I'm looking, in reading this, the first word in that provision after the heading is if. If the registrar determines, then it sets out what the procedure should be if the registrar makes that determination. Is that correct?
That is correct.
So it's not even requiring the registrar to make a determination. It's simply saying that if that happens, then this is the procedure that the registrar follows.
It also simplifies the process for the registrar. If you'll look, lines 17 through 19 are struck. Now, previously, it would require the registrar to make a determination that if the territory for the DA is more than one county, then they have to send it to the Attorney General. And so they had to make this determination of who do I send it to. Well, this change simply says, well, you don't have to figure out who to send it to. You send it to your local prosecutor, the Attorney General, and the Secretary of State. So that way they don't have to stop and figure out what to do next.
So the local prosecutor still
always will receive notice. Okay. That is correct.
And then by also requiring under these circumstances that information, that data be delivered also to 2 statewide or state agencies, the Attorney General's office, Secretary of State's office. To me, that's interesting. I think it is helpful. It basically creates a clearinghouse for this type of information. It's been suggested to you several times in the several hours that you've been sitting at that table by some of our colleagues on the panel, and I think it's a very noble suggestion. that we look at the disparate impact that this could have, or just have that data. Is there any way that we can have data like this unless it's going to a central clearinghouse instead of to potentially 254 different prosecutors' offices across the state or more?
No, I think you make a valid point, and I would think that obviously many people have asked about data, and data is always beneficial in making decisions. And so in this circumstance, yes, I mean, Chairwoman Niave asked me specifically if I knew how many of these cases existed. I don't know. And so having that data would be very helpful to know if it was rare or frequent. So.
Okay, thank you.
Yes.
Next, the chair recognizes Representative Busey.
Thank you, Mr. Chairman. Chairman, I want to turn to Article 9.
Yes, sir.
Page 44, Section 901.
Just a second to flip over page 44.
Yes. Lines 10 through 17. This, we've talked about this a lot.
Yes, sir.
The case of Crystal Mason. I think this whole hearing, especially you think about Bill earlier, we're trying to figure out how to make sure that accidents, not knowing, does not result in a crime. Crystal Mason's on the verge of being thrown in jail for 5 years for making an accident. And I think what we're doing here is good. This first part that I'm highlighting here is lines 10 through 17. It's being more specific to someone who loses their right to vote after a felony, that they have lost that right to vote. Right now, they get a packet, and this is saying specifically that you must instruct the defendant regarding how the felony conviction will impact the defendant's right to vote in this state. So it's, we want to add language here that's very clear if that right has been impacted. What I think we are lacking in this section is notification when the right has been regained. And I think that would be helpful. And I have a bill for that this session. I have an amendment.
Well, and just to be clear, so Chairwoman Niave had me open up to a specific section of the code. And for our purposes of our dialogue, when we talk about it and you're specific about the felony, and if they've been so convicted, they must have been discharged from their sentence. And so that's lumped into a category that includes incarceration, parole, or supervision, or completed a period of probation ordered by a court. So I think there are, and I'm just trying to, as a practitioner in that area, I would point out that there are some unknowns at that point. So for example, if someone is serving a sentence, frequently we will hear that they are paroled out. Now that would be occurring sooner than the end of the sentence. So I'm just going to randomly make up a number. Let's say their sentence is for 10 years, and they get paroled out after serving 4, and then they have a period of time that they're on parole. That may be different than that original 10 years. And so it actually requires some education with new facts at a later point in time in order to tell them. And so my practical point, and I know there are other people that know more than I do about it, but I don't know that there's always a way to tell a person at the time of sentencing or a determination that they've been convicted of a felony, to tell them when that may be lifted and they'll be eligible to vote. It's my point. And part of that's state law. We've made it that way, but there's also some facts there. If they're out on parole or they're on probation, but let's say, for example, they are permitted to seek early termination of probation, I don't know if that might impact the length of time in which they wait. And so it is a little bit of a challenge for them. And so there's some moving parts there.
I guess what I'm getting at is when someone is off paper, when someone's gone through the process, they regain their right to vote. What I want in this bill is a notification to that individual by the state that they have regained their right to vote, that they have regained the franchise, letting them know that they're back. And this, I think, will help, one, not only with your intent to promote voter access, to make sure these individuals that have regained their right know that they have regained their right. I think we have a system that we can figure out how to give them that notification. What I'm trying to seek here is a mandate that we do such things.
So in the language that they're focusing on, and I know it's late, so I want to go back to it because otherwise I get distracted. We're looking at page 44, lines 16 and 17, where they instruct the defendant regarding how the felony conviction will impact the defendant's right to vote in the state. And I guess your discussion is you want to go further and explain.
I want the bookend. So this is when they lose their right, they're getting instructed very clearly that they have lost their right. I want another system years later when they regain their right. I want the state, us, to notify them to meet one of your goals to promote voter access for these individuals.
And how would you best propose that notification occur?
Well, I think we can work with people to do it. We can work with Secretary of State's office to figure out how to do that. I think I would defer to some of my colleagues here who have worked in the criminal justice area. TCDJ, do they maintain a list? I would assume we maintain who's been paroled when their time is up, that we have a list of this, and I want to make sure that we are doing everything we can as a state to help Texans who have a right to vote that have lost that right know that they have that right retained, and I don't think we've done a good job there. And I think also if we're trying to avoid mistakes and issues that would lead to people voting that aren't eligible, this is a way to have these bookends for people that lose that right, which is very few people lose that right. We want to make sure those that do and then regain it are aware of it.
And I applaud you for the desire to do that. I think it's important to have that knowledge. But what I'm getting at is so many cases are so individualized. To make that determination, that's going to be tough to do and do it accurately.
So you're saying there's no system in the state?
I didn't say there was no system. I'm just saying it's easy to do at the beginning of your bookend, but I can see it being a little bit more challenging to get it correct because it's going to require data points depending on whether they are incarcerated and paroled or whether they're on probation or have been pardoned or otherwise released from the resulting disability to vote, which would be perhaps in a court case. I don't know the answer to that. And so there's some different systems and moving parts that could be challenging.
Okay.
So maybe what you may be talking about is additional information at the front bookend of here's how that might work. I don't know.
You know, we're talking about many years sometimes between these bookends.
Yes, we are.
So I think it's important if we really want to do our part and do what's hard and make sure that individuals have this knowledge. I think we could do a better job as a state. I think probably the people on this dais, we could figure out a solution to this if there was the will to come up with this and find an amendment that would help us get to the goal, the end goal, which is notify these individuals when they've regained their right to vote and participate.
I just know that it's going to be a challenge to come with consistency of what you're talking about.
But you're committed to going down that challenge with me.
And I will always dialogue with you on that topic. At the beginning, though, on the first bookend, if there are improvements to make, just so that they are made as aware as possible of what the rights are and how to restore those rights and when that might occur, I'm all ears because I think education of that process is very important. And I wouldn't disagree with you on that.
Okay, I appreciate it. Section 10, Article 10, .01, page 46, lines 4 through 5.
Yes, sir, lines 4 and 5.
Code, the following provisions of the election code are repealed. 1, section 85.062E, and 2, section 86.0105B. Can you just make sure we all know what you're repealing here?
Yes, and I was actually prepared for that. Chairwoman Niave caught me without having my book open, but I have my book open for these. So section 85.062E deals with temporary branch polling places and movable structures. And section 86.0105B addresses penalty for illegal compensation for assisting voters. And so on the last section, since we have modified the penalty that's available for that, it would be 2 penalties running at once, so that's why that's removed. And as far as the temporary branch polling places, this speaks in small part to the movable structures. And I know we've in the past had a big discussion about tents and movable structures when it related to, we'll call it universal curbside voting, or everybody gets to go vote from their car. And so instead we've focused on asking them to go to a building, which we talked about. And so that's what that relates to.
Appreciate it.
Yes, sir.
Representative White. Okay, he'll pass for now. Representative Johnson.
Thank you. I think part of the frustration is, over the last few months, we've talked about criminal responsibility. And for example, you could walk into a Starbucks with a long gun strapped on your back where it has a sign that says you can't come in here with a gun. And it's only Class C unless somebody goes up to you and says, I'm sorry, you have a gun on in here and we don't want guns, and give them an opportunity to correct their error and walk out. When it's probably more open and obvious that you've got a long gun on your back, then it might be that you 25 years ago got convicted for something and your parole date's just a few days away. And so I think the concern is, why are we not affording the same opportunity to cure what may be a more honest mistake than what is physically apparent in the other? And so I think that's part of the frustration. I agree with you that it's hard to send out a notice to say, hey, you guys are off parole, or your probation terminated earlier, or you got a pardon. I do understand the complexities around that. But my question would be, if people are registering, why would they send them, why one can't they say, hey, sir, you made a mistake, you're not eligible, right? Or does the registrar make mistakes and register people that they should be able to check and verify and say, you're not eligible under the code?
Okay, and to try to best answer your question, first, I don't know that there's a prohibition against the registrar saying, hey, wait, I think you don't qualify, you're not eligible at this time.
Okay.
And maybe you will have testimony that speaks to that. So I can imagine that, given the friendliness of Texans, that may very well occur. I don't know. The second part, I know that all processes are human, and I would recognize that, and that's part of the challenges of even the election code, is that sometimes mistakes or errors can occasionally happen, and I would assume that registrar is not impervious to that as well. That being said, your point is, it seems very unfair for someone if many years ago they were told of what the prohibitions make them eligible and not eligible, and they're not necessarily instructed, as Mr. Busey would like, when that change will revert back. And all I pointed out, and you and I would both agree, parole is a different mechanism than probation and pardon and all those things. And so we may think of one timeline, but it could be shortened or lengthened, especially if there was an extension of parole or probation that occurs. And so it's really going to be difficult to keep up with that. I'm happy to front load that knowledge to them up front. But if it's a long period of time, I don't know how we deliver that correctly, because we then would have errors in that system as well, so that at the end of the duration, they have good knowledge of what to do. Maybe that's something that needs to be in front of the registrar before they even accept a registration. I don't quite know that, and that's a good question to ask some of your resource witnesses, how we could better patrol that to make sure that, hey, have you been on parole or probation, and are you still on it? And if so, here's the duration. Maybe there's a mechanism in there that we just don't realize could be the easy way to deliver that information, because it's occurring when they're either voting or when they're registering to vote.
Could we have this code section track the same kind of language that we have in carrying weapons, that it's a Class C, you're given the opportunity to cure. If you don't cure it, then it's a Class A misdemeanor.
That's an interesting concept, and I would want to ponder that a little bit more and perhaps visit with you about that.
Sounds great.
Okay.
Thank you.
Okay, members, I don't see any other hot mics right now. Representative Meza has been very patient. Thank you, Terry. But as the rules we've been operating under today is all committee members certainly want to make sure we have all of our questions and comments addressed before I recognize her. Nobody's, okay. Terry, and just so you know, I don't know if you heard earlier today, I've said this several times, but we're limiting non-committee members to 5 minutes on questions of witnesses. So with that, you're recognized. And thank you for being here.
Thank you, Chair, for the privilege to speak. And for Chairman Murr and for the members of the committee, I want to have an opportunity to explain where I'm coming from on election reform. You might remember during the regular session that we had buttons that said protect the vote. And one of your colleagues smiled at me and said, well, that's what we want to do too. So I thought about it, I said, well, yeah, you're right. Both of us feel like that what we're doing is we're trying to protect the vote. We're just coming at it from different perspectives. My perspective in protecting the vote is protecting the vote for the people who have a right to vote, and their right to vote is being denied. In my district, House District 105, which is Irving and Grand Prairie, we had voter intimidation too, kind of like what Dean Thompson talked about, except hers happened inside the polling place. In my race, it happened out on the parking lot. We actually had operatives of the opposing candidate who was running people's license plates and then telling them, I know where you live. Gerardo, they told Gerardo, says, does Maria know you stole her car? And he says, what are you talking about? Maria's my mom. Tactics like that. So we actually had to have the sheriff's department come out to stop that kind of voter intimidation happening right out there on the parking lot in front of the polling place. We have examples of referrals to other polls that are not the right polling place. So, for example, an African man, and I say African meaning because he's a U.S. citizen but born in Africa, went to his polling place and was told that was not it. He needed to go somewhere else. He went to place B. They said, well, this is not your polling place. And he said, well, I was told to come here. Well, we don't want to give you a run around, so let's look up where your polling place is. Guess what? It was place A. He goes back to place A. He's still denied his vote. He was only given a provisional ballot. How many voters go 3 times? That's a lot of persistence. Some people give up after 1 time. Maybe they have to go to work. Maybe they have to go pick up their children. They only have that 1 chance to vote. Some people are given provisional ballots when it's not their polling place, when there is time for them to go to the right polling place and vote, and not really realizing that casting that provisional ballot basically means that their vote doesn't count. They think they're voting, and they don't realize that their vote may very well not be counted. In the race in 2016, we came within 64 votes. So there were over 300 provisional ballots, which is an extremely high number, so it was a red flag. So we asked for the list of provisional voters. And at that time, all that we got was a first name and a last name from each polling place. So we're looking at this list to call people and say, we know that you had to cast a provisional ballot, we just don't know why. Can you tell us why so we can help you cure it? Well, I got, these are real names, Maria Rodriguez. I had dozens of Maria Rodriguez's in my district. So which Maria was the one who tried to vote at detective work, vote at this polling place? Juan Hernandez, another real name. I had dozens of Juan Hernandez's. Which Juan was the one who tried to vote at that polling place? We called people. We actually went to doors and knocked on doors and let people know that the race was close enough that their vote could make a difference. Could they tell us why they were made to vote a provisional ballot? The most interesting story I can share with you is a lady in Grand Prairie that when my team knocked on her door, she said that she was so glad that someone had come and asked her that question. She said, no es justo, pero no sé qué puedo hacer. It's not fair, but I didn't know what to do about it. I'm so glad I've got somebody to tell. She said, my husband went to vote first thing in the morning. He went on to work. A couple hours later, I get ready and I go down to the polling place. I have all my identification. And they say that I can't vote. And I asked them why. And they told her, are you ready for this? Your husband cast your ballot. What? We have voter ID. He's a man, I'm a woman, we don't look alike, or it's not like he's Patrick and I'm Patricia. What's the deal, you know? They still made her vote a provisional ballot, and the reason they gave her was because her husband had cast her vote. She was willing to get into the car with these 2 people that just knocked on her door and take her from Grand Prairie over into Dallas so that she could fill out an affidavit to get her vote to count. But how many people can do that? And what an effort that was made to try to help people who were made to vote a provisional ballot to help try to cure their ballot. So this is the kind of thing that we run into in our districts, in my district in Irving and Grand Prairie. So my concern is more about when I think of protecting the vote and when I think about election integrity, when I think about election reform, is to protect the right to vote for my constituents who are being denied their right to vote. So thank you for listening to me. Thank you.
Thank you, Representative Meza. Representative Murr, we're going to reserve your right to close, and we're going to move into invited testimony. Members, we have 4 panels. The chair calls our first panel, which is going to be Heather Hawthorne with the Texas County and District Clerks Association of Texas, and Chris Davis with the Texas Association of Elections Administrators. Heather, we're going to start with you. We show you registered as Heather Hawthorne with the County and District Clerks Association of Texas, and you're registering neutral on the bill. Is that correct?
That is correct.
Please.
So, first of all, I'd like to say thank you for inviting us to testify on this bill. We think that this bill has come a long way since January of this year. We are the stakeholders. Our name's on the door. We are the ones that conduct the elections. We are elected like you are, so we want to believe that there is a lot of integrity involved. Was pointed out earlier that Representative Clardy represent a rural district that is growing quickly because I am from Chambers County, Texas, and that would be right next to the Kingdom of Harris on I-10. I'm here to point out some concerns that I have as an elections administrator myself, and to represent the over 100 county clerks around the state that also conduct elections. I want everybody in this room, I want everybody that's watching, I want the nation to know and feel confident about elections in Texas. So with that, I will entertain any questions you have.
Thank you, Ms. Hawthorne. Members, any questions? Yes, Representative Clardy.
Thank you, Mr. Chairman, and Clerk Hawthorne, thank you for being here with us today. I listened to many of the questions that our bill author, Mr. Murr, who I just ran out of the room, took, but it seemed to me that one of the questions and one of the considerations everybody should think about, we talk about elections. I think the people on this dais want people who are registered and eligible to vote, not only to be able to vote, but actually to go vote. The one thing I cannot explain with elections, this is true on all sides of the political parties, it's not the people who show up to vote, it's the 1/3 of people who register to vote who choose not to vote. That one is a problem I think we all should be trying to solve. But we look at it from the voter standpoint, but one group that gets left out of the mix are the people like you who actually are in the trenches, the elections professionals who run the elections, and then those people, that team that you have to pull together to make sure that you can adequately man and staff an election so that the voters, or the rest of us that vote, have a good, fair, that we walk away from that experience feeling like, I feel good about how my election was run, that when I voted it mattered, that I was treated respectfully as a citizen, that we could do those things. And so a lot of the questions I think that our bill author, Representative Murr, took of why are we doing it this way, why limit hours here, why do these things, could you explain to us a little bit the importance of making sure we take care of the people that are actually doing the work, that have to show up an hour or two early to get ready or stay an hour or two late to get ready for the next day or to move equipment? How does that factor into how we run elections in Texas?
Great question. So obviously our poll workers are made up of a member of each political party, or the judge and the assistant judge. They are paid what I would call a pittance. You know, you can make more money at Buc-ee's than you can working an election, but that's okay. That they are trained, that especially our early voting workers that work 2 weekends, because we have a judge over that particular voting location, so we don't like to change them in and out. They're not really interchangeable during that process. That we have to be fair to them, that if they are there at 5 o'clock in the morning, now that we say the elections can run from 6 until 9 p.m., you know, that's the given hour for 9 hours, then we have to be fair to those people as well. Why? Because we want them to be on point. We want them not to make mistakes. And here we sit at what hour of the night it is, and we're tired, and we're human, and we need to go to bed so we can make better decisions tomorrow. And so we want these people who I believe have a lot of integrity as well, who are proud of their precinct, that some of them have worked in that precinct for years and don't even want to give it up. That these people are treated with respect as well, these presiding judges and alternate judges, that they have the opportunity to have some rest as well. So it's not a bad thing. Let me tell you what about living in Chambers County is I have Houston on one side and Beaumont on the other, and the Houston News reports that polls are open 24 hours. And in Chambers County, I got people calling, asking me where they can go vote for 24 hours because we don't have Chambers County News. We have Harris County News. And so, you know, some kind of consistency, that's not going to be a bad thing.
I think uniformity is the word.
Uniformity, okay. And, you know, same with on the east side of me is Jefferson County, and they have a different set of news. So,
And by the way, let me ask you this, Ms. Hawthorne. I think what happens is you prepare for an election. You know how many voting locations you have, how many people you need where. You're doing the logistics of, you're trying to manage manpower, get them there. And I think this is true throughout the state. You work very closely with the chairman of both the Republican and the Democratic Party to get people to those locations. Is that right?
that is correct.
This isn't, you know, and I know you're an elected official. I think we're going to hear from Chris in a moment, who's an elections administrator who answers to elected officials. But, you know, you may run under a particular banner as a Republican or Democrat as an elected county clerk in the state of Texas. But when it comes to doing your job, there's probably nobody that works more in a more bipartisan manner than our clerks and elections officials in the state. Would you agree with that?
I thank you for saying that, yes.
And so what you do is you try to find people. And one thing I'm concerned about with several of the bills we've taken up and some of the things that the ideas come out of the Senate is some of the criminalization of people who work, whether it's the elected or appointed elections administrator or the people working underneath them. And I do have a real concern because we cannot have good elections if we don't have good people to greet you as the voter when you show up in the polls. Are you concerned at all about any kind of chilling effect that this hyper-criminalization of people working elections might have?
Absolutely.
Can you explain that a little bit?
Okay, so yes, we have both parties working, and you know, most of the time we all get along because we want the same outcome, a safe and honest election. But yes, when I'm getting ready for this constitutional amendment, and the first ballots for that go out in 69 days, by the way, yeah, it's very concerning for me to try to get an election judge who has always had that precinct, who are there and doing honest work, and now all of a sudden they're going to be criminalized if they make a mistake. I'm a former school teacher, and I believe in that warning system before I have to head you off to the principal's office. And so, yeah, it's very scary. And I know it's really scary in the urban areas where it's just harder and harder to attract. Even though Representative Johnson said you got more to choose from and you can, you know, do longer hours, et cetera, I want you to know that it's harder and harder to find election judges these days. And the more we put on them, the more they're going to shy away from that job, no doubt. I would like to also, if we can take a minute and go to the poll watcher training. Poll watchers are so vital to the process, but there are so many instances around the state. Everybody's got a story. I love your story of feeling intimidated by somebody standing behind you. I get that way in the grocery store. I mean, I don't want anybody in my space. And so the idea of having maybe a 6-foot, you know, line, well, we've all practiced social distancing now for over a year. And so the poll watchers are so vital, but we have to train them. A lot of times they are handed a piece of paper the night before any of us run for office and say, hey, can you go watch precinct 13 for me? Of course they will. They're honored that you even thought about asking them. But they come in and they have no clues whatsoever about what their duties are. And it's innocent. I mean, they're not intentionally being, 90% of the time, they're not intentionally being disruptive, or they don't know. That's the bottom line. They don't know. And so one of my suggestions, or our suggestions on the poll watcher's oath, is that we add language. And of course, you know, I'm a former school teacher, so I believe in education, but that they have to read at least the poll watcher's guide that's currently on the Secretary of State's website. You know, that doesn't involve them having to drive to training or whatever. Get that candidate to help them out by printing off that poll worker book and saying, here's the watcher's guide. Will you go work at whatever precinct? Here's your certificate. And then they sign that oath that says, I have read it, I understand my duties, I understand my responsibilities, and I swear I will not disrupt the voting process or harass voters in the discharge of my duties. I don't think that's hard to ask.
Kind of makes sense. Well, one last question, if I could, Ms. T, just one last, I promise you this is it for me, of this witness. So a lot of people have been trying to figure out, kind of pull out, what is the intent behind this bill? I think one of the things that has been lost is you don't just run an election every 4 years in November. That you work within Chambers County with a number, I don't know how many school districts you have, or how many SUDs, special utility districts, or municipal utility districts, or hospital districts, or city councils, or commission. You know, you have one set of commissioners, I know that. But you have elections frequently, both primaries, but then other in May for some nonpartisan elections, and again in November, this time a constitutional race, sometimes it's statewide, sometimes it's federal-wide. All of these are very important elections that matter a whole lot to the people who are running for office, but also really can determine how much people are taxed, the responsibility, what contracts are led, how tax dollars are spent. All elections are important. It's just, unfortunately, it seems to me the national narrative has condensed it down to where people only want to think about the presidential election on November every 4 years. And we've got a broader scope in our responsibility as a legislature than you have as a clerk running elections. Do you think that has been lost in some of the conversations and the rhetoric about trying to have election reform and legislation to make our elections better and more secure?
I believe that the pandemic brought a lot of things to light, but I believe that there is nothing wrong with doing whatever it takes so that every single voter in Texas feels good about walking into that poll and secure and walk out. And I believe that 95% of the voters, that's all they want. They want to walk in, cast their ballot, get an I voted sticker, because that is the number one important job of voting, is you get the sticker for your selfie. But yes, I believe that making legislation that works and that is practical and that it's not asking counties or EAs, county clerks or EAs, or the county government itself to spend millions of dollars to make something happen in this state that we don't have. So yes, I believe that every election is important. We prepare the same way for every election. We might have to have some more I voted stickers in certain elections than others, but as far as the processes that take place, it's the same every election.
Okay. Thank you.
You're welcome. Vice Chair Thompson.
Oh, I want to thank you for your service. Let me tell you what I like to do. I like to have my constituents feel the freedom when they're in their polling places to be able to vote without intimidation. And I know your track record, which is good, and I want to commend you for your outstanding record and the work you do.
Thank you.
But there are some people who come to my polling place of another ethnicity and who assume the position of superiority that when God gave out intelligence, he didn't have enough for the rest of us to have any. And then they want to treat us as though we're some kind of subhuman beings. It is that kind of intimidation and resentment that I don't care for being in my district. I know that there have been people in our society have weaponized certain kind of languages and attitudes among people. But if we're going to be Texans and Americans, then we must look beyond the color and look upon the fact that we are Americans and we are Texans and we are all bleed blood red when we get cut, and we have the same constitutional rights. I don't want my constituents to feel like that they are being privileged to vote. They have a constitutional right to vote. And my people have fought in this country for that privilege. We are not going to go back to counting beans in a bag. And we are not going to count the bubbles in a bar of soap. And when those persons comes to my district to be poll watchers, we want to welcome them and we want to treat them with dignity and respect. And we expect the same reciprocation from them. That is what I'm talking about on poll watchers. When they come, sometimes you give persons who are just wonderful people a little bit of authority. And that little bit of authority make them feel like that they can rise above other persons and trample upon their rights. So that is the reason why that I have been concerned about training of poll watchers, not to make them feel like that they don't have the intelligence, know how to act or carry out orders or things of that nature, but to be able to give the respect that they want from others. That's what I'm talking about. And just to say that I give you a piece of paper and give you an oath of office and tell you what your duties are, how are they to determine what the irregularities are? It takes experience, it takes training for people to be aware when you're in a precinct environment and this is what I want you to look for. That is an irregularity or that. But I don't need them peering over my shoulders trying to see how I'm voting, and I don't need them be standing close enough for me to hear what I'm saying, because I think those are infringement upon other rights that I have as a person. Those are the things that I'm talking about, to make the system work and to work effectively, not just for you, but for me too. Thank you.
Thank you.
Thank you, Vice Chair Thompson. Members, any further questions for Ms. Hawthorne? Heather, thank you for being here.
Absolutely. I passed out did everybody get that?
I think
great,
we
great.
do.
So there was just some other concerns on there, and that way we'll save a little time if you don't have questions on those.
We've got it right here.
Good.
Great. And thank you for your service.
Thanks.
Chris, we show you registered as Chris Davis on behalf of the Texas Association of Elections Administrators, and you have registered neutral on the bill. Is that correct?
That's correct, Mr. Chairman. Thank you.
Please proceed.
Thank you, sir. Thank you, Mr. Chairman. Thank you, committee members. Thank you, Chairman Murr, for your authorship of this bill. What a difference a session makes, what a difference a committee makes. Already, we feel good. I know the county clerks and district clerks feel good. The Texas Association of Election Administrators feel good. And yes, we're appointed, as Representative Clardy said, not politicians, not here to discuss politics. We're here to discuss process. And we appreciate this bill and the changes that we've seen from this bill and its predecessor, where in its predecessor, there were some issues we had with some of the objectives and how it affected process. Now we're saying, yes, we share some of these objectives. And how about this as it affects our processes? For instance, and Heather talked about this a bit, 4.03, the poll watchers oath. We'd love to discuss, and we are encouraged with Chairman Murr's openness to discuss poll watcher training, the poll watcher oath, perhaps even have that oath include eligibility, where they swear they're eligible to be a poll watcher. In other words, they're from that county, they live in that same district of which that election consists of. I think that would go a long way and give that poll watcher ownership in their duties, because it is a very important responsibility and a very important duty into the integrity and transparency of an election. We love Chairman Murr's openness in his discussion with Chairwoman Thompson in training and the possibility to discuss training. I don't think the Secretary of State has to reinvent the wheel to implement training for poll watchers. We already have poll worker training, and the code makes poll worker training open to the public. Anyone sitting here could attend our poll worker training if they'd like to. Why can't a poll watcher? Maybe we can make a poll watcher attend the training. So they know what is irregular, like Chairwoman Thompson said. To them, without training, there are no regularities. It's all new. And quite frankly, not only are they doing a service to the voter and the poll workers, they're doing a disservice to their appointer if they don't know what they're looking for. Being the eyes and the ears and observing that process at a polling place. So training is quite important. And we encourage that ongoing dialogue about how to include training for poll watchers. 502, 505, and 510 of the bill, Representative Busey mentioned this, and it deals with now requiring a driver's license number or a social security number on your application for ballot by mail, and also the carrier envelope when a mail voter sends it back. And Representative Busey brought up a good point that while there may not be a whole lot of folks that have neither right now on their voter registration application, they're legacy voters when it wasn't required to include one or the other. We're seeing a lot of counties, and Heather was really proactive in asking the counties days before this hearing of how many counties have voters that have one and not the other. And those numbers are quite high, 10%, 20%. Spoiler alert, and Keith, sorry if I steal your thunder when you come up here. The number statewide, he told us, is 1.9 million voters have one, a DL number, and not the SS4, or SS4, not the DL number. And why that's important is there's a 50% chance of that voter guessing wrong when they apply for their ballot. I challenge any of you on the committee to remember, do you remember what you registered for when you filled out your voter registration application? If you put DL or the SS4 or both? I certainly don't, and I'm in the business of this. Voters could guess wrong. And we'd like to propose a potential remedy of whatever they put on their application, whether they put their DL number or they put their SS4 on their application for ballot by mail, can that perhaps retroactively update their voter registration application? If we're going to make this thing dependent, and if we're going to make DL numbers or social security numbers now pretty much make obsolete signature comparison. There's sections in this bill that talk about curing and signature verification and signature comparison. With this, and if I'm considering the bill as a whole and it passes as a whole, signature comparison is almost a thing of the past now. We're comparing DL numbers, or we're comparing social security numbers. And if they don't match, we're rejecting. We're not even getting to the point of looking at signatures for those that have one or the other. Maybe for the minority that have never been issued a DL and have never been issued an SS4, then we're looking at their signatures. The signatures go the way of the dinosaur if this becomes law, and okay if that becomes law, but it takes longer to compare an 8-digit number than it does squirrelies on a screen for my early voting ballot board. We'd love to see more time for an early voting ballot board to meet when we're talking about hundreds or thousands of that incremental, Speaker Moody spoke of that incremental increase in time. We'd see that in early voting ballot board if now we're comparing 8-digit driver's license by the hundreds, by the thousands, by the 10,000s in some of our largest counties.
And that goes back to page 20 is where we were.
We see in the prohibition of an application for ballot by mail, or rather the prohibition of a proactive distribution of an application for ballot by mail. I think proactive is the word Chairman Murr used, and how in this bill, that's now a state jail felony offense. Well, a couple of pages later, the prohibition on a proactive distribution of an actual ballot is a Class A misdemeanor. Those offenses seem a little asymmetric to me. I'm not sure of the logic of that. If I can hand an individual a simple form and they didn't ask for it, state jail felony, but if I send an actual ballot that you know can actually impact an election, it's a Class A misdemeanor. We've never understood the logic of that when it was in the predecessor bill, but we'd love to have that discussion of what what that means or what is, why that is. Lastly, allowing early voting ballot board members to take and keep notes. We appreciate that. If PII, as Chairman Murr said, is now going to be a thing that's going to be readily visible at an early voting ballot board, having those members of the early voting ballot board walk out with that PII is a problem. In my opinion, it is being distributed. If one worker is walking out of that meeting room and taking it home, consider it distributed. Consider it shared with that worker. And I don't think PII should be shared. Let's have it retained, and if it's publicly accessible, we can exempt driver's license numbers and SS4s from public release like we do right now when they're on our VR applications. That's essentially my kind of bullet points. Again, in the overall scheme of things, these are probably nitpicks compared to the things that are no longer in this bill and the good things that have been reintroduced in this bill, we appreciate as well. And I'll answer any questions.
Great. Thank you, Chris. Members, yes, Representative Busey.
Thank you, Mr. Chairman. Ms. Davis, just since we've been on the topic of poll watchers, can you tell us, and I hear you, you are a fan in favor of training for poll watchers, correct?
Indeed.
Have you had any issues with disruptive or unruly poll watchers in Williamson County?
Yes.
Can you elaborate on that?
I can't elaborate on that. Inevitably, it's like Heather said, they're 11th hour appointments. They're candidates that have asked, hey, can you do this? And it's their first time doing it. And it's like, you need to go in there and make sure there's nothing wrong. Well, they've got an agenda. They're looking for something wrong. And if we could tell them in training what's right, what isn't right, what's regular and irregular, it would save so much time. It would save so much time, and they're not all disruptive. The majority are not disruptive. They preserve the order. But right now, not having them training comes into conflict with the presiding judge's mandate to preserve order and maintain the peace, or maintain order and preserve the peace in a polling place. They have the powers of a district judge, our presiding judge does. And there's a bit of a concern of now, well, there may be one warning, and now we got to look into whether you're, disruptive, or we need to call law enforcement to come. And heaven forbid if law enforcement isn't well versed in the various the things that a poll watcher can or can't do. But those are some of the issues not only I've seen, but a lot of our colleagues, clerks, elected clerks or appointed EAs throughout the state.
In addition to training, are there other ways you would tweak this poll watcher stuff, maybe around the warning or anything there, or do we need more from your perspective?
Again, the oath, I think, is a step in a positive direction. And we appreciate Chairman Murr including that and carrying that forward in this bill. Having them affirm their eligibility may open them up to, they have to be eligible to be a poll watcher. And it can't just be, there's certain provisions that they must meet to be a poll watcher. That's how important we view poll watchers, because everybody else has to take an oath. Poll workers, county clerks and EAs, when we're conducting election or at central count, we want poll watchers to have that kind of ownership and responsibility too. If they're going to have that authority, they need that responsibility.
I appreciate that. Let me ask you this question. Was there anything you did in the 2020 election to keep voters or poll workers safe that you would no longer be able to do if this law went into effect?
That's a really good question. I'm not sure. There were things that the governor through executive order allowed us to do that I think were one time only for the election. I'm not sure how many of those things would carry over. We've always tried to abide by the code. We've tried to keep implementing things that we're allowed to have discretion to. I think there was discussion on, not doing things that aren't specifically outlined by rule or law. Our ballot by mail tracker was one, I think, that we had discretion on that isn't provided for in the code. But we've done it, and we hope to continue that.
Okay. Let me ask you, emergency situations. What does this bill do and not do around emergency situations? And emergency situations, we've talked about hurricanes, we've talked about pandemic, but sometimes there's a water pipe breaks in a specific site. I know we've had issues in Williams County where we had to move the election outdoors, right?
That's correct.
So talk to me about this bill and how it impacts your ability to react to situations in the moment, which sometimes has nothing to do with something grand. It's you walk in at, well, y'all get there early, 5 in the morning or something, and you see all of a sudden we have a problem.
Well, Representative Beasley, I'm optimistic, and I hope I'm reading the right signs in HB3. And with that omission of tents, and I think Chairman Murr talked about it a little bit, and that we have, maybe we can use tents when that need arises, when there's a water leak or a power outage. We don't want to divert voters to somewhere down the block. Well, let's just set up in the parking lot or somewhere on the curb or on the sidewalk, and we are able to do something temporary until the emergency situation is resolved.
So you think this bill still allows you to do that?
It's my hope, given that tents isn't necessarily in the sections that it was in CCR SB 7.
Or where they changed it to building now instead of structure?
That's right. And I think, if I heard him correctly, Chairman Murr recognized that the intent was to have county election officers still be able to avail themselves of those contingency situations.
Okay. We'll ask Secretary of State about the building and structure as well, but I think will you get back to us quickly if you find out that that's not going to give you what you need?
You'll know I will, yes, sir.
All right. Thank you, Mr. Davis. I appreciate it.
Thank you,
Mr.
sir.
Chairman.
Welcome. Yes, Representative Clardy.
Thank you, Chairman Ashby. E.A. Davis, great to see you back here today.
Thank you, sir.
You mentioned the PII. Is that the right acronym?
Yes, sir.
Okay. And it seems to me this could be straightened out, just some clarification on the language, because I'm thinking, I'm a lawyer by profession. You try cases, jurors can take notes, but they leave their notes in the jury room during the course of the trial. They don't take them home. I know one of the provisions in the bill, I think Chairman Murr talked about this, is that those notes are preserved for 22 months, okay? And I think in part that may be because if there's some legal challenge of what happened in the room, decision whether or not to count that vote, you have those records available to maintain. We got into this discussion of copies. It seems to me that this could be solved very simply, that if the originals can't be copied, they're already told. I think there's an admonition in a separate part of the statute says you can't take information you've learned and use it for your own benefit or do something else with it, much like nurses and doctors in the medical community can't take HIPAA information, which they've appropriately learned and seen and read and dealt with treating their patients. They don't share that with anybody else. So elections officials, or in this instance, those folks who are looking out on the boards and reviewing those, the PII, they have to see it. They have to look at it. They have to consider it, just like a medical professional looks at health records. But it stays there. It doesn't go anywhere else. It doesn't go home. It's not copied. Does it seem to you, does it make any sense to you that we tweak the statute or the proposed bill and we say, no, you can make notes, you can make records, but they stay with the elections office, and once they're done, then they are preserved, but they are not to be copied and certainly never to be divulged to third parties. Does that make any sense to you?
Yes, sir, it does. And that's something that would be amenable to us, and I think the voters' privacy and secrecy.
Well, if we never get the bill author to show back up in this room, I'll talk to him about it. Okay, thank you.
He's watching on the tube behind us, getting a little nutrition. He'll be out shortly. Don't worry. Okay, members, any other questions for Mr. Davis? Okay, I want to thank our first panel for being with us this evening.
Thank you, Mr. Chairman. Thank you, members. Have a good evening.
You too. Next, the chair calls Savannah Kumar with the American Civil Liberties Union and Chuck DeVore with the Texas Public Policy Foundation. Savannah, we show you registered as Savannah Kumar on behalf of the American Civil Liberties Union of Texas, and you have registered against the bill. Is that correct?
That's correct.
Please proceed.
Chair Ashby and members of the committee, thank you so much for having me. Again, my name is Savannah Kumar, and I'm an attorney testifying on behalf of the ACLU of Texas, and I'm testifying in opposition to HB 3 today. Our ability to vote, to elect representatives that reflect our values and our needs, forms the cornerstone of our democracy. Those of us who believe in the democratic process should be working as hard as we can to ensure that every eligible voter has the opportunity to cast their ballot and let their voice be heard. This legislation does the exact opposite of that. HB 3 is a voter suppression bill. Voter suppression is defined as kind of one, raising administrative barriers to make voting so cumbersome that voters get discouraged and aren't able to participate in our democratic process. And two, it's intimidating voters and others who participate in our elections with threats to their physical safety or the looming threat of criminal prosecutions and resulting incarceration. HB 3 features both of these two types of voter suppression. HB 3 will make it more dangerous and more difficult for Texans to vote, especially voters of color and individuals with disabilities. It drastically cuts down on voting by mail, limits when and where voters can vote. It makes it harder for voters to receive assistance when they're eligible to receive that assistance, and it adds vague criminal offenses to the election code. And I'd like to focus my testimony today on 3 risks to Texas voters if this bill is passed. So first, Texans who are legally entitled to vote by mail will have their ballots discarded arbitrarily under HB 3. Chapter 82 of the Election Code, which lays out eligibility for voting by mail, is designed to make voting accessible for certain vulnerable groups, mainly people who are over 65 years old and those who are sick or disabled. The Texas legislature has already acknowledged and recognized that these individuals have unique needs that would make it hard for them to vote in person. And so HB 3 undermines protections for these vulnerable voters. It adds cumbersome and unnecessary steps to the voting process that can discourage people from completing the voting process, and it increases the likelihood that their ballots will be arbitrarily tossed out. So under current law, voters fill out a robust application that includes identifying information such as their name, their address, their date of birth, and voters must certify that that information that is given in that application is true and correct, and certify that giving false information is a crime. And I actually have copies of the form here and ask that the clerk distribute them to members of the committee. I'm sure you are all already familiar with this, but I wanted to provide copies as well. The system has worked very well to deliver safe and secure elections in Texas with increased participation for vulnerable voters. And yet, HB 3 would make using this process even more difficult and would cause ballots to be thrown out for small administrative mistakes and errors. There is simply no need for these changes to a system that is already strong, our vote by mail system. And specifically, Section 5.01 and 5.06 adds a requirement that individuals voting by mail either list their 8-digit driver's license number, or if they don't have a driver's license, the last 4 digits of their social security number. And most egregiously, Section 5.05 and 5.10 require that a clerk reject a vote by mail application or a ballot as well, where the listed information doesn't match the information that's on the application for voter registration. So if a voter makes a minor mistake when entering this additional information that is now would be required under HB 3, their application would be rejected, even though they are legally eligible to vote by mail. And we just heard a little bit of testimony about this regarding if a voter put down their social security number when they were registering to vote and then later put down their driver's license number. And so this certainly would cause a problem because it would mean that they're under HB 3, their ballot could be rejected even though they're eligible to vote. But there are other problems as well. For example, you can imagine a situation in which you accidentally mix up 2 numbers when you write down your driver's license number on your vote by mail application. And you mix up those 2 numbers and you're no longer able to vote by mail and your application is rejected. And again, this is someone who's eligible to vote. Or the people who are reviewing your application mistake your handwritten number 4 for the number 9. Very possible, and that would also result in your application or your ballot itself not being counted. Again, eligible voters who would not have their ballots counted. So to make matters worse, while Section 5.09 of HB3 contains a provision which allows voters who submit mail-in ballots to correct or to cure defects in their ballots in some situations, it does not allow individuals who make mistakes when copying their driver's license number or their social security number to cure those defects. So HB3, again, it would deny Texans the ability to exercise their fundamental right to vote, including by throwing out their ballots entirely because of these administrative or clerical errors, just in the process of copying numbers from one document to another, and this is simply unacceptable. The second risk to voters under this bill is the threat of that of harassment and intimidation at the polls. So HB3 expressly gives partisan poll watchers a free pass to intimidate and harass voters. Texas has a long history of poll watchers intimidating and harassing voters, and Black people and Latino voters in particular have experienced the brunt of this. And in the 2020 election, the nonpartisan Election Protection Coalition that the ACLU of Texas is a part of received 267 reports of voter intimidation in Texas, and we've heard today other examples of voter intimidation or harassment at the polls as well. HB3 gives poll watchers a free pass to intimidate or harass voters without worrying that they're even going to be asked to leave the polling place. And I'll give you a specific. So Section 4.01 prohibits presiding election judges from removing watchers from polling places for violating the election code, the penal code, or any other provision of law relating to elections, unless they have been previously warned that their conduct violated the law and that the violation was observed by an election judge or clerk. This amounts to a one-time free pass for voter intimidation that is observed and an unlimited pass to intimidate voters outside of the watch of the election staff. Under this provision, a watcher could hurl a racial epithet at a voter and be allowed to remain at the polling place as a watcher. Under this provision, an election judge could receive a multitude of complaints from voters about being sexually harassed by a watcher, but the judge would be powerless to do anything unless the election staff had personally witnessed that themselves. A single instance of harassment or intimidation can deter people who are still waiting in line from expressing their right to vote, or exercising it rather. And rather than condemning harassment or intimidation, HB3 expressly permits it. And so the third risk to voters under this bill is that voters who are entitled to assistance under the law will not be able to access it because the bill restricts the kinds of assistance that they can receive, and it criminalizes the act of helping people vote. Individuals with disabilities and individuals who do not speak English proficiently, who in Texas are often Latino and Asian American individuals, are entitled to receive assistance with voting, including by the federal Voting Rights Act of 1965 and the American with Disabilities Act. Under current law, assistants can answer questions about things like navigating the polling place or how to operate the voting machine. And these are essential accommodations to ensure that every Texan can exercise their right to vote. So HB3 illegally limits the kind of assistance voters entitled to assistance can receive. Section 6.03 limits the type of help an assistant can provide by requiring them to affirm that their assistance was limited only to reading the ballot, marking the ballot, or directing the voter to mark the ballot. So what this means is that the assistant is no longer allowed to answer the voters' questions about the voting process more broadly, and it prevents them from providing the kind of common sense help that people actually need. So in addition, the new oath language requires voters in need of assistance to know the legal reason that they require assistance, not just the practical reason that they need that assistance. So the new language requires voters in need of assistance to tell their assistant that they need assistance, and then also to specify that they need it because of a physical disability that renders them unable to write or to see, or because of an inability to read the language of the ballot. So voters who do not or cannot, maybe because of an intellectual disability, use the exact language of the law to request assistance will either be unable to vote, or they may inadvertently be subjecting their assistants to prosecution for committing a state jail felony for violating that oath. Texas voters should not need to be lawyers, and they should not need to be legislators in order to participate in our democratic process. HB3 imposes a criminal penalty for violating the assistance oath, subjecting even those who unknowingly violate the oath to criminal prosecution for perjury and a state jail felony, again, for violating that oath. And so what this will do is that it'll deter people from offering their assistance to Texans who are in need of assistance. This is an unconscionable affront to democratic participation and the principle that every single Texan must be able to exercise their right to vote, regardless of their ability. So again, the message of HB 3 is clear. This bill will make it harder for voters to get to the polling place. It will allow people to harass voters once they're at the polling place. It will prevent eligible voters from receiving the help that they need to cast their ballots. And it will increase the likelihood that those ballots get tossed out entirely. This is voter suppression, plain and simple. It's wrong, it's unnecessary, and it's why we oppose HB 3. Thank you so much.
Thank you, Savannah. Members, any questions? Okay. Chuck, we show you registered as Chuck DeVore on behalf, on behalf of the Texas Public Policy Foundation, and you're registered for the bill. Is that correct?
Yes, Mr. Chairman.
Please proceed.
Well, first of all, I'd like to thank the representatives for their marathon session today. You're really doing the public's work, and I applaud you for it. What I'd like to do is cover three basic things in my testimony. Number one, I've handed out to the members of the committee some recent polling that the Texas Public Policy Foundation commissioned from WPA Intelligence. And what the polling shows is that while Republicans and Democrats may differ on the importance of some regulations, you see that both value election security. On the issue of poll watchers, which has been much discussed here today, 83% of voters agree that poll watchers are deemed necessary for election integrity, and this includes 93% of Republicans and 75% of Democrats agreeing with this contention. In addition, majorities of every demographic, specifically 91% of Republicans, support a policy allowing at least one representative from each campaign to be present to monitor election administration and vote counting. And I think that's very important when you think of some of the instances that we saw in the last election where duly appointed poll watchers were either removed from the premises or prevented from observing the proceedings. In addition, voters are very supportive of voter identification rules, with 80% of voters saying that it should be required for mail-in voting, including nearly 9 in 10, 89% that said ID should be required for federal and state elections. And so that obviously is one of the huge things that has been discussed today, is this issue of improving our mail-in voting system. In the last 10 years or so, we've seen a 5-fold increase in the use of mail-in ballots as a share of all ballots in Texas, topping out at about 9% of the ballot in our last election. With that huge increase, of course, I think it is incumbent upon this chamber to consider some improvement to the voter ID that is used with mail-in ballots, as it is with in-person voting, that they ought to be brought to the same level. And of course, the polling that I've provided you shows very strong support for that. One of the great things about this bill, which I think is very important, and some of it's been touched on in the testimony today, is that in the modern era, signatures are highly variable. We are not taught to use signatures like we were 40, 50 years ago. How many of us in the last week has used our index finger, for example, to scrawl just a vague approximation of our signature on some plastic screen when we use our credit card? And so that has degraded signatures significantly. But what isn't degraded are things that are constant, like your driver's license number, your state ID number, the last 4 of your social security number. And one of the wonderful things about this proposed law is that it provides the presumption that if those numbers match up, that the signature is valid. I love the direction that that's going in, because it seems to me that when you have a 3-member signature verification committee that's always 2-to-1 partisan, depending on who's running that county, you run the risk of having partisan determinations for signature validation. And what we see across the state of Texas, perhaps counterintuitively, according to an ABC News study of the 2016 and 2018 general election, is you find that down along the border, you find a greater degree of swing between rejected mail-in ballots and accepted ballots. And let me explain briefly. Texas rejects about half of the national average when it comes to mail-in ballots, according to this ABC News investigation that looked at 2018 and 19. Nationally, as I recall, a little over 0.7% are rejected due to signature mismatch. In Texas, as I recall, it's about 0.36. So we're already doing better than the nation when it comes to rejecting ballots. But in certain counties, especially in the Rio Grande Valley, what you find is you see signature rejection rates approaching up to 10 times the rate, average rate in Texas. And in other counties in the valley, you find zero rejections. And so in my research about why that might be so, what I was told was that it is part of the ballot trafficking process. That, in other words, the people who are abusing the system also have the signature verification committee as a lock, right? It's part of the local machine. And so they're just ruling 2-1 to accept or reject ballots, depending on which harvester those ballots came from. And so that was fascinating to find that information with this huge swing in the accepted or rejected mail-in ballots down along the border. Lastly, in mentioning prosecutions, and I know that you'll probably have a resource witness here from the Attorney General's office, the Texas Public Policy Foundation did a Public Information Act request asking for the the election fraud prosecutions over the last several years. And what we found was that there were 140 individuals that had been convicted from 2005 to 2020, hundreds of counts, of course. Some of that had been pled down. That there are 44 current open cases where individuals have been indicted. And of the previous years, the 140, 72 of the 140 dealt with mail-in voting. So a little over half of all the individuals convicted were convicted of mail-in ballot fraud. I think the other thing that's quite important to understand, and I'll leave the members with this, is that through most of that early period, after 2005 to about 2012, 2013, the Attorney General's office only had half of an individual working on prosecuting election fraud in the Attorney General's office, and they worked within the white-collar crime unit. They eventually went up to 1. And at that point, interestingly enough, during Hurricane Harvey, they took that individual off to deal with the wake of the hurricane, and they were dealing with price gouging cases. Eventually, within the last 2.5 years or so, because of additional resources that had been appropriated, my understanding, from the legislature, they were able to hire 3 prosecutors in a state of 30 million people. What I found, at least mathematically, is each prosecutor working in the AG's office is able to successfully bring a prosecution about every 2 months. And so if you have 3 individuals working in the office, then, that's probably going to mean that you just have maybe 18 successful prosecutions every year. That's not a lot of bandwidth in a state as big as 30 million people. Lastly, with these pending cases, there were some questions over in the other chamber about the time frame it takes to bring these cases. Most of the pending 43 cases are from the 2018 election. There's one as old as 2008, and there's only one case from 2020. And the reason why there's only one case from 2020 out of the 44 pending is that these are very complex cases that take a lot of effort and a lot of investigative work to be able to bring forward with confidence before the legal system to ask for indictments. I'm sure you'll hear a little more of this later, but I think it's important to understand that while we can be confident in our elections that there likely is not widespread and systemic fraud, there certainly is enough to overturn elections from time to time. Let me just leave the members with one last example. Last month, late last month, in fact, we see that someone was charged out of Victoria with 26 counts of vote fraud, 3 counts of illegal voting, 7 counts of unlawful voter assistance, 8 counts of returning marked ballots without consent, et cetera. And this was in a water district board election in May of 2018. And why is this important? Well, the investigation even started because 275 new voters registered using the same P.O. box. That seems a little odd, given that no one can live in a P.O. box. And the election was decided by only 12 votes. And so this was just even late last month. So when you think about fraud, you have to ask yourself, how much is too much? And I think that it's important that when we see loopholes and exploits in the existing code, that we work wherever we can to close those in a reasonable fashion. Thank you, members. I appreciate your steadfastness tonight.
Chuck, thank you for your testimony. Chair recognizes Representative Johnson.
I was just curious, you mentioned the complexities of the prosecution and investigation and why it would be delayed. I was just curious what technique or what they're doing or your understanding about the complexities that are leading you to suggest that's why you're not seeing some influx of cases currently.
I don't know as if I could suggest that there's an influx of cases. I know that in the other chamber's testimony, we heard that COVID, for example, delayed substantially throughout all of last year the ability to bring some cases to conclusion. You may want to explore that further with the resource witness from the Attorney General's office. What I do know, though, is that going over the spreadsheet that we got through our Public Information Act request, you do typically see a time delay between the cycle in which the fraud is alleged to have occurred and when an actual conviction is brought. And as I recall going through, these cases, that's typically 2 to 3 years' time. So this is a lot of legwork that is occurring to result in these convictions. And that's probably why of the 44 cases that are pending now, almost all of them are from the 2018 election cycle, and only one so far has emerged from 2020.
And where are these prosecutions pending?
They're pending pretty much all over the state.
So potentially 44 prosecutions statewide from 2018 is what you're suggesting?
It's where the preponderance of them. There's some from.
What do you mean by preponderance?
Well, okay, so we have 2000, I'm just looking at the list, 2008, 2016, 16, 16, 16, 16, 16, 16. Then we have 16, 16, 16, 18, 17, 17, 17, 17, 17. Whole page of 17, City of Edinburgh, and 17 in 2019, 18, 18, 18, 18, and then 2020, and then 4 more 2018. So, I mean, it's I would say the plurality are 2018.
Okay, I was concerned when you said that the investigations were so complex that they hadn't been filed yet. And if you've been here all day, you know that we have like 8,500 people sitting in Harris County alone on cases that are being investigated. So I wouldn't say that COVID's been a deterrent. You rattled off about 17, 17, 17, 17, 18, 18, 18. What percentage of those cases that you're citing are versus total ballots cast statewide?
That would take some effort to be able to dig into. And in addition to the fact that in many cases, these cases have been pled down. So I don't have access to that information.
I guess what would no, you do have access. It's public record. We all have access to public record, and any case filing in criminal court, it's always public record. But that's my question. If you're coming in and saying, one, I can't really tell you what the fraud is because I think that the court system's delayed because of COVID, that's not true. If you're citing those cases and saying that you have a recommendation, I think you said 140 cases over maybe 8 years?
15.
Over 15, so you have
140 convictions.
140 convictions over 15 years.
Right.
Out of an entire state of how many millions of ballots cast?
So, as you may recall from the beginning of my testimony, you had less than one full-time equivalent prosecutor working through most of that time.
At the AG's office.
Correct.
But you realize that we have hundreds of thousands of prosecutors working in every
Right.
county throughout the state.
All of these are AG prosecutions, and what you find is very rarely are there convictions brought by the local DAs. Historically speaking, this is something that has been talked about in American politics going back to the 1830s, from what I found in my research, where people were lamenting that local DAs were reluctant to bring election fraud charges because those were the people that helped them get elected. And so they were a bit conflicted.
So that would, not just a conflict, that would be an ethical conflict, right? Potentially, what you're alleging there. And so I'd like to know how often your group that is alleging that local DAs are not prosecuting this idea of voter fraud, how often have you called the Texas Rangers to file the complaint and have them do an investigation?
We're not an investigative agency, ma'am. We're a think tank.
Well, I understand you're a think tank, but you're coming up here and you're making a promise about what you're coming up here. You're providing testimony to the state of Texas, and you're throwing out these numbers about alleged voter fraud, of which you opined about why there's not prosecution. And now what I'm asking, if you're making these allegations that what you hear is local jurisdictions are not prosecuting, then I'm asking for the logical follow-up around transparency and ethics and voter confidence. Then I want to know how often you guys are calling the Texas Rangers to investigate the DAs in counties you say are not really investigating, because that's the next step.
So what I would suggest is, given that the legislature has the power of the purse, we currently have 3 prosecutors working in the Attorney General's office on this issue for a state of 30 million people. If we had 30 instead of 3, I would surmise that the number of convictions and open cases would go up probably about relative to the amount of additional staff put on the effort. What I was rather shocked about was that we had less than one full-time person working on this for about 10 years, from 2005 to somewhere around 2015.
But what's the jurisdiction of the AG?
The jurisdiction of the AG, it's the state of Texas.
Look at it. There's a reason that you have county elected district attorneys for prosecution. The AG has a very different determination of what they can do. And the idea that you're trying to turn AG Ken Paxton into somehow the cop to go after supposed voter fraud, when we've seen his cases that he has pursued outside of the state of Texas, presumably on behalf of the citizens of the state of Texas in other states, that scares me, because it's not his jurisdiction. You have elected DAs to prosecute crime, and that's why I'm saying, if you really think there's an issue with your elected DAs, you call the Texas Rangers. And so if y'all are calling the Texas Rangers, let us know. But if you're not following that logical, ethical step, it gives me great concern when you scream about the idea of voter fraud and prosecution, and you don't have numbers to back it up, and you don't have a legitimate policy that suggests that this is a legitimate complaint. So let's just follow the proper process and not allege that we need a new one. That's my only request.
Chair recognizes Representative Click.
Chuck, have y'all done any research about some of the cases that might have been filed locally or at the federal level? I mean, I'm aware of some press accounts of some cases that were prosecuted at the federal level.
No, Representative, we have not gathered federal case information.
Okay, because, you know, there have been a few that in the course of some other identity theft, they uncovered that, you know, there was voter fraud as well. And there are some prosecutors around the state, and Don't know whether there's a one place that you could, pull that data to see if there are some other local prosecutions, because I think there may be.
There have been, of course, we have a lot of counties in Texas.
Yes, we do, 254.
As you're aware, perhaps, the former, he was a two-term district attorney from Starr County, among other counties, DA Omar Escobar. He lost his primary last year. He was fairly active in this realm and had, I think, done a yeoman's job to fight what he saw as abuses of the system, and came up to this chamber numerous times over the last few years to testify about some of the abuses that he had uncovered. Unfortunately, he lost his primary and is no longer in office, which may or may not be part of the historical research that I did that found, going back as early as the 1830s, that local DAs were often reluctant to go after these individuals because that's oftentimes the individuals that kind of held their own election in the palm of their hand.
Do you think some of it may also be, I mean, those are time-intensive cases, but some of the penalties on some of those are so small that they're going after capital murder cases instead?
Right. I mean, in the case of some of the things DA Escobar did was he warned some of the individuals that had checked the disability box on the mail-in ballot. And because it was a small rural county, he knew many of these individuals personally and knew that they weren't disabled and that they weren't over the age of 65. And so they did a kind of a notification like, look, do you really want to do this? Because I don't think you meant to do this. And so what he did was kind of disrupted a ballot trafficking operation, and people ended up taking their unfilled out ballots down to the precinct, turned them in, and then voted in person. And so in that case, I don't think there were any charges. I think he just disrupted the operation for one specific election.
But you did have somebody that was at least attempting to do some enforcement.
He was.
Thank you.
Chair recognizes Representative Guerin.
Jack, thank you for being here today. You cited a number of years where there was potential voter fraud. Is that correct? And a number in multiple years. Is that correct?
Yes, sir. That's from our Public Information Act request of the Attorney General's office.
So are you saying that Republican and Democrat district attorneys chose not to prosecute those?
That's not what I meant to say.
And is that what you said?
What I said was the information we got from the Attorney General's office shows 140 convictions in that 15-year period, and that my understanding from some of the research I've done is you don't find a lot of county level effort.
And a lot of those are Republican district attorneys and Republican sheriffs. Is that true?
That would be true.
And of these cases that the Attorney General's office may or may not have prosecuted, how many convictions did they get?
140 individuals.
Of how many?
Of how many? Well, there were, let me see, there were 14 cases that were either expunged, dismissed, or grand jury no bill. And listening to the testimony in the other chamber, the AG's office recalled, I think, 2 not guilty.
Okay, but the 143, a lot of those were the same person. Is that correct?
No, sir. This is all individuals. I broke it down just to individuals that have been successly prosecuted.
So I guess what we're saying is the AG's office is going to be the one that's going to have to prosecute this because our the local DAs are not prosecuting, and a lot of those are of his cliques in my party.
Well, again, yes, sir. They have other priorities. They like to pursue criminal.
This is criminal as well.
Well,
is that not true?
Yes. I mean, let's don't go with other priorities because we're sitting here tonight and this is a major bill and we're talking about a major priority for the state of Texas. And TPPF has been very much behind. This is a major priority for the state of Texas. Is that not correct? That's absolutely true, Representative.
All right. Well, that's as far as I need to go with this. Thank you.
Yeah, thank you, sir.
Members, any further questions for Mr. DeVore? Okay. Thank you both for your patience today.
Thank you, members.
Testimony here. Next, the chair calls Chase Bearden with the Coalition of Texans with Disabilities and James Slattery with Texas Civil Rights Project. Chase, if you'll hang on one second. Jeff, we have some literature to hand out. Okay, Chase, we show you registered as Chase Bearden on behalf of the Coalition of Texans with Disabilities and yourself, and you are here registered neutral on the bill. Is that correct?
Chairman, that's correct.
Please proceed.
First, y'all look so awake. Thank you for having us, and I really do appreciate you making sure that invited testimony included the disability community, because this bill and voting really is affected. For many in the disability community, there's different issues that you run into when you're trying to just live your daily life. But when you're trying to vote, there are different access points. There's different times that you need different types of assistance. And even when you might have been able to vote one way in one election, your health could deteriorate and then bounce back up. So things vary and change for many of us in the disability community. But I want to start off with the reason we went neutral on this bill is it's our hope that we can work on with the chairman to get to a point where we can really improve some of the disability issues in here. We want to see maybe some amendments that might help actually improve access for the disability community, things that we've been working on for a long time. And when you start listening to this whole discussion around assistance, and we've bumped up to state jail felonies, and we're making people have to sign greater oaths, something that's gotten lost in all of this is that we should be going in a different direction. We should be working to make our system as accessible. That way, a person doesn't need as much assistance. Because to us, the most secure ballot is the ballot that you can cast on your own. Now, that being said, there will always be many in our community that do need hands-on assistance. But there's things we can do structurally that we aren't doing to make it better. And I'm going to start off with one issue area that is a big issue for us that's in this bill and something that we really do appreciate that's made it in. We've been working on this for a long time, and that is the cure process. For many in our community, signature verification is an issue. Many are using mail-in ballots. I have no use in my hands after I broke my neck. Many that were here earlier have significant cerebral palsy. As you age, your signature's not the same. We've all heard that. And one of the scary numbers to me is that in 2018, we had 3,746 ballots thrown out due to mismatch. Now, they didn't find out till 10 days after the election that their vote didn't count. And when we look at that, we've been talking about how many hundreds of fraud cases. In one election, our own system failed. 3,746 votes were thrown out. These are legal votes, nothing wrong with them. It's just that the signature did not look enough like the signature on file. I don't even know what mine looks like anymore. When I went to DPS to sign for my driver's license, the device was up high and they said, just put an X on it because I couldn't reach it. And I told them, no, disconnect it all and drag it down to me so I can try and hold on to the pen and sign it, so, like my signature. As people try and vote, they want to do it independently. They don't want to have an assistant. They don't want to have to make an X and then have a witness. And as we go through this process and we're looking at the cure, we do appreciate the cure that's in there, but there's things missing on this cure that we really do need. One of the first ones is we have no remote way to cure. The way it's written is that you would actually have to go into one of the poll places. The whole idea behind the mail-in ballot is the person can't get to the poll place. So if we're going to contact them, then they're going to have to find transportation. Or if it's too close, they're not going to have time to get there. There's a better way to do it. I know Representative Busey and Senator Hughes worked hard on putting in that tracking program that the Secretary of State's office is going to host. That's the place a person should be able to go. You're already having to log on with your credentials. You're having to put in your ID number, just like I did when I checked where my mail-in ballot was here in Travis County. There ought to be a way in there that when you get notified that your ballot made it back to the state and they looked at it and they felt like there was something missing or your signature wasn't right, you're already logged into a secure system. You ought to be able to check a box and say, yes, that was me. That is the fastest, easiest way to do it. There's probably other ways we can do it. Right now, remotely, you can cure your ballot in Florida and I believe in Ohio. We shouldn't be waiting to send it in the mail to someone and then wait for them to get it back when we're talking about mail-in ballots. It's just not going to happen quickly. And if the whole idea is to make sure we can count these legal votes, we need to improve that. On the other side of working through these, we want to make sure that people who are voting, and we talk about trying to ensure access and ensure the ability for someone to vote that private ballot. If you're visually impaired or blind and you get a mail-in ballot, you know what your only option is? Someone else filling it out. Do you know how they filled it out? You really don't. You know, if you have a really significant disability, like a good friend of mine, David Fowler, who used to run the Paralyzed Veterans of America, used a sip and puff device to blow into and move around, and it controlled his chair, it controlled his computer. You know, he had to get someone to do it. We have technology, and what we've been wanting and asking for, and what many other states are doing for people who are visually impaired and blind, is that the state will send them an ADA-compliant, accessible mail-in ballot. It's a simple system. We already use it basically for our military and overseas people. They get an email with the login credentials. They're able to go into a portal, pull down their specific ballot. They go through, they use the assistive technology on their computer, which is on every computer. And I'll remind you, many people in this state that are blind, the state helps pay to teach them how to use this adaptive software. But they receive that, they're able to go through, mark that ballot themselves, just like you would basically if you were at the polling place and you put the headphones on and you're listening to it and you're marking it and you're blind. When you got done, you hit print. It's not electronic voting. It's not sending it back over the internet. You hit print and you're printing off your ballot. The state sends you an envelope, just like you would, just not with the other ballot in there. You're able to fold it up, put it in there, send it back. That is how we secure people with disabilities ballots. We give them the independence to do it. And I know Representative Busey's worked with us on this for a long time. I had conversations, I guess a day ago, with Representative Leach, who he even mentioned he wanted to put in an amendment to see if that could happen. And that's a good bipartisan thing we can do to help improve the disability vote. If integrity and security is what we're getting at, let's do everything we can to make sure people can do that. Now, as I go down the list, there's a couple things that we really do want to say thank you for. Curbside voting, thank you for leaving it alone. In prior bills, there was a lot of changes and people looking at that. Curbside voting works, and it works for us. There's times when people need it and times when they don't. In the Senate bill right now, there's still things that really worry us about that, like making everyone get out of the car. And it gives no provision for a parent with a disability whose 2 kids are in the car that are 6 and having to get out in a parking lot. Or if you take your 92-year-old grandmother and 92-year-old grandfather, and one has to stand out in the sun while the other votes. At least in y'all's version, it leaves curbside voting alone. It works for us. And I believe that was even in the letter that the elections committees had sent to y'all, or the county elections officials sent, is that curbside voting works. Online voter registration, that was something that came up earlier. Representative Busey, you were talking about how it's in the DMV when you go to reapply, or if you're going from there. I think you're right. I think we need to make that easier for someone to reach, and also include people who wouldn't have a driver's license. So they'd still, if they have a state ID, they'd be able to go in there and do that. Because being able to do it online for the disability community really does help, and it really does work. And for us, getting more people voting is the best thing to do. Our organization, every day, we're the one minority you can join at any time. I learned that lesson at 17. It'll get a family member eventually. You're gonna know someone that's gonna need assistance. It's nice when these things are already in place, you don't have to worry about it. When I got injured, luckily, the other guys had already pushed so hard to get the ADA passed that I was able to use a ramp. July 26th, we hit 31 years, and we're still fighting for a lot of the accessibility we need. And there's things we want to do and sit down and work with to make sure we can get there. When you look at the voter assistance portions in here, we do have some issues around what assistance can be offered. What we always talk to people about and what we always teach them is for them to ask and tell a person what kind of assistance they need. We made it too prescriptive in here. I would suggest just leaving the way we do assistance alone, than the way the definition is already, and allow people to ask for the type of help they need. Actually, I have one part I need to go back that I'd forgotten. When it comes to the CURE program, and we're talking about doing the voter ID portion on the mail-in ballot, with all the signatures being thrown out, and now there's talk that you could either do the driver's license number or your last 4 of your digits. We definitely need to make sure that there's no wrong door, that if a person puts in one or the other, no matter what, it gets processed. The other thing is there are possibilities of a person putting in the wrong number. We need to make sure that that could be cured too. I know Chris earlier said that we might be able to do away with the CURE. Maybe I misunderstood that, because we wouldn't need the signatures as much based off of having that driver's license number. But any part of that could be a mistake, and you should be able to correct that and correct it quickly and remotely if need be. It's just taking the time to make sure people can do things right. even when the assistants, we talked about the mail-in ballots earlier and the person filling out the forms on the assistants. I don't know if you really, I know someone held up one of those envelopes, and have you ever read the 2 font that they put on there? I'm in my 40s and I can't read that thing. We're about to add, yeah, there you go, you got one up there. We're about to, okay, now look at all the things we are adding to what that person is going to have to fill out. The assistant on there. We have to fit on there somewhere, name, address, assistance giving. Did you receive money from a PAC or anyone else? We're gonna have to fit all of that on there. You're gonna need an 8.5 by 11 envelope for everything. And it really does get confusing when you're filling all this out. And what I've found a lot of times talking to some of our people is that they may get their mail-in ballot in the mail, and their attendant goes out, picks it up out of the mail form, opens it up, puts it on their table, and then someone else will come later to help them with something. And papers get moved around, and you can lose pieces of it. We want to make sure that if there is a simple mistake or someone misses something they didn't fill out that's assisting, it's not a state jail felony, not for the first time. There really should be that person wanting to cause intent to commit fraud, not a simple mistake. It happens, especially with mail-in ballots and many of our people. We really do strongly suggest making sure that no one ends up being punished because of a mistake. I know Representative Moody earlier was asking about a section in there that had brought up family members had an exemption for a family member if they didn't sign the assistant portion of it and they mailed it back, that was exempt, they wouldn't be punished. There's a little portion in there added at the very end, and Representative Moody wasn't sure about it. I think he said it was ambiguous, that it said attendant, caregiver in there. That came from when we were speaking with Representative Schofield. Originally, when those bills were being heard, my boss got up and talked about, the last thing we want is a simple mistake putting someone in jail that's just trying to help. And we wanted to make sure that attendants or someone that were helping them wouldn't have that problem. That's where that language came from. Now, it got in, but it was removed at the end when the last bill was filed at the end of the session. And we would like to make sure that stays in there. And we really would appreciate y'all fighting as hard as you can once this goes to a conference committee to make sure all the disability provisions that y'all have stay in. Because I can say that the provisions over here are much better than the other guys on the other side. And Chairman White, I appreciate earlier you talking about having to mark down what disability you had. That was a big issue for many of us. And we really appreciate that being removed, along with, in past bills, having to go to the doctor to get a signature, basically a prescription, and pay money every time you wanted to do a mail-in ballot if you had a disability. We appreciate those being removed. We want to work with y'all over the next few days to make the best bill we can, because we really do want to try and find ways we can improve disability voting in Texas. And I am willing to answer any questions y'all might have.
Okay, Chase, thank you, and I can assure you that is a two-way street. We want to work with you and the coalition and all Texans with disabilities to make sure as this bill moves through the process that we address some of the issues that you've raised here with us tonight. The chair recognizes Representative Busey.
Thank you, Mr. Chairman. Just want to touch on Section 501, which is dealing with the using ink on paper signature.
Yes.
There is the attempt was to make sure by adding Section 1.011, is that sufficient to getting where you need it to get?
On the ink on paper?
Yes.
Are you talking about the signature portion?
Mm-hmm.
One thing we would love to see, and that's something that has come up a lot, and I know Director Ingram and I have discussed a lot, is actually allowing people to use their signature stamp. It's not in the law that says you can, but it is the Secretary of State's position that you can't use a signature stamp. He may be able to finesse that and tell you a little more about it, but I know in the past, people with disabilities who have used a signature stamp to sign, it's actually a safer way for them than having a witness make a different mark, a different witness every time. The state will see the same signature on their application, even though it's the stamp, and then it'll come on their envelope. You know, that is the way the person signs their mark. And by saying, well, we'll just have someone else witness it, at the end of the day, that actually totally negates the whole idea of the signature verification committee. You know, you have a witness, it bypasses that. So it's not a benefit to that person to know. They know their signature stamp, and it's really a better way for allowing people. We also worry about, we wanted to make sure on those applications, you know, that a person could fill that out with a printer and not all have to be handwritten. Because many people can't handwrite all of that. They usually use a computer to fill out their forms, which I would suspect that most of the elections officials would much rather see a typed form than all my handwriting. But yes.
I appreciate it. Thank you. Thanks for your testimony.
Representative Moody.
Thank you, Mr. Chairman. Just wanted to weigh in real quick and clarify. When I spoke about an ambiguity in that provision, my intent and my desire was not to see it removed.
No, I know.
It was to say, the broader point is, let's be, when you're attaching a criminal provision to something, you get an attendant or a caregiver that you or I know fits this definition, but some overzealous prosecutor didn't like the results of an election, they can go after them. And so, no, and so what I wanted to just make clear is, at every iteration of this bill, and I'm not like Mr. Busey or Stephanie Click. I didn't serve as a party chair. This is not really my area of expertise, but every time that I was asked to be involved in these conversations, one of the main focuses about amendments or changes that I advocated for were for the disability community. And it's because, like I said earlier, why is our answer not to extend more assistance and more help to a population that I think every one of us would say deserves that courtesy.
Yeah.
And so you have my commitment on this day and every day going forward. If we're going to touch voting rights, that we're going to preserve rights for those who are living with disabilities, and we're going to try to expand them.
Yeah.
So thank you for being here and for your patience.
You know, and with your comments, in the past, we used to use a lot of the HAVA dollars to actually do trainings. And, you know, we would be able to get grants from the Secretary of State's office, and we would use those funds, multiple groups would, to reach out to disability communities and work with them to make sure they understood the voting process. And they knew what to, when they went to the polls, what to be asked and what was proper. You know, HAVA dollars have kind of disappeared. We do what we can, you know, to educate our people. But at the same time, you know, I think the state could be doing a better job, especially with all these changes coming. I mean, we got a lot of technical changes to make sure people are well educated ahead of time. And at the same time, you know, just continue that process, because let's face it, everything in here, it's confusing. And as much as we want to say that you should know the law, it's not that easy. I mean, I have a college degree, and I was reading through some of that, and I had to struggle. And it's hard then to assist others. We get calls all the time. Can I do this? Can I do that? And, you know, I think the more we invest in training everyone and making sure this is something that is easy to understand, the better our voting experiences across the board for all of us will be.
Thank you, Chase. Let me real quickly just, again, encourage you to continue to work with members of the committee. As you heard the bill author say, he's going to be working with several of them as this bill moves through the process. And as you heard Speaker Moody say, and certainly I want to share his comments, that we certainly want to do all we can to accommodate and encourage Texans with disabilities and preserve their right to vote.
Thank you.
So you have my commitment on that as well, as well as the entire committee, I'm sure.
Thank you.
Thank you for being here. James, we show you registered as James Slattery on behalf of the Texas Civil Rights Project, and you are registered against the bill. Is that correct?
That is.
Please proceed.
Thank you to the committee for the opportunity to testify today regarding HB 3. During my testimony, I will highlight 4 of the gravest threats that this bill poses to Texas voters. But as the committee considers these and other provisions in HB 3, it should bear in mind 2 important facts. First, during the March 4th, 2021 hearing of the House Elections Committee, the director of the Elections Division of the Texas Secretary of State reported to that committee the official position of the government of the state of Texas, that the most recent elections in Texas in 2020 were quote unquote a success, and that our elections were quote smooth and secure, unquote. Second, Texas is already the hardest state to vote in the entire country. That is not an opinion. That is an objective fact. According to a landmark study published in 2020 by Northern Illinois University, which measured the burdens on voters across the country when trying to register and cast a ballot via a cost of voting index, Texas ranked 50 out of 50 among U.S. states. Among other problems, we have no online voter registration, only a few discrete groups of Texans can vote by mail, and 750 polling places were closed between 2013 and 2019, predominantly in communities of color. Indeed, TCRP has documented the systemic barriers voters routinely faced in Texas in a number of reports in recent years, which are cited in my testimony in the footnotes. HB 3 does nearly nothing to make our elections more secure, but it will advance the big lie about the 2020 election and enshrine the big lie further into laws of what is already the most restrictive state in the country. Moving into specific portions of the bill, Sections 3.04 and 3.12 would prohibit counties from offering what is commonly known as drive-through voting. Drive-through voting was a wildly popular option at some polling places last year, adopted in part as a vital safety measure during the pandemic, which continues to rage to this very day. Relatedly, Sections 308 and 309 would sharply restrict the flexibility that counties currently have to set early voting hours that fit the unique needs of their communities. By providing for early voting beyond 10 p.m. on one or more days of the early voting period, counties can ensure that Texans such as shift workers, first responders, folks with irregular work schedules, and voters with substantial family responsibilities, among others, have an option to vote that works for them. Indeed, I cannot help but note the irony that this proceeding is occurring even now, past the 10 p.m. cutoff that this bill seeks to foreclose to voters. The hearing seems to be going just fine, so I don't know why people could not vote at this time either. We know that banning drive-through voting and extended hours voting would not harm all voters equally. In partnership with TargetSmart, TCRP conducted an analysis of the voters who used extended hours and drive-through voting. Attached to my written testimony are 3 charts showing by large and substantial margins that the voters who used extended hours and drive-through voting in Harris County were more likely to be people of color than early voters as a whole. As you can see at the end of the testimony in Chart 1, the demographic profile of the Harris County early voting population as a whole was 38% people of color and 62% white. But Chart 2 shows that the proportion of people of color using extended hours voting was 56% and only 44% white. And Chart 3 shows that the proportion of people of color who used drive-through voting was 53% and only 47% white. These results should not be surprising. People of color disproportionately have less flexible work schedules, and people of color have been disproportionately more likely to be infected with the coronavirus and die from it than white Texans, making a safe voting option that much more vital for them. TCRP and other organizations have repeatedly pointed out the disparate impact of both of these provisions when testifying on them during the recent regular session. If the legislature still chooses to enact these provisions after having received such data from multiple sources on a number of different occasions, the only reasonable conclusion is that these provisions in fact reflect a discriminatory intent by the legislature to eliminate forms of voting because they are used by voters of color. That this disparate impact is not merely an unfortunate side effect of HB 3, but is in fact the primary and intended purpose by the legislature of these provisions. One other thing that I noticed too, there were comments earlier about how the extended hours voting ban would promote uniformity and consistency. But that is obviously not true on the face of the provisions, because what the provisions do in conjunction with existing law is set a minimum number of hours and then set a longer period of time for those minimum hours to take place, which means that early voting hours will still continue to be different across counties, to the extent that election administrators, as we heard earlier, were hearing calls from people about being confused about hours changing between counties. They will still receive those calls under this provision. So setting uniform and consistent hours is clearly not the purpose of this law. One other thing that we, I think, have heard throughout on these provisions is that these were pandemic safety measures. The implication being that the pandemic is over and therefore those provisions are no longer necessary. But just before coming into this hearing room, I checked the New York Times' COVID tracker, and it reports that the current rolling average of national coronavirus cases is 18,272, which is a 52% increase from 2 weeks ago. And in fact, yesterday's number of daily cases was 35,201, which is the highest number of national daily coronavirus cases since May 14th. And in fact, you can still see the pandemic's effects in the audience behind me, where there are still seats being left open and people are wearing masks. So if we need pandemic-safe voting options, if we needed it in 2020, we clearly still need it in 2021. Moving to the partisan poll watcher provisions in Article 4. Partisan poll watchers are appointed by political campaigns to be their agents inside the polling place. That is not just me saying that. The election code is very explicit in section 33.001 that watchers are appointed, quote, on behalf of a candidate, a political party, or the proponents or opponents of a measure, unquote. They serve at the pleasure of the campaigns that have appointed them and represent the interests of those campaigns, not the public at large. Further, they are not required under Texas law to complete any kind of training or examination in election laws or procedures. Whatever training they do receive, the content and accuracy and content and quality can vary highly from one county to the next. They don't take an oath to observe Texas's election laws. These are not just theoretical dangers to voting posed by partisan watchers. as TCRP has documented in a report that I have both attached to this testimony and provided in hard copy to each member of this committee before beginning my testimony, partisan watchers have been deployed throughout American history, from Reconstruction to the present day, to harass, intimidate, and violently attack voters of color and voters of the opposing partisan affiliation. I list some examples in my written testimony going back quite some time in history, but I'll leave that to you all. But this is not ancient history. Common Cause Texas recently obtained video footage of a Harris County Republican Party presentation recruiting and training poll watchers for the 2020 general election. Throughout the video, the presenter uses dog whistles to target exclusively minority neighborhoods and rile up potential volunteers to form an aggressive poll-watching brigade. The presenter states that the predominantly white suburban areas of Harris County are quote-unquote safe. Therefore, quote-unquote courageous watchers from the suburbs need to venture into Harris County's predominantly black and brown urban core, highlighting particular areas on a map. Wheeler Baptist Church, a historic black church with storied ties to the civil rights movement, is singled out as a particularly problematic example, despite the fact that no evidence is cited or exists indicating that fraud has occurred at this polling place. These provisions would give partisan campaign volunteers a de facto license to run roughshod over election workers trying to conduct voting. Next, the ID Social Security matching provisions. It is easy to see the needless chaos and mass disenfranchisement that requiring this matching process will create. First, vote-by-mail applications and carrier envelopes are already complicated enough for voters to navigate, with a bewildering array of fields that they must fill out after reading instructions in small and dense type, as you've seen on the envelope you all were looking at earlier. Adding another required field makes it all too likely that voters will miss this field or another required field and have their vote needlessly taken away from them. Further, voters must handwrite those numbers on the form. The quality of people's handwriting varies wildly, as testified by the fact that I never did more than a C on handwriting classes, as does the ability to interpret other people's handwriting. If a voter's driver's license number ends in a 9, they should not lose their right to vote because an election worker mistakenly interprets it as a 4 and therefore concludes that the numbers don't match. In my own experience, I know that I would have been caught up in this because when I moved to Texas, I registered to vote right away before I had a Texas driver's license. So I would have used my Social Security number. Now, if I want to vote by mail and have a Texas driver's license, under this bill, I would use that number, which clearly would not match the Social Security number on my voter registration application. And so I would lose my right to vote by mail with no benefit to election security. One thing that was strange, I think people picked up on, is that when the sponsor was laying this provision out, he said, if I understood correctly, that this problem would not happen based on private verbal conversations with the Secretary of State's office. That is not a sufficient safeguard. The safeguard must be written into the text of the bill, or we must assume it does not exist. The last provision I will mention is the signature matching provision. This would be an improvement, but it doesn't go far enough to truly solve the problem. It allows voters to cure, for the most part, only in person, since most mail-in ballots are reviewed close to, on, or even after Election Day. All mail-in voters should be able to choose whether to cure their ballot by mail, phone, email, fax, or in person. A large subset of mail-in voters are simply not nearby. If you are an overseas voter voting from France, you cannot pop into your local county elections office to cure your ballot. If the committee wants to use HB3 to make Texas's elections more secure while making the ballot more accessible to voters, it could enact online voter registration, as 40 other states have done. OVR would make our voter rolls far more accurate by allowing for real-time updates from voters and avoiding mistakes that happen when people misinterpret handwriting. Texas could allow voters to register closer in time than 30 days before the election. It could make all Texas voters eligible to vote by mail, as 34 other states do. Could allow Texans to use a student or tribal ID as voter ID. It could codify Governor Abbott's COVID order extending early voting by a week. In our country, the government belongs to the people. Elections are the most important mechanism by which the government holds itself accountable and makes itself responsive to the people. It is the most basic duty of government to ensure that its citizens can vote in free and fair elections, and the most important component of that duty is to clear away any and all unnecessary obstacles to voting. Every Texas voter should be able to cast a ballot that is fairly and accurately counted, but HB3 would be a giant step backward. Thank you, and available.
Thank you, James. Representative Busey.
Thank you, Mr. Chairman. Mr. Slattery, in the Elections Committee, we were made aware and talked about this Harris County Republican training. But I'm not sure everyone here is, and you were telling us that you provided us information historical, but then you said not so recent. Can you make everyone aware of how recent we're talking about?
It was in 2020, the most recent election.
It was during the week that we were having, I believe, an Elections Committee on SB 7 or HB 6 or one of those. So this is happening right now as this conversation about poll watchers and needs for more safeguards going on. I know that your organization's been involved in litigation challenging the signature verification process. Do you have any concerns about the new signature verification process in this bill? I'm specifically thinking in Section 5, which I've been focusing on today, 5.08, 5.12.
Yeah, so signature verification is very dicey. Signature verification committees are not trained handwriting experts. They're essentially amateurs. And they're analyzing a thing, signatures, that are inherently fluid. People's signatures change over time, naturally, as they age, but also if they suffer an injury, or also, frankly, when people are signing documents, no one is thinking, I need to be sure that my signature is exactly the same as it's always been in the past. So this is not a truly scientific or accurate process to begin with. Also, signatures don't just change over time or because things happen to you physically, but signatures are different even based on the stylus that you use. Like, do you use a pen or do you use a stylus literally on an electronic pad, or do you use your finger? So signatures can vary very widely. And so we have been involved in challenging that process to ensure, currently under Texas law, you don't have a right to notice when the signature is challenged or an opportunity to cure.
Let me ask you one more question. As we've gone through the iterations of this bill throughout the regular session, you had come forward, your organization come forward talking about some of the prohibitions on the distribution of vote-by-mail applications. This is not written exactly the same in this bill. Have your concerns been addressed? If not so, where are we at in that process?
Yeah, not all of them. So one thing that is noticeable is a provision that provides that it would be prohibited for counties to distribute an application to vote by mail to a person who did not request the application. So one concern that we keep hearing that's allegedly motivating this is that if counties send out vote by mail applications, some voters who are not eligible to vote by mail will receive them. But there is at least one population that is knowable with certainty that is eligible to vote by mail, which is people who are 65 and up. This provision doesn't have even an exception to say, well, where the government knows with certainty that these voters are eligible to vote by mail, they still couldn't distribute the applications without a request from the voter first. One other provision that is still troubling here, two other, is the submission of an application to vote by mail. The counties could not solicit submission of an application to vote by mail. The word solicit is still very vague. For instance, even though there's a new exception to that for providing general information, it's common for counties to say, hey, you can apply to vote by mail by April 18th. Get your vote by mail ballot application today, ! It's encouraging people to exercise their civic rights, but it would also be soliciting a vote by mail application, and something as simple as that they couldn't do. And then finally, the prohibition on authorizing or approving the expenditure of public funds to facilitate a third party to distribute an application to vote by mail. This would affect potentially civic engagement groups that go to counties and say, hey, can we have vote by mail applications so we can help people vote by mail? Counties would appear to be prohibited from even providing them with the application forms because that would be a expenditure of some degree of public funds to give them vote by mail application forms.
So you think this might mess with a county partnering with like League of Women Voters?
Yes.
Okay, so we need to get clarity on that. All right, I appreciate it.
Sure.
Thank you. Thank you, Mr. Chairman.
Chair recognizes Representative Click.
You mentioned that you were concerned about the numbers matching up. Could that be cured by requiring both numbers and/or?
There might be some benefit to that, but a number of the other problems still remain in terms of reading handwriting, voters missing this on a complicated form.
But, as far as them entering the wrong number, that could prevent that aspect of your concern.
I am not sure it would prevent it in all circumstances, since it's not a provision in the bill. We haven't analyzed that yet.
Correct. Just thinking through as to what might address that concern and if there is in fact a problem, correcting that.
I think it's worth considering.
Okay, members, any further questions for this panel? Yes, Representative Niabi.
I don't have a question. I just want to make sure that the record reflects that you handed us a handout that says opening the floodgates for racial intimidation, disenfranchisement, and violence by expanding poll watcher authority. Quote, if we can disqualify enough blacks and enough Mexican Americans, ... end quote, by the Texas Civil Rights Project.
Yes, and that is a quote, I don't remember the precise thing that comes from, but that is a quote from a poll watcher program in the past.
Okay, thank you.
Thank you both for being here tonight.
Thank you.
Okay, next the chair calls Don Garner with the Texas Faith and Freedom Coalition, as well as Nina Perales with the Mexican American Legal Defense and Educational Fund.
Mr. Chairman, when you thank them, please thank them for being here this morning, no longer tonight. We moved to a new day.
Do either one of you have any literature you need? Okay, thank you. Don, we show you registered as Don Garner with the Texas Faith and Freedom Coalition, and you are registered being for the bill. Is that correct?
That is correct.
Please proceed.
Thank you, Chairman Ashby and members of the committee. I really am honored to be able to speak to you tonight, and want to say how much I have always appreciated just the rigors of what you all endure for the people of the state of Texas. Truly, I'm grateful for that. Faith and Freedom Coalition of Texas, our mission is to give people of faith a voice in government. And toward that end, I have the privilege of speaking in support of bills like House Bill 3. Faith and Freedom Coalition has a membership of over 2.5 million nationally and over 125,000 here in Texas. In the most recent election cycle, Faith and Freedom Coalition distributed voter guides through volunteer canvassers to 5.9 million voters across the country, over 300,000 of those here in Texas. In fact, about 310,000, and we intend to double that next year. We consider the integrity of our elections to be foundational to the freedoms we enjoy, and while the level of concern among those we represent has risen exponentially in recent months, this is an issue that always requires vigilance. Unforeseen challenges to our election system, like the pandemic, has been discussed, rapidly advancing technology, and the efforts of bad actors who are constantly seeking new ways to game the system, make it essential that we continually strive to adapt our election laws and practices. And that's why Faith and Freedom Coalition has given considerable attention to this in the past and hope to be part of the discussion for years to come. Having worked in recent election cycles in Texas on recruiting canvassers, poll watchers, and volunteer deputy registrars, I've been inspired by the passion that these folks have for the process itself. I've also seen how disheartened these same people become at discoveries of irregularities and at times outright cheating, like those that have been described in this hearing and hearings throughout this past regular session. I would contend, and really this is kind of a theme, a part of the theme of what I have to say, nothing suppresses voting more than the erosion of trust or confidence in the election process itself. I believe that is the purest form of voter suppression, is anything that would undermine people's confidence in the process. Now, it's disappointing to me, and I think it's really counterproductive, as so many will paint efforts at election reform as voter suppression. We see media headlines that consistently editorialize reforms as voter restriction. They attack practical common sense reforms as a solution looking for a problem. I feel like this undermines voter confidence in the election process and truly is damaging. Reforms over the past decade, like voter ID and the elimination of straight ticket voting, have also been demonized as voter suppression. Yet with their implementation, we have seen turnout increase, not decrease. Voter confidence in our election system will rise as specificity is brought to the process, and with it, voter participation, and that's what HB 3 is seeking to accomplish. In 2008, the Supreme Court of the United States stated, "Public confidence in the integrity of the electoral process has independent significance from the state's interest in preventing voter fraud, because it, that is public confidence, encourages citizen participation in the democratic process." And what that means to me is that it's a vital importance, and it's part of the responsibility of the state to ensure or to prevent fraud, to ensure integrity in the election process. But it's also part of the responsibility of the state that there's an appearance of integrity. That is not, the reality must be there, but the reality must be clear. It's got to be perceived by the public, I believe. Gross deviations from the election code undermine public confidence in the electoral process. 24-hour voting and drive-through voting were not concepts developed or contemplated by the Texas legislature. And it's the members of this legislature who have the responsibility to maintain the election laws in Texas such that every Texan believes in the integrity of the system we create. Texans must be able to trust that our elections are safe, secure, and fair. House Bill 3 is a big step in the right direction. To regain the trust of Texans, the gray areas in our voting process need to be clarified. That's really the bulk, in my view, of what HB 3 does, is simply clarifies things that are already there and therefore not really creating restrictions. These gray areas need to be clarified relative to voter registration, mail-in ballots, election security, enforcement. I believe that this bill, House Bill 3, offers common sense proposals in each of these key areas, and I encourage you to vote for its passage. And with that, I'll conclude, and I welcome any questions you may have.
Thank you, Don. Members, any questions? Okay, thank you. Nina, we show you registered as Nina Perales on behalf of the Mexican American Legal Defense and Educational Fund, and you're registered against the bill. Is that correct?
Yes, that is correct.
Please continue.
Good morning, Chairman Ashby and members of the committee. MALDEF opposes HB 3. My testimony today will focus on two aspects of HB 3 that have a particularly harmful effect on Latinos, but we oppose the bill in its entirety. Article 6 of the bill interferes with voter assistance and will have a disparate negative impact on Latino and Asian American voters. Assistors are relied upon by limited English proficient voters in order to cast their ballots. For example, 1 in 10 U.S.-born Latino adults does not speak English well. Slightly more than half of naturalized U.S. citizens who are Latino do not speak English well. Texas is home to close to 2 million naturalized U.S. citizens. These individuals, who meet the criteria for voter eligibility, are also eligible to receive language assistance when casting their ballots. Section 602 and 603 place unnecessary obstacles in the way of voter assistance in the polling place. Section 602 requires the assistor to complete a form stating the assistor's name and address and relationship of the assistor to the voter. And 603 requires the assistor to swear an oath under penalty of perjury, stating that the assistor secured a statement of eligibility from the voter for assistance, and also that the assistor limited the assistance provided to reading and marking the ballot. Assistors who are concerned about providing personal information to polling place officials, as well as those who are concerned about making an error in providing the assistance itself, will simply refuse to serve as assistors, and as a result, voters will not be able to obtain the assistance that they are legally entitled to. These provisions will also slow down the voting process and increase wait times at polling places in predominantly Latino neighborhoods. At polling places where there are more voters who need language assistance, the lines will slow down, voters will be forced to wait more time to vote, and some will leave before voting in order to meet work and family commitments. None of these assistance provisions are supported by any evidence that voters who need assistance because of limited English proficiency or disability are involved in fraud. This is one of the places where HB 3 is a complete mismatch to anything that the committee has heard about the need for election integrity. You have not heard, and you will not hear from a limited English proficient voter who says that somehow receiving assistance from the assister of their choice caused any type of voter fraud or any type of manipulation of the results. And so we would urge the committee to shed these provisions because they simply don't match up with any concerns about election integrity. There's another reason to omit these provisions from the final bill. They violate Section 208 of the Federal Voting Rights Act, which guarantee an assister of choice to voters who need help, either because of language or because of disability. Federal law does not require that the voter make a declaration of eligibility for assistance. And most importantly, a voter is entitled under federal law to greater scope of assistance than that provided in HB 3. So HB 3 requires the assistor to swear under penalty of perjury and face criminal prosecution for lying, swear that they confine their assistance to reading and marking the ballot. But federal law provides voters a much greater scope of assistance. Right? Sometimes reading and marking the ballot isn't the issue. A voter who is wheelchair bound or a voter who uses sign language to communicate may bring an assister with them and has every right under federal law to do that, to navigate the polling place, to interact with polling place officials, and to use the voting equipment. right? An assister cannot do that, even though it's a federal right, because they have to swear under penalty of perjury that they confined their assistance to reading and marking the ballot. And the same thing is true for the limited English proficient voter as well. The limited English proficient voter may want assistance to navigate the polling place, reading the signs, go here, get in line over there, checking in with the polling place officials, as well as using the equipment, right? These are things that the federal law says the limited English proficient voter has the right to do, and this is what HB3 criminalizes. All of those types of assistance, because the assister has to sign an oath saying that they confined their assistance to reading and marking the ballot. With respect to poll watchers, there's been an enormous amount of discussion. I would simply like to point out that, again, there is a mismatch between what people are saying the problem is and what the provisions are here. From what I have heard about people who have come to testify who served as poll watchers, was that they had an experience in which current law was not being followed. Right? Poll watchers exist. They are in the Texas Election Code, and they are entitled to find a place in the polling place where they can either sit or stand that is convenient for them to be able to watch the proceedings. I don't think anybody has criticized what current law provides. I haven't seen or heard an argument from anybody that polling place watchers have to roam freely and hover over voters in order to effectuate their mission. If anything, they're complaining about a lack of compliance sporadically with current law. And so I would simply say that allowing poll watchers to roam around the polling place and get close to voters is going to result in voter intimidation, because this is never going to occur on an even basis. And prohibiting election officers from removing poll watchers, right, until after they have already done something terrible and been warned and then done something terrible again makes no sense. That provision is irrational and is also not supported by any testimony, because what it means is that poll watchers can scream, yell, physically impede, frighten, or drive off voters and must still be allowed to remain in the polling place unless they have been previously warned. So you basically get two of these types of behaviors before you can be removed. Latino voters in Texas have borne the brunt of more than a century of voter intimidation by vigilantes as well as law enforcement. With the recent events of January 6th at the U.S. Capitol fresh in our mind, there's every reason to believe that removing security measures inside the polling place will result in more intimidation of Latino voters. Now is not the time for the Texas legislature to rescind laws that guarantee a safe and secure environment for voters inside the polling place, and to strip polling place officials of the authority to remove poll watchers who disrupt voting. MALDEF urges the committee to reject the bill. I thank you for your time, and I'm happy to answer any questions of the committee.
Thank you, Ms. Perales. First up, we'll have Representative Moody.
Thank you, Mr. Chairman. Earlier, Nina, how are you?
I'm very well, thank you.
Earlier I talked about whether and to what level any research had been done by anybody about individual sections or the cumulative nature of the impact of those sections taken together on voters of color. And the answers, at least that I received, were hadn't been done. Sounded like it seemed somewhat important to get it done, but hadn't been done. Do you think that it is important for this committee, for this body, to know and understand fully whether and to what extent any of these provisions, individually or cumulatively, would impact voters of color?
Yes, Representative. The context for voting in Texas is a long history of exclusion of minority voters from civic participation. We've even had testimony this evening claiming that voter turnout went up after voter ID was adopted, but perhaps the intentional omission of the fact that the voter ID law was struck down by a federal court as discriminatory and illegal. And it was only after that law was cured that it was ever put into effect in the elections in which voter turnout went up. We are steeped in a history and current context of discrimination against minority voters in Texas. And because of that, the legislature has to take special care, exercise special concern to make sure that they avoid disparate impact as well as intentional discrimination in the adoption of any voting changes.
That's what I want to drill down on, because you broke it up there, I think, in a perfect way. Intentional discrimination and disparate impact. Someone can sit there and say, I'm talking about the security and all the stuff of elections, and that's what I'm trying to get to, and that's the intent, and that's why I wrote it this way. And I can believe them, and they can believe themselves, and all that be fine. But that was the reason of the question. If we don't know the data behind it, my intent can be as pure as the driven snow, but in reality, it could have that disparate impact. In your experience, which I know is pretty extensive, is that kind of research done when we do changes like this to election law?
It ought to be done, and if it had been done prior to the enactment of the voter ID law, hopefully the legislature would have incorporated the reasonable impediment affidavit at the very beginning instead of having this long saga of litigation. Not the most recent declaration of discrimination by the state of Texas against minority voters, but perhaps a good example. So yes, it should be done. When it isn't done, it can often lead to very expensive and time-consuming litigation.
So it behooves us, what I'm hearing you say is, rather than figure that out in litigation, when it's going to get done, people are going to go do those studies to see if there's a disparate impact on black communities, brown communities. Why don't we just do it up front and know the truth of what we're doing? Because the intent of what someone puts on a page, I can only guess what's in someone's mind and their heart, but the data will bear out what the data will bear out, and we should be data driven. And so, do you see any reason for us not to have that information in front of us before we put this on the path to litigation?
I don't see any reason, and in fact, with respect to some of the things that we've talked about in my testimony, the assistor provisions, we already know that a disproportionately high number of limited English proficient voters use assistance. They are predominantly naturalized citizens, although some of our elders in the native-born Latino community also still struggle as a result of having attended segregated schools and other types of discrimination, still struggle with the language, especially with the complicated ballot language. Because we know that people of color are going to be particularly affected by the assistor provisions, and because we haven't heard any testimony that would support the need to impose these restrictions, it calls out for further study and justification. Otherwise, knowingly passing these provisions does itself provide circumstantial evidence of discriminatory intent.
So just the fact that we won't even delve into it is what you're saying. Is that's problematic?
Yes, it is.
What would you say to someone that said, well, we can't know that. No one could predict what the impact would be out in the real world of implementing one of these provisions or cumulatively all of these provisions. What would you respond to someone who said, we don't have the ability to do that?
I think we certainly do have the ability to do that, and you pointed out yourself that we will do it in litigation.
So it's not like it's an impossible task that's being asked. This is something that is routinely done every time that we get into litigation about these types of laws.
Yes, I agree, Representative.
Thank you so much.
Representative Niave.
Thank you, Mr. Chairman, and thank you, Ms. Perales. And I want to thank you and Malda for everything that y'all have done throughout the years to protect and advocate for the civil rights of Latinos. I know that there are so many landmark cases that y'all have litigated that have really opened the doors so that people like me have an opportunity to have a seat at the table. And so I thank you for that. When you talked about the the disparate negative impact on Latino and Asian American voters when it comes to the language. I think of my dad, who came to our country with a 6th grade education. He came with a dream. He came initially as an undocumented immigrant. He's a naturalized U.S. citizen now. He's proud to be an American, and really is the one who got me interested in politics at a very young age, and calls me every single time we have an election to make sure to let me know that he voted, and is very engaged. And his English is broken. But I think not just of him, but many other Latino families in our state, which is why we've been trying to raise the flag and talk all day about the impact on Latino voters. So I appreciate that you've highlighted that. Can you speak, and I just wanted to make sure, because you got into some of the federal laws that give Texans rights to assistance. Was there anything else that you hadn't mentioned? Any other rights to assistance that federal law gives to Texas voters?
Well, certainly the Americans with Disabilities Act. I mentioned Section 208 of the Federal Voting Rights Act of 1965. And then also there is the regular Section 2 of the Voting Rights Act of 1965, which the Supreme Court has recently weighed in on with respect to what are called vote denial claims, which are heavily implicated by HB 3.
Okay, and how are they heavily implicated?
Well, if you make it illegal for an assistor to help a limited English proficient voter, for example, to navigate the polling place, interact with poll workers, and have assistance in using the equipment, you are essentially denying that limited English proficient voter the ability to vote.
So are you telling us that House Bill 3 is interfering with the voter assistant rights granted by federal law?
Yes, I am. And I want to additionally point out that because of the Supremacy Clause of the U.S. Constitution, federal law is supreme here, which means that Texas cannot countermand a federal right.
And what are the legal implications of this legislation, House Bill 3, conflicting with the federal voter assistance law?
In my opinion, it renders the provisions in HB 3 invalid.
Can you tell us who can a voter choose to assist them when they're voting?
Under Section 208 of the Voting Rights Act, any voter who requires assistance to vote by reason of blindness, disability, or inability to read or write may be given assistance by a person of the voter's choice, other than the voter's employer or agent of that employer, or officer or agent of the voters' union.
Thank you. And I want to transition to the poll watching discussion. With respect to the poll watcher provisions from your analysis, can you tell us what is the practical effect of removing the requirement that poll watchers sit or stand in one place to observe the polling place activities?
The practical effect of allowing partisan poll watchers to roam freely in the polling place and get up close to voters to observe their activities will be voter intimidation.
And with respect to the partisan poll watcher provisions, what's the practical effect of preventing polling place officials from removing a disruptive watcher? I know there's language in there that says unless the watcher has been warned and committed a second offense.
Right.
So there is an incredible lopsidedness about HB3's approach, because on the one hand, the polling place official, who is the representative of the government and is responsible for conducting a safe and secure election, faces very heavy criminal penalties and prosecution for making a mistake in this context, right? The poll place official has to weigh whether the poll watcher is committing a crime that's already barred by the election code or is doing something else like screaming, yelling, impeding that doesn't violate the election code, in which case they have to give a second warning. They can't position themselves between the poll watcher and the voter in a way that the poll watcher will later claim, is a criminal obstruction of their vision. This is going to deter people from working as polling place officials, and it's also this sort of crazy lopsided Fellini film in which poll watchers get to do all kinds of disruptive behavior and suffer no consequences at all, and polling place officials may go to jail for something that they don't even realize is anything other than keeping order in the polling place.
Thank you. And with respect to those same provisions, can you tell us what is the practical effect of making it a crime for a polling place official to obstruct the view of a watcher?
I believe that far fewer people will agree to work as polling place officials if they fear that they will be prosecuted and jailed for maintaining order in the polling place. And this will cause a crisis of availability of polling place officials.
That could end up closing polling locations if we don't have enough, possibly.
I think that counties will be hard pressed to find enough people to work at their polls.
Okay. Thank you.
Thank you, members. Any other questions? Okay. Thank you both for your patience this morning, and thank you for being here. Finally, we have some resource witnesses from the Secretary of State's office. The chair calls Keith Ingram, Christina Atkins, and I'm also going and call up Jonathan White from the Office of the Attorney General, if he's here. And right behind this panel, we will begin the public testimony.
We can share the mic.
Thank you, everyone, for your patience. Okay, let's see here. Keith, well, I'm sorry, I'm going to start with Christina. Christina, Christina Atkins, we show you registered as Christina Atkins on behalf of the Texas Secretary of State, and you're neutral on the bill, is that correct?
Yes, that's correct.
Okay. Let's see here. I'm waiting on Keith to be pulled up. Okay, next we have Keith Ingram. Keith, you are registered as Keith Ingram on behalf of the Texas Secretary of State, Elections Division, and you're registered as neutral on the bill. Is that correct?
That is correct.
Okay. And then let's find Mr. White. There we are. Jonathan, we show you registered as Jonathan White with the Office of the Attorney General, and you're also registered neutral on the bill. Is that correct?
That is correct.
Okay. Members, do we have any questions for this resource panel? Representative Johnson.
Mr. White, you're with the Attorney General's office.
Yes, ma'am.
I've had the honor of being with the Harris County DA's office, and I've had a chance to work with your office around human trafficking issues and things of that sort. Would it be fair to say that counties have the authority to prosecute any kind of fraud or election issues?
They do, ma'am.
And do you have any statistical numbers on this supposed election fraud and cases that are out there?
In terms of what's prosecuted by the counties, no, ma'am.
Right. Okay. And you would agree with me that any prosecution is public record, and all you have to do is a Freedom of Information request, and you could get those numbers, right?
That's right, if you know which statutes to ask for and all of that.
And obviously, as the Attorney General, y'all would know that, correct?
We would know how to obtain records?
Right.
Yes, ma'am.
And you would know what statutes to look for?
We would. I think there are 110 or 115, somewhere in that ballpark of criminal offenses under the election code.
And right now, have you even made an attempt to find out if any counties have election fraud cases?
That's not something that I've done, no.
Okay. And also, you would agree with me, as a prosecutor, I can't go after child support cases, right?
Correct.
That's y'all's sole purview. And the biggest responsibility for the AG's office is to go after deadbeat dads and make sure that children and women have the funding that they need, right?
As a percentage of our personnel, that's correct.
Okay. And I've looked at your website, and I see that the Attorney General elected Ken Paxton is making a big deal about his human trafficking prosecutions, and he's making a big deal about, quote, election integrity. I also see some note in here that somehow the legislature gave the Attorney General, is it authority in 2017 to look at this, or what is the reference on your website to the legislature's actions in 2017 that led to the AG's election integrity? What is that about?
That may reference a legislative appropriation of a few positions that became available for election integrity work.
And so this is the page that y'all are highlighting that says election integrity, and it says 534 successful prosecuted election fraud offenses against 155 individuals by the Office of the Attorney General since 2005, right?
I'm familiar with that.
The numbers. It also says 510, the number of pending offenses against 43 defendants currently pending prosecution. And it says 386, the number of currently active election fraud investigations. When you say, so let's take in the first box, 534 and 155 individuals, are you suggesting that there were 534 counts of election fraud applying to 155 people?
Yes, individual offenses of the election code or an election law against that number of defendants. Yes, ma'am.
So potentially, I'm assuming, you tell me if I'm right, 155 people that accounted for 534 potential fraudulent ballots.
Yeah, potentially. Potentially, obviously, we don't know what all they're involved in, but from what we had evidence.
Okay. Don't hold me to this, but this is just me very quickly, since I heard from TPPF and got curious about this.
Yes, ma'am.
Looking at Ballotpedia and looking at the number of votes. Since 2006, I didn't even go back to 2005, there have been 80,677,814 cast ballots. So if I give you your 534 potential fraudulent ballots, that is 0.000662%.
I'll trust your math on that. Yeah, it's going to be a small number.
And you have a 0.002 chance of being struck by lightning.
I'll take your word for that too, ma'am.
And even if I give you your presumed best case scenario published that you have here of 1,430 potential false ballots, potential, because these are not even convicted. This is just what y'all are claiming on investigations. It's 0.001772%.
I follow.
It's significantly negligible, correct?
I understand it's a very small number.
Very small number.
Yes, ma'am.
And so if there's a question about integrity of election fraud or fake ballots, your numbers prove out the point that it is statistically almost whatever the times is, you got 2 or 3 times better chance of being struck by lightning than this being an issue for an individual in Texas, right?
I think assuming that those cases represent the entirety of fraud in Texas, that we've caught every single case and we've been able to bring every single case to a criminal conclusion, that would be correct.
And again, you have the ability to check and verify if you really thought this was a big issue, to go to the counties and see what investigations. And I also, I know you've answered that, I also want to clarify something that I brought up with TPPF. If people think there's a fraudulent bad DA, then the right thing to do is to call up the Texas Rangers or the FBI and start that check and balance of authority. And that is an existing current structure within Texas law. And that's the option, from whether it's an investigation, you can just Google Texas Rangers investigating DAs, and you can find lots of examples where people have done it, correct?
Well, what I would say to that, ma'am, is we always encourage relationships with district attorneys' offices, and we are more than willing to work with them or have them take cases and work with them. We are encouraging of cooperation from DAs, and I'm not here to disparage any DA's office.
I was not suggesting that you were suggesting.
Sure.
But
I just
what
wanted to
we've
make that
heard
clear.
was testimony earlier where a certain organization came in and said that maybe DAs weren't prosecuting because they were getting benefit from ballots, and that maybe we weren't getting real numbers. And you would agree with me that if anybody suspects that a DA is acting fraudulently or doing something that is against the law, that everybody knows you can call the Texas Rangers, investigate, because a crime is a crime in Texas, whether or not it's being committed by a DA of somebody's political favor or party or not, right?
I think you'd probably need a little bit more substance to your complaint to get the Rangers to look at something like that, but I see where you're going with that.
So you would need legitimate substance to the complaint, and the Rangers may get involved. And contrary to that, it's easy to blast stuff on social media and blogs. But if you called the Texas Rangers and you made a false report, that would be a problem, right?
It would. It would. I think that also I would point out that there's prosecutorial discretion, obviously. So I don't really see an ethical issue there when district attorneys do sometimes not look at election cases because of their difficulty or because the facts don't look that great. Honestly, if your metric for evaluating cases is all the murders and the violent crimes that are stacked up in your court, sometimes when you are inundated in that type of crime, election offenses don't really move the needle. And I understand that. So, and there is a reason that we exist. We're a very small unit. We try to work with DA's offices where we can. We are currently working with a number of DA's offices on ongoing cases in some capacity. And we appreciate those relationships. So I want to make it clear that I'm not here at all to disparage DA's offices, and we encourage and continue to grow those relationships. And we value those.
And so just to be clear, does your employment exist in this new election integrity office that is being funded by the state of Texas? Is that where you're from, or are you just from the AG's office?
When you say new office, what does that mean?
Well, we heard from TPPF that you guys have gotten new bodies. Went from half prosecutor to full prosecutor. And
Yeah.
are you that full prosecutor?
I think I'm the half prosecutor.
You're the half prosecutor. All right. Well, as the half prosecutor, would it be fair to say that you are being employed at the the AG's office?
That's fair.
As half a prosecutor for suspiciously 1,430 cases since 2005.
The cases were, right, the defendants resolved since, yes, ma'am.
I wish I'd had those kind of docket numbers as a prosecutor. So thank you.
It's a different animal.
Representative Clardy.
Thank you, Mr. Chairman, and Mr. White, thank you for being here and staying with us so late, 1 in the morning. A happy good morning to you. If I understood the thrust of Attorney Johnson's questions to you, what I'm hearing is like, you don't really have a job. You got nothing to do. You're sitting around twiddling your thumbs. There's no such thing as a case of voter integrity problems or any voter fraud. And you're like going through the trash piles in the back alley looking for a case to prosecute. Is that the way you view your job?
No, and I'm going to try not to be too clever with my answer.
Leave that to me. I've got plenty left.
When you throw terms like trash pile out there,
But no, let me ask a more serious question. You are, for the Office of the Attorney General of the state of Texas, you are the chief and responsible of voter integrity and election fraud cases, right?
That's right.
I've had the privilege of serving on the election committee this session, and I heard your testimony. I did not know you. We never met until, I think, the first time you appeared at our committee hearing, right?
Yes, sir.
Right. And I will tell you unabashedly, I was very impressed by your candor, your knowledge, your experience, your prosecutorial zeal. I think we're fortunate to have you in the position that you're in. But what I recall you saying at that very first hearing you testified is that, and you've been in the position you have now, or at least in the Office of Attorney General responsibility for election fraud or integrity issues. How long?
I've been doing election fraud cases as some portion of my casework since I started with the AG's office in public integrity, which was, I think, almost 14 years ago.
14 years ago. And what I recall about your testimony, I cannot give you the numbers, you probably can't, is that when it started, it was a relatively small number of cases that were reported from citizens or interested parties, whatever they may be, alleging that there was some impropriety with an election or some fraud by some person voting. Is that accurate or fair to say?
Smaller than it is today, yes.
And as I recall, you started off with single-digit numbers. And then in the next few years, it grew into 12 or 14 or 16 or 18 or 20. I mean, you tell me, what happened in your professional career in this division representing the state of Texas to make sure our elections are fair and free and honest and reliable? What has happened in your experience and the number of cases that are reported that deserve to be investigated and prosecuted to make sure our elections are right?
Well, I think the simplest way to say that is when I started 14 years ago, election fraud cases were a portion of my caseload as a public integrity prosecutor that travels around the state of Texas. In those cases, stepping in usually where a DA had a conflict because of a political case or political conflict, and we would step in his shoes. The election fraud cases we tried under our own authority, and it went from being a portion of one attorney's caseload to being, 100% and adding attorneys and it being 100% of their caseload. So that now I have 3 attorneys. We all work full-time on election fraud cases. We've got an investigation unit that's part of another division that has 8 investigators that investigate election fraud cases full-time. They've got 386 active investigations. And so if that answers your question, I think the point would be that, and the question that I think you're asking is that we are busy, we are at a capacity. I do think that the addition of personnel would probably increase whatever results that we're showing on paper linearly. Not geometrically, but linearly with the number of people that are at it. And that would hold true up into a certain point, and that's a question mark because I just don't know.
Okay. And of course, this is probably true in any prosecution, whether the amount of drugs that are seized at the border represent a fraction of those drugs that actually make it across the border, or the number of armed robberies that are actually prosecuted, investigated, or a fraction of those that actually are committed. Would you expect that same truism to apply to voter election fraud or to election impropriety?
I think so to some degree, sir. Yes.
And so what you do is you only investigate those cases that come to you from reliable sources. You don't take every case or commit your limited investigatory resources to every case. You have to pick and choose where you're going to apply your resources.
That's right.
All right. That's true for every, Representative Johnson has served as a district attorney. As a district attorney, you don't have unlimited resources. Maybe you do if you're a federal prosecutor, but as a state prosecutor, you got to make tough choices, right?
That's right.
And so where you do, you're going to direct your resources, your time, your attention, your investigators to cases that seem to have merit. Fair?
That's right.
But that does not mean the other cases that you choose not to delve into aren't meritorious. You just got to make hard choices.
That's correct.
This is, you're doing criminal justice triage when you're a prosecutor in the state of Texas.
That's true always.
Despite the resources the state has, we have limited resources.
Yes, sir.
So what I really want to understand from you is your concern for the enforcement of election laws, are you more concerned now with the cases you're seeing, the activities that are you're told about, whether investigated or not, or whether prosecuted or not, or whether convicted or not? Are things just the way they were 10 years ago, or do you have greater concern for the stability and the reliability of our elections now than you did then?
Candidly, when I first started looking at these cases, I didn't understand. I didn't understand what people were doing and why they were doing it. Why they were collecting ballots, mail ballots, why what voter assistance was about. I didn't understand what was going on. Now that I do, yeah, I would say I certainly have much greater concerns than I did in the beginning, for sure.
And these were opinions and things that you have developed over the last 10 years. This is not something that all of a sudden, after November of 2020, the presidential election, you came to these conclusions.
No, sir.
All right. Because hopefully I've made this point. I made it in the Elections Committee. I'm making it now. That we are not just talking about general elections every 4 years in the state of Texas that we're concerned about. Isn't that right?
That's absolutely correct. And most of the stuff that we see that's fraud exists in small elections, local elections, primary elections, special district, and political subdivision elections. That's where we see the majority of the fraud.
And I think it stands to reason that the smaller an election, the fewer people that choose to go vote, the easier it is to influence the outcome of those elections.
That's exactly right.
Fair to say. The bigger the election, the harder it is to move.
That's correct.
And this is just the law of big numbers. And so I really do want to, and I'm sorry, Mr. White, to push you on this issue. And I also want to say I thank you for the service you've given to the state. But, you know, there are other considerations than partisan politics when we formulate the election laws of the state of Texas. That every taxpayer should have the right and believe that when they have someone elected to some political subdivision that controls the power of eminent domain, or the power of adverse possession, or the power of raising taxes in an ad valorem tax basis, that those people making those decisions are there legally and rightfully before they can take those actions. Now, I'm not saying that national elections and those things aren't important. Please understand me. We all vote. We all care about that. But the context within which this debate seems to have devolved focuses on things that matter, but there are other things too. And so your office does coordinate. I think Representative Johnson said this. You do coordinate and you work with District Attorney's Office, and you've certainly given great deference and respect to those offices, right?
Yes, sir.
But sometimes they have limited resources, and there are cases that are more appropriate for the Attorney General's office, or some more appropriate for the District Attorney. But regardless, you know, I think our law enforcement community and our prosecutorial community really wants the same thing we all want. That is honest, fair, true elections.
I agree with that.
Okay. And so that you haven't looked at their statistics or they haven't looked at yours, I don't care. I really don't care. I just want to know you're out there doing the job. And so as we move forward, I just want people to give some thought to this, that sometimes this is more important with the city council race. This is more important for a county commissioner's race. This is more important for a school district race or a hospital board race. That it's not always about who occupies 1600 Pennsylvania Avenue. This is about Texas. People control your taxes, the things that you do, your daily lives in a way much more importantly and much more closely. And that's the task that you were given as the chief prosecutor for the state of Texas, the Office of Attorney General, across all elections. Isn't that right?
I think I'd agree with that.
All right. I just want to thank you again for everything you do. I need to talk to these two in a little bit, but I'm going to go ahead and pass the witness. Thank you, Mr. Chairman.
Okay, next up, we have Representative Busey, followed by Representative Jeton. And I would just remind members what time it is this morning, and we would like to get to public testimony sooner rather than later.
Are we doing everybody right now?
Yes, so everyone has been sworn in, and we're legit. So I know there were some questions earlier for the Secretary of State's office.
I do have some, but I'll just start right here. Just Section 9 of this bill deals with ineligible voters and related reforms. And a lot of what is in here is some of the stuff I've worked on, which is trying to help make sure that mistakes don't become crimes in the voting process. So we've looked at Crystal Mason's case, for example. I think anyone that would look at that case would realize there was not intent or knowledge in that case. And we're trying to figure out how we can have safeguards without criminalizing mistakes. And so I'm just trying to figure out, are we doing enough here we have a new case in this state, Mr. Rogers out of Harris County. And I'm just trying to figure out again, is this another instance where we're seeing multiple times in this state, people honestly make mistakes and then they're getting charged with crimes? You know, how does your office come around finding a case to go after? Is it because you receive a complaint, or is it?
Yes, sir. It all starts with a complaint. Once that complaint's received, it's evaluated. It's assigned for investigation, if appropriate, and investigated. And based on those facts, we make a decision on whether or not we have a violation of the law.
Sure.
And move forward.
So in Mr. Rogers' case, he voted in Harris County, is that correct?
It is, although I'm not able to speak about the facts of an ongoing prosecution, so I'm fairly limited in what I can talk about.
Okay. So he voted in Harris County. Let me talk about what I read in an article then. He voted in Harris County, I guess, twice now. He was not eligible because of being a felon to register to vote, but he registered to vote, was given his voter registration. So somewhere along the way, he was given voter registration. He voted twice and didn't hide it, which makes me believe he didn't know he couldn't be doing that since he registered to vote and then was granted that registration. I'm just wondering, where is the line in this bill, and what are we doing wrong if people are making what only appear on the surface to be honest mistakes, and then there's crime and they're being thrown in jail, and there's Crystal Mason is on the verge of going to jail for 5 years for an honest mistake. I understand you're saying you can't talk too much about this Rogers case. Is there anything else in that? Or can you take from these two cases and talk to me about Article 9 and what we need to do to make sure that honest mistakes are not turning into criminal action?
I appreciate the question. And while I'm aware of the Crystal Mason case, obviously our office had nothing to do with the case.
Sure.
That is a case that was actually tried in court. So we have facts that have been established in a court of law, which we don't have in this case. We've got some articles published in media. Obviously, well, I think I can say that.
And I think with that point, I guess, and I did bring him up, so I opened that conversation, and I appreciate that. But I guess what I'm really trying to get at is, how do we craft this legislation so accidents don't become crimes?
Sure. With that said, what I would suggest, looking over Article 9, is in the context of a convicted felon, particularly with regard to the Crystal Mason case, which we are familiar with because we have facts established. Why not fix the provisional ballot affidavit so that it clearly has the affirmation that the voter makes, where they could initial or check next to it where it says, I am not a convicted felon, or if convicted, have completed any parole or probation. And so that there could be no doubt that if they check that they read that and they understand what the law is because they've read it and they've initialed. That would be one suggestion that I would have of something additional that could be done besides the things that have been done in this bill.
I had a House Bill 3523 this session. I don't expect you to know off the top of your head. But it would, we talked about it a little bit earlier, it would require the Secretary of State's office to come up with a way to notify people when they've regained the franchise to vote after being felons. And we heard some testimony about why that can be a complicated process. How would these individuals know to check that box properly that, you know, they were felon once, they're no longer in jail, they think maybe they're out, then
right.
How will they know?
When they're released from their probation or their parole, they will get a release letter, and they'll know. And instead of checking in on a periodic basis with their parole or probation officer, that will be done. And
does that go far enough to explain their rights to vote being regained? Do you know? And if the answer is no, or we don't know, then maybe that's where we need to target this legislation.
And that's one thing that I think is really good about this bill, putting it in the judgment, because
sure.
it can be spotty on what the procedure is with a specific probation or parole office, whether they're notified at probation or parole about their voter rights, about their voting rights. Yeah. And so I don't know the answer to the question of do they receive that notice on the back end that you've now regained your right to vote. One thing that I thought is on this judgment form, you could put an expected date based on their sentence of when they could be expected to regain their right to vote. And, you know, even if some technicality happened that made that date different, if they're relying on an official judgment form that's in the record, that's been signed by the judge, that's going to give them protection under the law.
Okay. So in crafting this idea, and I agree, this bill does some good here of giving extra notification upon losing your right, but I want to make sure we're getting in and bringing back your right. And if y'all have any other ideas on this specific matter before we go on other things, I really think that's an important step. If we really are trying to increase voter access, we're really trying to help people not accidentally walk into a crime, which I think is happening in some cases for sure, then how can we all go about doing this?
Just to add one thing to that, unless someone in the room has a little bit more knowledge than I do in this area, to me, the time, the date on which they would regain their right to vote is pretty simple to calculate at the judgment when the sentence is imposed. If it's a 5-year sentence, if it's a 10-year sentence and they go to prison, they get paroled, the parole date is when their probation is finally completed. That is the date when they regain their, and that's the time of the sentence imposed. So whether it was 5 years or 10 or 20 or 25, that's the date.
So if it's 10 years and they get out early, they get out at 8 years, they still
are on
at
paper.
The 10-year mark is
10-year
when they
mark.
get.
Yes, sir.
Okay.
That's right.
So it's basically their original full sentence, whether they serve the whole time or not.
That's right. That's exactly right. Because the probation, the end of that probation period or parole period is where the right to vote is regained.
Is there some database of felons in Texas that have a list of when they are? And I'm just trying to think the best tool to make sure we're notifying people when they're coming on.
I don't believe that exists in a format that we can work with in that way.
Okay.
It does exist, and we've been working with Chair Click and TDCJ to try to come up with a process to check voter registrations when they occur to make sure that people aren't on that list. And we were trying to
can we use that to also put people back on?
I don't know, probably, but that's a wrinkle that we haven't been thinking about. What we're trying to do is make sure that people don't fall into a trap by registering to vote when they're on paper. So if they're on TDCJ's list and they register to vote, they're going to get a notice that says, it doesn't appear you're eligible to register. Are you sure? You know, so we're trying to do the same thing you're trying to do. We're just trying to make sure that they don't fall into the trap accidentally.
Yeah. Well, one of these days we're all going to agree to say that nobody ever loses their right to vote. But until that day, I would like to get to this step. So maybe we can work on this together. But I do think as we talk about the focus of this House and criminal justice reform being a priority of the Speaker and this body, I know Speaker Moody and I have talked about this issue as we've been working on this bill. This is a vital step in the process. And if we want to avoid more mistakes that then turn into crimes and take resources, this is something we need to figure out. And if it's complicated, you know, I think that's what we're here for. I do have a bunch of questions for the Secretary of State's office. I don't know if other members were going to do that as well. And I was going to go after them.
We've got a lot of people waiting to testify. Representative Busey, I certainly don't want to cut you off, but I'm sure they can also avail themselves to you, come to your office and answer those questions directly, but it's your decision.
All right. Can I just narrow it down to a couple?
You can narrow it down to a couple.
All right. Thank you, Mr. Chairman.
Thank you for that.
I've worked on a few sections today, really focused in Section 5, and we're dealing with the ID issue, and I have it here. I just need to get organized. Section 510, and I believe it's 505, and we talked about it many times, putting down your driver's license or your social security number, and the conflict and potentially, do you read this that if it's not the same number, the ballot would get thrown out or the application would get thrown out?
So there's two different things that are going on, right? So we've got the application for a ballot by mail.
In 505.
And it's got to have one of these numbers.
Yes.
If it doesn't have one of these numbers, then that application is going to get rejected. That's what the statute will say if this passes. The carrier envelope is different. The carrier envelope, if it's got a number that doesn't match the application or that's not in the voter record, then we're going to have an opportunity to cure. Because what we're going to do is, this says, the wording says that it's supposed to match what's on the voter registration application. That's not really good wording. It should say match a number in the voter registration file. And that's because the number might not have come from the voter when they registered to vote. We do work behind the scenes to make sure that we get as much matching criteria data as we can. So we sometimes have supplied a full 9 of social for a voter that they might not have put on their first application because we got it from the driver's license file. So it's better to reference the voter registration file instead of the voter registration application. But either way, that's the way we would interpret it. And if the number they provide on the carrier envelope matches anything in their voter registration file, then that's the end of the hunt. They're okay. If it doesn't, then there's still a cure period in this bill for them to supply the other number.
Let me ask a follow-up to that. You've got some new language. You say you would interpret it that way anyways. Can we get the language to just spell it out so it doesn't go back to interpretation to this committee and to Chairman Murr? And maybe we can get that put directly in. What is the security implication with respect to voting at night or casting a ballot from a car? Is there anything that is less secure about the voting process after 10 p.m.?
I don't know that it's a security issue. I mean, obviously, anytime people are voting from the car, there's a potential of ballot secrecy being compromised. And
well, I guess I don't even mean from a car. I did say that. Let's say just going in and voting at 10:01 p.m. versus 9:59 p.m. No change.
No.
Okay. You still would ask for an ID or other?
It would be the same check-in process.
Okay. So as far as a safe and secure way of doing this, doing 24-hour voting versus 12-hour voting, it's not less secure.
I don't think security is the issue with that. I think it's consistency across counties, and especially you can think of a county that's got a part of a school district and the county next door that's got another part of that school district. The voters in one county, if they've got an opportunity for 24-hour voting and the voters in the other county don't.
Don't we run into that right now, though? I mean, you and I both live in Williamson County, and I live in Austin, Williamson County versus Travis County, Austin. And I know on Sundays our voting hours are different, even though we're both voting for the same mayor, same city council spots.
I agree there's some discrepancy, but not that kind of an advantage. We hadn't seen anybody try 24-hour voting until the pandemic caused people to get creative last year.
Does anything ban that directly right now in the law?
In the law, it says at least 12 hours a day, at least 8 hours a day. So the at least implies that you can go longer than that. And that's what we advised counties last year when they were thinking about doing this.
Let me just ask one more question on this. If it's at least, that means that Loving County or Harris County could do 24 hours under the current law, right? So it is equitable. What we're doing is we're going to cap it, but we're not going to do the same minimum requirements. So we're moving to an area where it's not as equitable under current law, right?
Well, we have that discrepancy between what's required of big counties versus what's required of smaller counties now. That discrepancy is already built into the law. We're changing the threshold a little bit in this bill from 100 to 5,000.
I appreciate increasing minimums and changing the threshold of what counties automatically. I guess I'm just saying under the law right now, any county has the choice to do 24-hour, but now we're going to rein it in.
I agree
with this bill. Okay, so right now it would be consistent, all 254 counties, if they said, well, I don't want my neighbor to have more time to vote for mayor than me, then they're doing 24-hour, we'll do 24-hour under the current law, correct? They could do that.
It's a resource of intensive thing, so I don't think very many counties would opt for it.
I heard we just had extra money, so we can distribute some to you guys to help with that, right? I appreciate it, guys. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Busey. Representative Jeton.
Thank you, Chairman. I'll keep this brief. Representative Busey addressed some of the things I was concerned about, but Mr. Ingram, I'll start with you first. Dealing with the voter rolls, it does seem that we have some vulnerabilities, and that's evident with Mr. Rogers being ineligible to vote and still being able to vote. Is there anything in HB 3 right now that you feel addresses or would help improve that situation at all?
I don't think so, and I think we've got existing authority to do this project with TDCJ that we're contemplating.
Okay. What happens when there's not a definite match? Do you feel that with that implemented that you would primarily have definite matches that the Secretary of State's office would be able to address, or would that likely end up having to go to the counties?
All of the matches would be sent to the counties as a weak match, no matter how strong the match actually is, so that we don't inadvertently cancel anybody without notice.
Okay. And we had discussed during the regular session when we were, I think it was HB 6 at that time, but there was language, actually it may have been even a different bill, dealing with the Secretary of State's ability to train and then audit and then potentially fine the county or elected official. Would something like that help ensure that when it gets to the county that they are actually going through the process of verifying that the accuracy of the voter rolls?
I agree with that. There was a bill that passed that's going to require us to make sure that the counties are actually working their tasks, but that sort of thing would add another layer of accountability.
Okay. All right. I appreciate that. I'll speak with Chairman Murr about that with the bill. Real quick, Mr. White, there was some discussion that occurred during the Elections Committee at during the regular session dealing with cases that come to your office. And can you briefly discuss, just explain what happens when you get a complaint to your office?
Sure. And the majority of our complaints come through the Secretary of State, who's kind of a central gathering point for all complaints that are election related. And when a credible complaint comes to the Secretary of State that gives them reason to believe an offense was committed, they will refer those complaints to us, and we'll receive those in the Criminal Investigations Division, review them, determine whether investigation is necessary, investigate, and then based on the facts of that investigation, determine whether an offense was committed and a prosecution is warranted. And that's probably 90% of the complaints that we receive, although we do occasionally receive complaints directly from district attorneys, local law enforcement, and local elections administrators.
Thank you. I believe we had discussed, or it was brought up, I think I asked the question, regarding the demographics of most of the victims of the complaints that you're getting, especially when it comes to mail-in ballot fraud and voter assistance fraud. Is there a particular demographic that you feel that most of those victims end up falling into?
Yeah, I remember we talked about this earlier in the regular session, and the demographics that we typically see are elderly for mail ballot fraud, often low income, and often minority.
Right. And so, yeah, and I think it's very important that we make sure we protect every one of those votes, regardless of how little the number may appear with the complaints that we have right now. It seems like every one of those votes was worth protecting. Do you feel that the language within HB 3 would help protect those votes?
There are certainly a few provisions in here that I think stand out as being tools that could definitely be used to increase the pressure on mail ballot fraud and specifically the practice of vote harvesting, which is addressed head on in this bill, which is something that's not been done historically. We've kind of regulated vote harvesting without having an outright ban on paid vote harvesting, and that's essentially what this is. And so, yes, my answer would be yes to that question.
Thank you. And just add on top of that, is there additional language that you would like to see within HB 3 to make sure that we're protecting those voters?
Well, the only thing that I didn't see was a civil remedy component to the vote harvesting statute, which, in my mind, having remedies available to candidates who are victims of vote harvesting in their races is something that's more powerful than having a prosecution tool, because it gives them a remedy. And what I've been finding, especially over the last year or so, with the influx of complaints we've received and some of the fervor with which those complaints are coming in, is that we do not have adequate, not only resources, but we don't have adequate remedies in criminal law to address the issues and the problems in real time that are happening in elections, and the redresses between, candidates and so that's something that obviously it doesn't come into my world. It might take some pressure off and act as an additional deterrent to those types of activities if there's a penalty involved, where the cottage industry of vote harvesting is just sort of self-regulate.
Yeah. Thank you, Mr. White. Thank you, Chairman.
Yes, sir. Thank you.
Absolutely. Representative Niave.
Thank you. And I'm going to be super fast. I want to thank everybody who's out there waiting. So I'm just going to ask a few yes or no questions, and I'll start with the AG, then I'll come to Secretary of State super fast. To the AG's office, believe that we had full, free, and fair elections in Texas?
I think that my department is a little bit more on the side of the problems that we see in elections, but I don't have any quarrel with the Secretary of State's opinion and their representation to you, and they're really in the best position to answer that question.
So, but yes or no?
Well, that's a qualified one of those. I can't.
Qualified?
You could pick a no or a yes. It's going to be a qualified either one of them.
Okay, we'll leave folks to interpret that. Do you believe that the elections, does the Attorney General's office believe that the elections were secure, yes or no, in Texas?
Okay, I'm here to speak as a prosecutor in the Attorney General, so I can't speak on behalf of the AG. It's not a question I can properly answer.
So you're not here to testify on behalf of the Attorney General's office?
Not as the entire agency.
Then as the chief of the Voter Integrity Fraud Unit, did I give the right title for that? Do you believe that our elections in Texas were secure, yes or no?
I think that elections in Texas were in the main, aside from some issues that we see in every election, which we do see fraud in every election. But I'll agree with my colleague Keith Ingram that the counties did, all 254 counties did a magnificent job of pulling off this election, specifically in the conditions that we had it during COVID.
So with respect to them being secure, you said they were in the what? I'm sorry, I couldn't hear you. In the main? Is that what
in
you
the
said?
main.
In the main.
In the main. What does that mean?
For the most part, I think generally speaking,
for the most part,
with the exceptions that are the focus, the entire focus of my unit is on the things that go wrong in elections. So, with that said,
okay.
I will defer to my colleague Keith Ingram completely on that question.
Do you believe that public confidence has been undermined in the legitimacy of any public officers chosen by election in Texas? Yes or no?
Given the fact that we have seen races, and these are typically small races, not statewide races. Are you asking about statewide races or
any elected
level?
Official in Texas?
We have seen an election contest have reversed the results of elections due to that. So I can't say that every elected official at every level of government in the entire state has been elected fairly and without fraud.
Okay, and I'll just ask you, because we're limited on time, to provide us with any information to the committee where you're not agreeing with these. And do you have any concerns about the impact of House Bill 3, a disproportionate impact on Latinos and African Americans in Texas, yes or no?
I have not evaluated that.
Do you have any concerns about disproportionate impact of House Bill 3 on individuals with disabilities?
I have not evaluated that either, ma'am.
Or the impact of House Bill 3 disproportionately on senior citizens?
That either, ma'am.
Okay, thank you.
Thank you.
And I'll just ask y'all the same questions. Does the Secretary of State's office believe that we had full, free, and fair elections in Texas? Yes or no?
Yes.
Do you believe that our elections were secure in Texas?
Yes.
Do you believe that we have a
caveat that with they were more secure than they used to be. We have been working diligently since 2016 to increase the security level of our election. The counties have performed magnificently, and I believe we are more secure in 20 than we were in 16, but I believe in 22 and 24 we will be more secure yet.
Thank you. Do you believe that public confidence has been undermined in the legitimacy of public officers chosen by election in Texas?
I don't know what that means.
It's on page 1 of the bill.
I don't know what that means.
You don't know, Secretary of State's office, there's a legislative finding specifically in here. You don't, it's line 16, subparagraph 2. You read that?
I see it.
You just don't know what it means?
I agree that fraud in elections would definitely threaten the stability of confidence in the elections, yes. That's the reason why we need to root it out.
So do you believe that public confidence has been undermined because there's a concern, so there's a legislative finding in here the bill is requesting a legislative finding that, so can you tell me whether the Secretary of State's office believes that there has been any undermining of public confidence in the legitimacy of public officers chosen by election?
What this says is that fraud threatens the confidence. I completely
Right.
agree with that.
So, but do you think there is existing concern about any undermining of public confidence in our elections in Texas or any elected official being chosen?
I think there are polls on that, yes.
Say that again?
I think I've seen polls in that regard, yes, ma'am.
Okay. Do you, Secretary of State's office, have any concern about the disproportionate impact of House Bill 3 on Latinos or African Americans in Texas?
No, ma'am.
Okay. Does Secretary of State's office have any concerns about disproportionate impact on senior citizens because of this bill or individuals with disabilities?
No.
Okay, thank you.
Members, any further questions for our resource witnesses this morning? Okay, thank you all for being here and for your patience. That concludes our invited testimony. We'll now begin public testimony. As another reminder, each witness will have 3 minutes to testify. The timer, which is down here on the front dais closest to the witness table,